8:20, Monday, February 10th, 2025. Anderson? Barlow? Boner? Brennan? Case? Cooper? Crago? Crum? Dockstetter? Driscoll? French? Guru? Hicks? Hutchings? Ide? Jones? Cole? Landon? Larson? McEwen? Nethercott? Olson? Pappas? Excused. Pearson? Rothfuss? Salazar? Schuler? Scott? Smith? Steinmetz? McEwen? Excused. And President Beitman?
Here.
Mr. President, 29 present, 2 excused.
Thank you, Ellen. Today we are joined by Reverend Christian Basil from St. Mark's Episcopal Church. He will lead us in the prayer today.
Let us pray. O God, you are the source of truth. In you we place our trust. We thank you for giving us the work set before us, for labor that demands our best efforts, for the responsibility entrusted to those who govern, and for the privilege of leadership. We pray that you will provide wisdom and foresight to all those gathered today in this Senate, that they may serve with integrity, seeking good for all people, upholding justice and compassion, and that they may support the welfare of this state and country. We pray, Lord, that you will bless each member of this body, that their own needs may be met in you, that their own prayers and concerns will be held by you, and that both their burdens and joys may be surrounded by your grace and love. May each person here be guided not only by a sense of duty, but by the call to care for those whose lives are touched by their work. We pray especially for the family of Marilyn Moore on the passing of their son. May his soul be guided into your arms, and may their grief and sorrow be met with your unending comfort and peace. Above all, Lord, we pray for those whom we serve. May our actions reflect their hopes, and our service their dignity. All this we ask in your holy name. Amen.
Thank you, Reverend. Senator Nethercott, will you lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Reading correction and approval of journal. Will the reading clerk please read the journal committee report?
Mr. President, your journal committee reports that the journal of February 7, 2025 has been read and recommends that it be approved. Senator Crum, Chairman.
Are there any objections? There being none, the report is adopted. We have a new student page today. Ladies and gentlemen of the Senate, please welcome Lucas Legler. He is a senior from Powell High School. We have a Panther in the house. Senator Larson, he says he's your neighbor. So he's here to keep an eye on you, sir. Lucas, I have a pin for you. Make it official here. No secret handshakes yet, but that one, and put that on, and we're ready to rock and roll. Welcome to the Senate, Lucas. All right. Today in Cheyenne history, in 1868, the first public school in Cheyenne was established with 100 students. Quote for the day, "Don't count the days, make the days count," Muhammad Ali. Dad joke of the day, What do you call a sheep who can sing and dance? Lady Baba. Lady Baba. They're getting better, folks. Yeah, reminder, if you traveled home over the weekend, please remember to go sign the mileage book in the office. And today is the last day for Committee of the Whole in House of Origin. This session is flying by. Speaking of which, it's that time already for interim topics. The form to submit interim topics went live this morning on the legislature's website. There's a memo in each of your mailboxes outlining the process. Suggested topics may originate from any source, but the topic must be submitted and presented to joint committees by a legislator. The deadline is Friday, February 21st at 5 p.m. It'll be here before you know it, so just keep that on your radar. And we'll be bugging you and reminding you every day until then. So that takes care of that. Do we have any privileges of the floor, Mr. Vice President?
Thank you, Mr. President. Honorable Senators, in our gallery today, we have students from across Wyoming. They attended the CTE breakfast this morning and witnessed Governor Gordon signing a proclamation declaring February as Career and Technical Education Month. These are high school and college students in technical education classes who also participate in one of Wyoming's 5 recognized career and technical student organizations. A career and technical student organization, a CTSO, is a group that provides students with opportunity to develop vocational skills, leadership abilities, and professional knowledge. These organizations are affiliated with our schools and focus on special career technical education fields such as agriculture, business, health sciences, engineering, welding, automotive and diesel technology, construction, and hospitality, to name a few. CTSO members often participate in competitions, community service projects, and leadership activities, which help them gain hands-on experience, build their resumes, and prepare for future careers in the trades. Please stand when you are announced. First of all, we have the FBLA. We have members of the state officer team, accompanied by their state director, Andrew Borgelli. We have the FCCLA state president is here with us. Please stand and be recognized if you're here. The FFA state officer team is here with state director Stacy Broda. And finally, the Skills USA state officer team is here with their state director, Jenny Wilcox, if you could be recognized. If there are any other student members, advisors, staff, or alumni in the gallery representing FBLA, FCCLA, FFA, or the Skills USA, or possibly DECA, can you please stand as well? And then finally, I'd like Declan Hutchison from Riverton High School to wave. He actually reached out to me telling me that these groups were going to be here today. So Senators, if you could give a warm Senate welcome to all these students, we'd appreciate it. Thank you, Mr. President.
Thank you, Mr. Vice President, and welcome to the Senate, everybody. It's good to have you here. All right, messages from the House. Oh, wait, we have Senator Ide.
Thank you, Mr. President. Up here in the gallery to the left of myself I would like to introduce a family that is very special to me, the Davis family. Dan and Christy Davis, along with their daughters, Abby and Sophie, are some of Casper's finest patriots. We have been close friends for many years, so it is my honor. It is my honor to have them here today. Would you please give a warm Senate welcome to the Davis family?
All right. Welcome to the Senate, Davis family. Anybody else? Senator Case.
Mr. President, thank you very much. I sure like the Monday start time.
I can get used to this.
Yeah, I could get used to this, but thank you very much, sir. Privilege of the floor.
Granted.
Sir, in our gallery, we have our friends and neighbors that are working very hard to make better opportunities for people that are hardworking poor people in Wyoming. And so in the gallery, we have the members of Healthy Wyoming. They're here. It's a broad coalition of local, statewide, and national organizations dedicated to helping Wyoming citizens live healthier lives. Would you join me in helping to welcome them to Cheyenne? Hope you get a chance to talk to them. They've got some ideas about some solutions to make people's lives better. Thank you very much. Healthy Wyoming. Welcome.
Pitchers and catchers.
That'll be tomorrow. Everybody stay tuned because tomorrow, the Tampa Bay Rays
All
are
right.
reporting, pitchers and catchers, and LA's trying to get a jump on everybody. So the Angels and the Dodgers both have pitchers and catchers reporting tomorrow morning.
All right. We're
It's
there.
here, everybody.
All right.
Smell the mitt. It's happening. All right.
Thank you,
Did
sir.
you bring your mitt down, sir?
No, I didn't go home, but we'll still play catch out on
Okay.
Okay.
It's a deal.
All right. Senator Landon,
Mr. President, may I have privilege of the floor?
the floor is yours. sir.
Thank you, Mr. President. Indulge me for just a moment, if you will. I just wanted to recognize a moment in time a few years ago when my son Nick went off to a national competition in Skills USA, and he won a national championship. And the reason I'm looking up there at all of our students is that he now is a partner upcoming in an engineering firm down along the Front Range in the state south of us. And so it means a lot. So I just wanted you all to know that. And Mr. President, I just want to recognize a longtime friend of mine who is up there with our FFA students. Heath Horniker's up there. Has been an instructor in the Ag Department at Casper College for many, many years and has done so much for so many of our young people. I hope you would welcome Heath Horniker to the State Senate today. Thank you.
Thank you. Welcome. All right. Anybody else? Oh, yes, sir.
I am so sorry. And there's another good friend of ours, and that's Rob Hill right up there. I want to recognize
You
him
don't want to
too.
leave him out.
It's really great to see Rob.
Welcome.
Thank you.
Okay. Messages from the House.
From the House of Representatives, February 7, 2025, message number 213. Mr. President, House Bill 1, General Government Appropriations 2, passed the House on third reading in an amended form. Ayes 43, noes 14, excused 5. Sincerely, Katie Talbot, House Chief Clerk.
Thank you, Randy. House bills on first reading and introduction. Ooh, this one's, it's like, got some heavy weight to it here. House Bill 1, first reading of the bill. Oops, I'll take that. There we go.
House Bill 1, General Government Appropriations 2, sponsored by the Appropriations Committee. Passed the House, ayes 43, noes 14, excused 5.
Thank you. Pursuant to Joint Rule 14-1E, House Bill 1 is referred to Committee Number 2, Appropriations. All right. Oh, boy. Committees need something to do. We can't be showing up at noon every day. House Bill 54, first reading of the House Bill.
House Bill 54, Chancery Court Judges, District and Circuit Court Assistants, sponsored by the Judiciary Committee. Passed the House, ayes 58, noes 1, excused 3.
House Bill 54 is assigned to Committee Number 1, Judiciary. House Bill 62, first reading of the House Bill.
House Bill 62, Prostitution Amendment, sponsored by Representative Heiner, passed the House, ayes 60, excused 2.
House Bill 62 is referred to Committee Number 1, Judiciary. House Bill 133, first reading of the House Bill.
House Bill 133 engrossed, Sanctuary Cities, Counties, and State Prohibition, sponsored by Representative Guggenmoos, passed the House, ayes 51, noes 6, excused 5.
House Bill 133 is referred to Committee Number 1, Judiciary. House Bill 172, first reading of the House Bill.
House Bill 172, Repeal Gun-Free Zones and Preemption Amendments, sponsored by Representative Harrelson, passed the House, ayes 50, noes 10, excused 2.
House Bill 172 is referred to Committee Number 1, Judiciary. House Bill 189, first reading of the House Bill.
House Bill 189, Harmful Communications Minors, sponsored by Representative Lean, passed the House, ayes 59, noes 1, excused 2.
House Bill 189 is referred to Committee Number 1, Judiciary. House Bill 207, first reading of the House Bill.
House Bill 207, Religious Freedom Restoration Act, sponsored by Representative Washut, passed the House, ayes 57, noes 3, excused 2.
House Bill 207 is referred to Committee Number 1, Judiciary. House Bill 273, first reading of the House Bill.
House Bill 273, Wyoming Pregnancy Centers, Autonomy and Rights, sponsored by Representative Rodriguez-Williams, passed the House, ayes 46, noes 14, excused 2.
House Bill 273 is referred to Committee Number 1, Judiciary. House Bill 86, first reading of the House Bill.
House Bill 86 engrossed, Public Property and Buildings Amendments, sponsored by the Appropriations Committee, passed the House, ayes 57, excused 5.
House Bill 86 is assigned to Committee Number 2, Appropriations. House Bill 97, first reading of the House Bill.
House Bill 97 engrossed, Property Conveyances near Critical Infrastructure, sponsored by the Appropriations Committee, ayes 60, excused 2.
House Bill 97 is assigned to Committee Number 2, Appropriations. House Bill 166, first reading of the House Bill.
House Bill 166, State Auditor Payment Transparency, sponsored by Representative Bratton, passed the House, ayes 60, excused 2.
House Bill 166 is assigned to Committee Number 2, Appropriations. House Joint Resolution 1, first reading of the joint resolution.
House Joint Resolution 1, amending Wyoming's Act of Admission for Earnings, sponsored by the Capital Finance Committee, passed the House, ayes 61, excused 1.
House Joint Resolution 1 is assigned to Committee Number 2, Appropriations. House Bill 11, first reading of the House Bill.
House Bill 11 engrossed, Manufacturing Sales and Use Tax Exemption Amendments, sponsored by the Minerals Committee, passed the House, ayes 55, noes 5, excused 2.
House Bill 11 is assigned to Committee Number 3, Revenue. House Bill 38, first reading of the House Bill.
House Bill 38, Ad valorem taxation, payment and credit of penalties, sponsored by the Revenue Committee, passed the House, ayes 60, no 1, excused 1.
House Bill 38 is assigned to Committee Number 3, Revenue. House Bill 39, first reading of the House Bill.
House Bill 39, Property Tax Refund Program Revision, sponsored by the Revenue Committee, passed the House, ayes 59, noes 2, excused 1.
House Bill 39 is assigned to Committee Number 3, Revenue. House Bill 40, first reading of the House Bill.
House Bill 40, Sales and Use Tax Revision, sponsored by the Revenue Committee, ayes 61, excused 1.
House Bill 40 is assigned to Committee Number 3, Revenue. House Bill 75, first reading of the House Bill.
House Bill 75, Coal Severance Tax Rate, sponsored by Representative Closton, passed the House, ayes 57, noes 4, excused 1.
House Bill 75 is assigned to Committee Number 3, Revenue. House Bill 123, first reading of the House Bill.
House Bill 123 engrossed, Adverse Possession Property Tax Payment Defense, sponsored by Representative Nyman, passed the House, ayes 40, noes 21, excused 1.
House Bill 123 is assigned to Committee Number 3, Revenue. House Bill 17, first reading of the House Bill.
House Bill 17, Career Technical Education Equipment Grants Amendments, sponsored by the Education Committee. Passed the House, ayes 59, excused 3.
House Bill 17 is assigned to Committee Number 4, Education. House Bill 18, first reading of the House Bill.
House Bill 18, Career Technical Education Funding, sponsored by the Education Committee. Passed the House, ayes 60, excused 2.
House Bill 18 is assigned to Committee Number 4, Education. House Bill 20, first reading of the House Bill.
House Bill 20, K-12 School Facility Leasing, sponsored by the School Facilities Committee. Ayes 38, noes 23, excused 1.
House Bill 20 is assigned to Committee Number 4, Education. House Bill 46, first reading of the House Bill.
House Bill 46, Homeschool Freedom Act, sponsored by Representative Strzok. Passed the House, ayes 54, noes 6, excused 2.
House Bill 46 is assigned to Committee Number 4, Education. House Bill 60, first reading of the House Bill.
House Bill 60, engrossed, Student Eligibility in Sports Amendments, sponsored by Representative Lawley. Passed the House, ayes 51, and noes 6, excused 5.
House Bill 60 is assigned to Committee Number 4, Education. House Bill 94, first reading of the House Bill.
House Bill 94, Charter School Authorizations Amendments, sponsored by Representative Andrew. Passed the House, ayes 45, noes 16, excused 1.
House Bill 94 is assigned to Committee Number 4, Education. House Bill 199, first reading of the House Bill.
House Bill 199, engrossed, Wyoming Freedom Scholarship Act, sponsored by Representative Andrew. Passed the House. No vote recorded.
Okay. House Bill 199 is assigned to Committee Number 4, Education. House Bill 316, first reading of the House Bill.
House Bill 316, engrossed, School Finance Model Recalibration 2, sponsored by the Management Council. Passed the House, ayes 60, excused 2.
House Bill 316 is assigned to Committee Number 4, Education. House Bill 61, first reading of the House Bill.
House Bill 61, engrossed, State Land Lease Preference Amendments, sponsored by Representative Banks. Passed the House, ayes 60, excused 2.
House Bill 61 is assigned to Committee Number 5, Agriculture. House Bill 92, first reading of the House Bill.
House Bill 92, Wyoming Livestock Board Memorandums of Understanding, sponsored by the Agriculture Committee. Passed the House, ayes 61, excused 1.
House Bill 92 is assigned to Committee Number 5, Agriculture. House Bill 93, first reading of the House Bill.
House Bill 93, Protect Wyoming's Lands Act, sponsored by the Agriculture Committee. Passed the House, ayes 57, noes 4, excused 1.
House Bill 93 is assigned to Committee Number 5, Agriculture. House Bill 168, first reading of the House Bill.
House Bill 168, engrossed, Cultivated Meat Prohibition, sponsored by Representative Eklund. Passed the House, ayes 42, noes 17, excused 3.
House Bill 168 is assigned to Committee Number 5, Agriculture. House Bill 221, first reading of the House Bill.
House Bill 221, engrossed, Bighorn and Domestic Sheep Relocation, Effective Date Repeal, sponsored by Representative Ottman. Passed the House, ayes 55, noes 2, excused 5.
House Bill 221 is assigned to Committee Number 5, Agriculture. House Joint Resolution 2, first reading of the joint resolution.
House Joint Resolution 2, engrossed, Foreign Adversaries Prohibited Property Ownership, sponsored by the Agriculture Committee. Passed the House, ayes 58, noes 3, excused 1.
House Joint Resolution 2 is assigned to Committee Number 5, Agriculture. House Bill 45, first reading of the House Bill.
House Bill 45, Removing Otters as Protected Animals, sponsored by Representative Byron. Passed the House, ayes 52, noes 8, excused 2.
House Bill 45 is assigned to Committee Number 6, Travel. House Bill 47, first reading of the House Bill.
House Bill 47, engrossed, Secretary of State Expedited Filing, sponsored by the Blockchain Committee. Passed the House, ayes 60, excused 2.
House Bill 47 is assigned to Committee Number 7, Corporations. House Bill 69, first reading of the House Bill.
House Bill 69, Foreign Adversary Ownership or Control of Business Entities, sponsored by the Corporations Committee. Passed the House, ayes 61, excused 1.
House Bill 69 is assigned to Committee Number 7, Corporations. House Bill 131, first reading of the House Bill.
House Bill 131 engrossed. Ballot drop boxes prohibition, sponsored by Representative Knapp. Passed the House, ayes 51, noes 10, excused 1.
House Bill 131 is assigned to Committee Number 7, Corporations. House Bill 154, first reading of the House Bill.
House Bill 154, House Holding Amendments, sponsored by Representative Brady. Passed the House, ayes 60, excused 2.
House Bill 154 is assigned to Committee Number 7, Corporations. House Bill 156, first reading of the House Bill.
House Bill 156, Proof of Voter Residency Registration Qualifications, sponsored by Representative Baer. Passed the House, ayes 51, noes 8, excused 3.
House Bill 156 is assigned to Committee Number 7, Corporations. House Bill 238, first reading of the House Bill.
House Bill 238 engrossed. Ballot Harvesting Prohibition, sponsored by Representative Johnson. Passed the House, ayes 52, noes 8, excused 2.
House Bill 238 is assigned to Committee Number 7, Corporations. House Bill 23, first reading of the House Bill.
House Bill 23 engrossed. Surrender driver's license repeal, sponsored by the Transportation Committee. Passed the House, ayes 60, excused 2.
House Bill 23 is assigned to Committee Number 8, Transportation. House Bill 25, first reading of the House Bill.
House Bill 25 engrossed. Vehicle Accident Reporting Amendments, sponsored by the Transportation Committee. Passed the House, ayes 53, noes 8, excused 1.
House Bill 25 is assigned to Committee Number 8, Transportation. House Bill 27, first reading of the bill.
House Bill 27 engrossed. Disable Parking Windshield Placards Revisions, sponsored by the Transportation Committee. Ayes 60, excused 2.
House Bill 27 is assigned to Committee Number 8, Transportation. House Bill 28, first reading of the bill.
House Bill 28, Commercial Driver's Licenses Revisions, sponsored by the Transportation Committee. Passed the House, ayes 60, noes 1, excused 1.
House Bill 28 is assigned to Committee Number 8, Transportation. House Bill 30, first reading of the bill.
House Bill 30 engrossed. Driver's Licenses and IDs Revisions, sponsored by the Transportation Committee. Passed the House, ayes 61, excused 1.
House Bill 30 is assigned to Committee Number 8, Transportation. House Bill 33, first reading of the bill.
House Bill 33, Vehicle Sales and Use Tax Distribution Highway Fund, sponsored by the Transportation Committee. Passed the House, ayes 48, noes 13, excused 1.
House Bill 33 is assigned to Committee Number 8, Transportation. House Bill 14, first reading of the bill.
House Bill 14, Solid Waste Municipal Cease and Transfer Funding, sponsored by the Minerals Committee. Passed the House, ayes 59, excused 3.
House Bill 14 is assigned to Committee Number 9, Minerals. House Bill 22, first reading of the bill.
House Bill 22, Water and Wastewater Operator Emergency Response, sponsored by Representative Campbell. Passed the House. No vote recorded.
Okay. House Bill 22 is assigned to Committee Number 9, Minerals. House Bill 41, first reading of the bill.
House Bill 41 engrossed. Environmental Quality Irrevocable Letters of Credit, sponsored by Representative Lawley. Passed the House, ayes 61, excused 1.
House Bill 41 is assigned to Committee Number 9, Minerals. House Bill 42, first reading of the bill.
House Bill 42 engrossed. Regulation of Surgical Abortion, sponsored by Representative Lawley. Passed the House, ayes 52, noes 8, excused 2.
House Bill 42 is assigned to Committee Number 10, Labor Health. House Bill 64, first reading of the bill.
House Bill 64 engrossed. Chemical Abortions Ultrasound Requirement, sponsored by Representative Nyman. Passed the House, ayes 48, noes 13, excused 1.
House Bill 64 is assigned to Committee Number 10, Labor. House Bill 82, first reading of the bill.
House Bill 82, Provider Enrollment Standards, sponsored by the Labor Committee. Passed the House, ayes 55, noes 4, excused 3.
House Bill 82 is assigned to Committee Number 10, Labor. House Bill 96, first reading of the bill.
House Bill 96 engrossed, prohibiting masks, vaccine, and testing discrimination, sponsored by Representative McCann. Passed the House, ayes 45, noes 16, excused 1.
House Bill 96 is assigned to Committee Number 10, Labor. House Bill 121, first reading of the bill.
House Bill 121 engrossed, hospital pricing transparency, sponsored by Representative Singh. Passed the House, ayes 58, noes 3, excused 1.
House Bill 121 is assigned to Committee Number 10, Labor, and House Bill 164, first reading of the bill.
House Bill 164 engrossed, medical prescriptions off-label purchases, sponsored by Representative Brown. Passed the House, ayes 42, noes 15, excused 5.
And House Bill 164 is assigned to Committee Number 10, Labor. All right. Bills on second reading. Thank you. All right. Senate File 22, second reading of the Senate file.
Senate File 22, ground for termination of parental rights guardianship, sponsored by Senator Schuler.
Senate File 22 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 133, second reading of the Senate file.
Senate File 133, protection of parental rights amendments, sponsored by Senator Brennan.
Senator Brennan.
Thank you, Mr. President. Absent objection, I would request that Senate File 133 be laid back for 1 day.
Hearing no objection, it is so ordered. Senate File 133 is laid back for 1 day. Senate File 157, second reading of the Senate file.
Senate File 157, Department of Family Services Confidentiality Amendments 2, sponsored by Senator Olson.
Senate File 157 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 164, second reading of the Senate file.
Senate File 164, Parimutuel Rodeo Definition, sponsored by Senator Driscoll.
Senate File 164 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 169, second reading of the Senate file.
Senate File 169, Strategic Investments and Projects Account Repeal, sponsored by Senator Hicks.
There is an amendment. Will the reading clerk please read it in?
Senate File 169, second reading amendment number 1, page 1, line 10, delete.
Thank you. Senator Hicks.
Mr. President, I move second reading amendment number 1 to Senate File 169. Ask for your favorable consideration. This is a technical correction that staff found from the original version. There was a provision there that they forgot to add the strikeout in the existing statute. So just a technical correction, and it changed the year to reflect what's in the rest of the bill. It's just a conforming amendment to the rest of the bill.
Thank you, Senator Hicks. Discussion on the amendment? Hearing none, question being called. All those in favor of Senator Hicks's motion to adopt second reading amendment number 1 to Senate File 169, please say aye. Aye. All those opposed, no. The amendment has been adopted. We are back on the bill. Discussion on the bill. Senate File 169 having been read two separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 175, second reading of the Senate file.
Senate File 175, Unemployment Insurance Coverage, Period and Reporting, sponsored by Senator Kolb.
There is an amendment. Would the reading clerk please read in the amendment?
Senate File 175, second reading amendment number 1, page 5, line 5, delete.
Thank you. Senator Cole.
Thank you, Mr. President. I would move second reading amendment number 1 to Senate File 175. Ask for your favorable consideration, and I'd like to explain the amendment. It's merely changing the date to conform with the department's request that it hits on a quarter, and they requested this so their system could transition with less problems because it would be more amenable. So this came from the department head. to move the date these few days, Mr. Chairman. I ask for your favorable consideration, or if you have any questions, can answer them. Thank you.
Thank you. Discussion on the amendment? Discussion on the amendment. Seeing none, question being called. All those in favor of Senator Hicks's motion to adopt second reading amendment number 1, the Senate File 175, please say aye. Aye. All those opposed? What did I say? Did I say Hicks? I was looking at Hicks, that's why. Let's do that again. All those in favor of Senator Kolb's motion to adopt second reading amendment number 1, the Senate File 175, please say aye. Aye. All those opposed, no. The amendment has been adopted. We're back on the bill. Discussion on the bill. Seeing none. Senate File 175 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate File 179, second reading of the Senate File.
Senate File 179, Sage Grouse Compensatory Mitigation Amendment, sponsored by Senator Barlow.
Senate File 179 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. Senate Joint Resolution 8, second reading of the joint resolution.
Senate Joint Resolution 8, Political Expenditures, sponsored by Senator Cooper.
Senate Joint Resolution 8 having been read 2 separate times. The question is, shall the bill be read a third time? Hearing no objection, it is so ordered. All right, we are at that order of business on bills on third reading and final passage. Madam Majority Floor Leader, do we have a consent list?
Mr. President, I move third reading consent list as follows. Senate File 103, terminating and defunding diversity, equity, and inclusion. Senate File 126, establishment of a K-8 public lab school. Senate File 151, monthly ad valorem tax distribution amendments. Senate File 154, industrial wind and solar projects hearing deadline. Senate File 162, education block grant model amendments. Senate File 172, physical therapy licensure compact. Senate File 191, state funds proxy voting and pecuniary investments. Senate File 196, Second Amendment Protection Act amendments. Senate Joint Resolution 4, resolution on commercial baseload power generation. And Senate Joint Resolution 11, this is not the right list, supporting anti-ESG litigation. Thank you, Mr. President.
Thank you. Would anybody like any of these removed from the consent list? Senator Dockstetter.
Thank you, Mr. President. Senate File 126.
Senate File 126 is removed from the consent list. Any others? Having been read 3 separate times, the question is, shall these bills pass the Senate? Senate File 103, terminating and defunding diversity, equity, and inclusion. Senate File 151, monthly ad valorem tax distribution amendments. Senate File 154, industrial wind and solar projects hearing deadline. Senate File 162, education block grant model amendments. Senate File 172, physical therapy licensure compact. Senate File 191, state funds proxy voting and pecuniary investments. Senate File 196, Second Amendment Protection Act amendments. Senate Joint Resolution 4, resolution on commercial baseload power generation, and Senate Joint Resolution 11, supporting anti-ESG litigation. Chief Clerk will call the roll.
On the consent list, Anderson. Aye. Barlow. Boner. Aye. Brennan. Aye. Case. Aye. Cooper. Aye. Crago. Crum. Aye. Dockstetter. Aye. Driscoll. Aye. French. Aye. Guru. Aye. Hicks. Aye. Hutchings. Aye. Ide. Aye. Jones. Aye. Kolb. Landon. Aye. Larson. Aye. McEwen. Aye. Nethercott. Aye. Olson. Aye. Pappas excused. Pearson. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Smith. Aye. Steinmetz. Aye. President Beitman.
Aye.
On the consent list, 30 aye, 1 excused. Senate File 103, are there any changes? Rothfuss, aye to no. Guru, aye to no. Case, aye to no. Landon, no. Closing vote. Closing. Vote closed. Senate File 103, 26 aye, 4 no, 1 excused. Senate File 151, are there any changes? Ayed? Ayed? Aye to no. Closing vote. Closing. Vote closed. Senate File 151, 29 aye, 1 no, 1 excused. Senate File 154, are there any changes? Ayed? Aye to no. Smith? Aye to no. McEwen? Aye to no. French? Aye to no. Closing vote. Closing. Vote closed. Senate File 154, 26 aye, 4 no, 1 excused. Senate File 162, are there any changes? Case aye to no. Dockstetter, no. Schuler, no. Guru, no. Rothfuss, no. Landon, no. Jones, no. Cooper, no. Anderson, no. Crago, no. Crum, no. Nethercott, no. Closing vote. Closing. Vote closed. Senate File 162, 18 aye, 12 no, 1 excused. Senate File 172, are there any changes? Ayed? Aye to no. Closing vote. Closing. Vote closed. Senate File 172, 29 aye, 1 no, 1 excused. Senate File 191, are there any changes? Case aye to no. Closing vote. Closing. Vote closed. Senate File 191, 29 aye, 1 no, 1 excused. Senate File 196, are there any changes? Case aye to no. Closing vote. Closing. Vote closed. Senate File 196, 29 aye, 1 no, 1 excused. Senate Joint Resolution 4, are there any changes? Case I to know. Closing vote. Closing. Vote closed. Senate Joint Resolution 4, 29 aye, 1 no, 1 excused. And Senate Joint Resolution 11. Are there any changes? Case I to know. Rothfuss, I to know. Closing vote. Closing. Vote closed. Senate Joint Resolution 11, 28 aye, 2 no, 1 excused.
Having received the affirmative vote of the majority of the members elected to the Senate, Senate File 103, terminating and defunding diversity, equity, and inclusion. Senate File 151, monthly ad valorem tax distribution amendments. Senate File 154, industrial, wind, and solar projects hearing deadline. Senate File 162, education block grant model amendments. Senate File 172, physical therapy licensure compact. Senate File 191, state funds, proxy voting, and pecuniary investments. Senate File 196, Second Amendment Protection Act amendments. Senate Joint Resolution 4, resolution on commercial baseload power generation, and Senate Joint Resolution 11, supporting anti-ESG litigation have passed the Senate. Bills on third reading. Senate File 126, third reading of the Senate file.
Senate File 126, establishment of a K-8 public lab school, sponsored by Senator Rothfuss, an act relating to education.
Senator Doxter.
Thank you, Mr. President. Mr. President, I asked to have this pulled off because I can't get past the point of feeling that we're missing an opportunity to involve the rest of the state. Members of the Senate, Mr. President, I travel across this state to a lot of events related to the university, not sporting events, but actually academic-related events, programs related to honoring the graduates, you name it. I'm here. I believe in this university. I'm sitting around a table with a group of students who are soon to graduate, take their careers, unfortunately, to other states. We were at a dinner event and they were talking and I ended up on a side table with them, and they soon to finish up at the University of Wyoming and leave to go to other states to take their careers along the way. And that bothered me. How do we keep our students at home? How do we involve them in Wyoming? And in the education world, I've sensed that if we're keeping everything centered around the university just over the hill and not working with our 48 districts and not having the students out there as much as possible, we lose yet another group of students out to who knows where with other teaching assignments. Mr. President, I'd like to keep them at home. I'd like to work with 48 districts. And if we don't have a good situation where we're out there opening up the doors of opportunity for them to stay here in the education world in Wyoming with those districts, then let's make those changes. Let's not keep them in the university setting in a lab school just over the hill. Let's involve all of our school districts. I think about that in terms of other things, and I'll just divert just a little bit. I would hope that we could round up enough engineers to take care of the Trona patch. I wish I attended the event where we honored a former U.S. Senator over at the university this fall and opened up another wing of the law school and future studies there. And you're going to think I'm strange to say this, but I think we need more attorneys. Yes, graduated from the University of Wyoming and brought here and kept at home and helping us with our mineral industry and all things Wyoming. And if we don't involve the rest of the state in some form or fashion, back to the schools, we're missing the opportunity. So that's why, Mr. President, I ask that we pull this off, give it some reconsideration. I know it has a lot of support. when it came up for a vote, I watched a lot of people that traveling in their lane of traffic all of a sudden take the exit over to the lab school. I did kind of a head spin. I said, whoa, look at this, got a lot of support. So I hesitated even bringing it up. But I think we're wrong if we don't discuss this. If we don't reach out, involve the rest of the education community around the state and open up those lab school opportunities in all 48 districts. So I'll stand opposed to the bill.
Discussion on Senate File 126. Senator Scott, for your first time.
Yes, Mr. President. And I have talked extensively to the management of the School of Education at the University of Wyoming. And I can tell you that regardless of whether there's a lab school or not, they are strongly committed to reaching out and placing their students for teaching purposes in districts all across the state. They're strongly committed to reaching out and helping those districts be the best they can. So I don't think that issue is at play here. I think this has to do with the excellence of the school. I don't think it will affect the behavior of the Department of Education significantly, Mr. Chair.
Thank you, Senator Scott. Anybody else wish to speak on the bill? Senator Nethercott.
Thank you, Mr. President. I appreciate the concerns of the good senator. I am surprised to hear them, though, because that's not really the issue at all. The school has been in existence for about 140 years, I think 1887, before we were a state. I know that I had student teachers in my schools in Riverton and Pinedale, and it never interfered with that. Usually, the students getting degrees in teaching that go back into their communities to student teach. So I've never heard or even think it's a relevant argument that the lab school is somehow preventing student teachers from teaching throughout the state of Wyoming. In fact, they should be graduating so many that the 1 K-8 lab school, can't take all of the education students to student teach, and certainly not the high school level students. And so I'm not sure that is an argument on point or connects to, again, the long-term history of educating these students in Albany County on the university's campus. Is it a resource for those education majors and others to interface with that population? Certainly, but it is not a threat and should be seen as an asset to that program. And I believe in continuing to support all of those educational and professional programs at the university. And the lab school, having been in existence for 140 years, is no threat to that. Thank you, Mr. President. Vote aye.
Thank you, Senator. Discussion? No, Senator Rothfuss.
Thank you, Mr. President. Very briefly, I did just want to echo that. The vision of the good senator from the western part of the state is exactly on point, and the College of Education knows that, the university knows that. The emphasis is on ensuring that all of our districts, all of our schools have access to student teachers for the very reasons that were laid out. And I'm sorry that this was presented in a way that it created a dichotomy between the lab school and that. It's not. In fact, the lab school is a part of that plan, a part of that vision. The pre-service teachers prior to student teaching need the opportunities at the lab school, but the whole state is the playground for an appropriate College of Education placement on student teaching. And if it were anything to the contrary, we'd certainly be hearing back from the communities. And Mr. Chairman, for a while, about 6 years ago, 8 years ago, there was a lot of concern because the placements were taking place largely in Casper, Cheyenne, and a few other cities that were easier to manage. But the concerns of the state were heard loud and clear by the College of Education that every district in the state needs access to student teachers, and that was provided and will continue to be provided. This legislation has nothing to do with that vision, with the exception of the fact that it might empower it further by allowing that lab school, through the mission of the lab school, to have statewide outreach and really try and cultivate education statewide to improve the very thing that the good senator is concerned about. On and for the bill.
Discussion? Senator Dockstader, for your second time.
Thank you, Mr. President. I'll wrap it up here. Appreciate that. If anything, this discussion, I hope, leads the university to involving the rest of the state, not on this, but in all things. We have a great university, and we need to find ways to involve the state at all levels. What is on point here, and at issue, is the Senate's probably been taken in and involved in something that is probably an issue that needs to be resolved on the campus of that university and not have an override from this Senate. So I'll stand against the bill at this time. Thank you.
Thank you. Anybody else? Okay. Senate File 126, having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Third reading roll call, Senate File 126. Anderson? Aye. Barlow? No. Boner? Aye. Brennan? Aye. Case? No. Cooper? Aye. Crago? Aye. Crum? No. Dockstetter? No. Driscoll? Aye. French? No. Guru? Aye. Hicks? No. Hutchings? Aye. Ide? No. Jones? No. Cole? No. Landon? Aye. Larson? Aye. McEwen? No. Nethercott? Aye. Olson? No. Pappas excused. Pearson? Aye. Rothfuss? Aye. Salazar? Aye. Schuler? Aye. Scott? Aye. Smith? Aye. Steinmetz? No. President Beitman?
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 126, 18 aye, 12 no, 1 excused.
Senate File 126, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 126 has passed the Senate. Let's see here. Senate File 155, third reading of the Senate File.
Senate File 155, International Physician Licensing, sponsored by Senator Driscoll, an act related to physicians and surgeons.
Looks like there's an amendment. Would the reading clerk please read it in?
Senate File 155, third reading amendment number 1, delete.
Senator Hutchings.
Thank you, Mr. President. I move third reading amendment to Senate File 155 and ask for your favorable consideration. When we brought this bill to the committee, never had a thought that they would want to remove the U.S. MLE from page 4, lines 1 through 2. The U.S. MLE is United States Medical License Examination. It's a 3-step examination taken by medical graduates in order to practice medicine in the United States. What this bill does is it allows foreign doctors to come in and work here in Wyoming under a practice here. Because we won't know, unless these people take these exams, if their qualifications have been falsified. We won't know anything about their background or education. With this examination, it ensures that licensed physicians are held to a rigorous and reliable standard and have demonstrated they understand they understand and can apply the medical knowledge and skills and clinical reasoning to provide safe and effective patient care. In fact, the National Board of Medical Examiner research shows that better U.S. MLE performances correlates to improved patient outcomes. These exams provide us with, give proof that the doctors have education in anatomy, biochemistry, behavioral sciences, immunology, pharmacology, They have clinical skills, clinical knowledge, and knowledge of patient management, disease, how diseases evolve over time. They aim to access their knowledge on diagnosis, care management, and medical decision-making. Policy decision, if we think it's okay for someone to come in from another country and practice here in Wyoming without taking this exam, vote no on the amendment. If you think it's important that they have the exam and they go through this rigorous training, vote yes on the amendment. Thank you, Mr. President.
Thank you, Senator Hutchings. Discussion on the amendment. Senator Driscoll.
Thank you, Mr. President. On an opposed amendment, folks, these are they're skilled doctors that have already come. There's a complete application and ability to ask anything they want to know. They still have to go through all the background checks, have to do all the things. And as they come in, as you look in the bill, there's a section in it that the ability to bring them in, they can ask any question they want. This is just another layer of bureaucracy, and my answer is the same as it was the first time. We should get rid of it for our physicians as well. Paper does not make a good physician. Good physician is somebody that treats patient. I encourage you to reject it.
Senator Brennan.
Thank you, Mr. President. I too would like to push back a little bit and oppose this amendment. As you all know, I work with several physicians, and actually probably 50% or more of the physicians that I work with are trained internationally and come here to work for our people after that. An exam is just that. It's an exam. And sometimes it gives us information, sometimes it doesn't. But the credentialing process for physicians within a hospital situation is actually a long, tedious process where they have to prove a lot of things. And this is just another added layer of bureaucracy that's going to make it longer for us to get physicians here to the United States in order to take care of our patients. So I do not find this necessary for us to have physicians to be able to practice here in the state of Wyoming, and I would urge a no vote on this amendment.
Thank you, Senator Brennan. Anybody else wish to speak on the amendment? Back to you, sponsor. Senator Hutchings.
Thank you, Mr. President. Just vote your conscience. If that's the way you feel, that's fine. Thank you.
Question being called. All those in favor of Senator Hutchings' motion to adopt third reading amendment number 1 to Senate File 155, please say aye. Aye. All those opposed, no. No. The amendment has failed. We are back on the bill. Discussion on the bill. Question being called. Senate File 155 having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Third reading roll call, Senate File 155, Anderson. Aye. Barlow. Aye. Boner. Aye. Brennan. Aye. Case. Aye. Cooper. Aye. Crago. Aye. Crum. Aye. Dockstetter. Aye. Driscoll. Aye. French. Aye. Guru. Aye. Hicks. Aye. Hutchings. No. Ide. Aye. Jones. Aye. Kolb. Aye. Landon. Aye. Larson. Aye. McEwen. Aye. Nethercott. Aye. Olson. Aye. Pappas excused. Pearson. Aye. Rothfuss. Aye. Salazar. Aye. Schuler. Aye. Scott. Aye. Smith. Aye. Steinmetz. Aye. President Beitman.
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 155, 29 aye, 1 no, 1 excused.
Senate File 155, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 155 has passed the Senate. Senate Joint Resolution 2, third reading of the joint resolution.
Senate Joint Resolution 2, resolution demanding equal footing, sponsored by Senator Ide. A joint resolution demanding that the United States Congress, in consultation with the legislature of the state of Wyoming, extinguish the federal title in those public lands and subsurface resources in this state that derive from former federal territory, and do so in recognition of the sovereign rights of this state as set forth in its Congressional Act of Admission into the Union, and in recognition of the solemn duties resting upon Congress under the admissions, property claims, and guarantee clauses of Article 4 of the United States Constitution, so that the state of Wyoming shall in due course obtain full admission into the Union of States upon an equal footing with the original states in all respects whatsoever.
There is an amendment. Would the reading clerk please read in the amendment?
Senate Joint Resolution 2, third reading amendment number 1, page 3 after line 22, insert.
Senator Guru.
Thank you, Mr. President. I move third reading amendment number 1 to Senate Joint Resolution 0002 and ask for your favorable considerations. Mr. President, good members of the 68th, this is fairly simple, just adds on page 6, line 8, after the word resources, excluding any federal national parks, national monuments, federal historic sites, federal recreation areas located within Wyoming. I've talked to the good bringer of this amendment, and he and I couldn't agree to co-sponsor this, and I certainly understand. But for me, in an attempt to try to make the bill better, and I want to be totally transparent here, I'm a no on the bill either way, but just trying to make it better. And to me, what would make this resolution better is to exclude these national treasures from this bill. I understand the frustration. I understand the issues involved. But these particular areas all run by the National Park Service. And I want to make that real clear. This is just these are National Park Service lands. The point here is no matter how upset you are at other branches or other departments within the federal large S, these are special places known by all Americans and all Wyomingites as special treasures, treasures that we hold very dear. So excluding these, I think, makes this a better resolution, and I ask you to support it. On and for. Thank you, Mr. President.
Thank you, Senator. Who else wishes to speak? Senator Ide. Oh, yep, Senator Ide, go ahead.
Thank you, Mr. President. I appreciate the good comments from the Teton County. It's a legitimate concern for sure, but I'm on and against the amendment just for the fact that, let me just read this to you real quick. Just go back to the bill here, section 4, on the bottom of page 6. I'll just read it again, it's pretty short. That the members of the Wyoming legislature recognize that the state of Wyoming has authority to absolve Congress of its constitutional duty to dispose of any portion or all of the federal territorial lands remaining within the state's borders. Accordingly, the legislature expresses its willingness to negotiate cession to Congress of the state's sovereign jurisdiction over any lands that may be mutually recognized as national interest. So the good bringer of the amendment, that's ultimately where we may end up, but I think we're giving up a card in our hand if we ever get to the table to negotiate here with Congress on, their duty under the property clause and, our act of admission, for equal footing with the original states. It's pretty clear. So, not to belabor on, but I wrote a few notes here that I probably can articulate better reading than just off the cuff here. But, this legislature and this governor, for that matter, we don't legislate over half of our state. The governor doesn't govern over half of our state. Our mineral estate is even more, it's 70%. We need to remember that. Does this legislature intend to be a legislature for the entire state, as promised under our congressional act of admission? Or are we content to cede that role over, over these areas that the good bringer of the bill, brought to Congress in the other 49 states? That's essentially what we would be doing with this amendment. So just keep that in mind. I think the intent is right, but I don't think we should concede to that yet until we get a chance to have the conversation with the powers that be back on the East Coast. Thank you, Mr. Chairman.
Thank you, Senator Ide. Well, Senator Driscoll.
Mr. Chairman, Mr. President, I think this is a great amendment to it. I think all of us heard loud and clear from the public. It's pretty interesting. We represent the people of Wyoming, and it's been pretty clear to me that the people love a lot of our public grounds. I live next to one. I think they happen to do a good job with it. It was never for homesteading. I'll make this statement again coming up, but nearly all these grounds were withdrawn from homesteading for a reason. And it wasn't when we went in. Our Constitution was clear that we didn't go this route. But on top of that, they withdrew them from homesteading. One layer above that, and it's kind of interesting, looking over my good friend up in the land of the Tetons, let's keep in mind that ground was all given to the federal government. It wasn't even part of it. It was all ground that was bought by somebody else and given to the federal government. And now we're asking them to give it back. It was given under the terms to be given to them. I'd encourage you to vote for this amendment. And if you can't, vote against the resolution. Thank you.
Thank you. Senator Scott.
Yeas and nays, please, Mr. President.
Yeas and nays have been called. We're on third reading amendment number 1. Senator Pearson, for your first time.
Thank you, Mr. President. So this amendment wouldn't include our national forests, correct? Just a question.
Okay. Any more questions for the bringer? Senator Nethercott.
Cancel on the bill.
Oh, sorry. All right, back to you, Senator Guru.
Thank you, Mr. President. I'll be short and answer the question. No, no national forests are in this, and I tried to be as prescriptive as I could. But we'll talk about the bill, or we'll talk about the resolution in a minute. But on the amendment, I understand the desire. I want to keep our cards close, and stay in the game. The folks that I represent, and as I said, and when this was brought up, 99% of my district is held by the federal government. And the folks who work there and the folks that make their living from that, in that other 1%, 10,000 people who spoke at public hearings around the state, all spoke with one voice and said, we hold these lands dear. We hold these lands sacred. Please vote on and for the amendment. The folks in my district don't want to sit at that card game. Thank you.
All right. We're voting on third reading amendment number 1, the Senate Joint Resolution 2. The chief clerk will call the roll. He went for his second time. He's the author of the amendment.
Third reading amendment number 1 to Senate Joint Resolution 2. Roll call. Anderson. Aye. Barlow. Aye. Boner. Aye. Brennan. Aye. Case. Aye. Cooper. Aye. Crago. Aye. Crum. Aye. Dockstetter. Aye. Driscoll. Aye. French. No. Guru. Aye. Hicks. Aye. Hutchings. No. Ide. No. Jones. Aye. Cole. Aye. Landon. Aye. Larson. No. McEwen. No. Nethercott. Aye. Olson. Aye. Pappas excused. Pearson. Aye. Rothfuss. Aye. Salazar. No. Schuler. Aye. Scott. Aye. Smith. No. Steinmetz. Aye. President Beitman?
Aye.
Aye. Closing, Salazar? No to aye? Closing vote? Closing, vote closed. On the amendment, 24 aye, 6 no, 1 excused.
Third reading amendment number 1 has been adopted. We're on third reading amendment number 2. Will the reading clerk please read in the amendment?
Senate Joint Resolution 2, third reading amendment number 2, delete.
Senator Driscoll.
Thank you, Mr. President. I move third read amendment number 2 to Senate Journal 2. Folks, I will belabor it much. This one does add in the wilderness areas, the national forests, national recreation areas, and other federally designated areas that are public. This really gets it to where I think you can be at the table is, I think the state ought to own all their minerals, all the subsurface should have come, same as any other state. And I think a lot of this scattered country that's probably mainly BLM, but grounds that were in homestead and whatnot, checkerboard grounds, those make sense to go back into state. They're just as easy managed by the state. They make sense for it. And I actually think resolutions are often called letters to Santa. And it means that they never go anywhere and they're never respected. And if you actually want to get to the card table and be respected, you have to be logical about what you do. This takes another step that way. I think it's a good move. Ask for your consideration.
Okay. Any discussion? Senator Anderson.
Mr. President, I'm wondering why no one exempts the reservations. They're sovereign nations within our borders. I'm wondering why we don't exempt them.
Anybody else? Anybody else? Question being called. I was wondering if you were gonna speak there.
Sorry, get my last shot here. So I'll keep it brief here. There's only one more comment that I wanted to make, just to keep on the top of our head. No one took an oath to devolve our legislative responsibility to the National Park Service or the Department of Interior or to Congress for that matter. I think we should guard the soil within our borders and our mineral estate as strong as we guard our rights, God-given rights, and our Bill of Rights in the U.S. Constitution. I mean, this is important. We need to defend our borders, and this is what this bill does. So we have effectively full autonomy other than Yellowstone National Park. So thank you, Mr. President.
Bill sponsored or amendment sponsored, you want to go for your second time?
Mr. President, yeah, not to belabor it, it's just this is a good amendment that really puts us to the right place that we ought to be at. I think we all agree the minerals are the most important part, and grounds that actually can be managed by us that aren't of national significance at this point. I think realistically, you can argue any way you want, but there is a snowball's chance in whatever you want to call it to ever come up with these grounds that are in these amendments. So there's no sense asking for something that just flat isn't going to happen, both from the people of Wyoming and from the federal government.
All right. The sponsor's already gone twice, sir. Okay, we're voting on Senate Joint Resolution, or third reading amendment number 2 to Senate Joint Resolution number 2. All those in favor, please say aye. Aye. All those opposed, no. No. The ayes have it. The amendment has been adopted. Division being called. All those in favor, please stand. Seventeen ayes. Those opposed, please stand. Less than 17. I'm a no. 13 no. Third reading amendment number 2 has been adopted. We are back on the bill. Discussion on the bill. Senator Case.
Thank you, Mr. President. Well, I think that it's a better bill now, Mr. President, but I would hope we would still defeat it. Mr. President, people in my district love their public lands. This is probably the most important issue to them in the whole session in a lot of ways. They really don't feel that the state doesn't necessarily a good job of managing the lands that the state oversees. For one example, our state school trust lands, they don't have public access. And I understand why, but they don't necessarily understand that, Mr. President. So they use our federal lands. They love them, they use them. They love the freedom to be able to go there, and they often point to states that don't have broad swaths of public lands, like those good friends on the border that wear the big hats and have towns like Houston and Dallas. And there's no public land there. To go hunting, you have to go join a club. And you know, you go out on a big ranch and you pay big money. Same for fishing, same for camping. Mr. President, it's been proposed that the Constitution doesn't provide for the federal government to hold these lands. And that's not true. There's been a lot of litigation, but the Constitution talks about two things. Talks about 10 square miles for the seat of government, to be seated by different states. That was for Washington, D.C. It talks about if there's a need for new lands, that the feds will confer with the states, state legislatures. But these lands belonged to the federal government before we were a state, and we relinquished any claim to them in our act of admission. And there's another part of the Constitution called the Necessary and Proper Clause. And it's as well litigated as anything you can imagine and is just as constitutional strong as words on the page. And it goes back to Chief Justice Marshall in 1819 in a case called McCullough versus Maryland. And it is one of the most fundamental pieces of our Constitution as much as any other words. And it says the federal government can do other things besides the enumerated things necessary and proper to carry out its mission. There we are. We have this rough relationship with the federal government that's not always easy, but we're co-responsible for the state's surface areas. I'd kind of like the minerals back too, I really would, Mr. President. But I don't think we have the resources to manage these lands. I look at our struggling to refill a fire account for our own lands. Do you know how much difficult that was to put that money in? Can you imagine if we had the responsibility for fighting fire across all of Wyoming? We couldn't afford it. We don't have the tools to manage this land. We couldn't get the tools. We don't have enough people. We don't have enough money. And even if we did get those mineral rights, which I'll tell you, they're not going to give us those mineral rights, Mr. President. And they're not because if we got them, Nevada would want them, Colorado would want them, Idaho would want them, Arizona would want them. And the federal government's not going to give up that revenue. I hope you'll oppose this bill.
Other discussion? Senator Anderson.
Mr. Vice President, I've been discussing this idea for 40-some years. 40 years ago, I was in another county and we tried hard to put this through. And we ran up against what we're running up against today. In our acts of admission, which was 1890, we were trying to get into the Union, We gave up our public lands. Paragraph 12 gives it up. We also put it in our Constitution in 1890, and I'll read that to you. It's in the ordinances, and the ordinances are, the following articles shall be irrevocable without the consent of the United States and the people of the state. It's in section 21, paragraph 26, ownership of certain lands disclaimed, restriction on taxation and non-residents. The people inhabiting this state do agree and declare that they may forever disclaim all right and title to the unappropriated public lands lying within the borders thereof, and to all the lands lying within said limits owned or held by any Indian or Indian tribes, and that until the title thereto shall have been extinguished by the United States. I'll stop there. Anyway, our own Constitution says we're not going to do it. Our acts of admission says we weren't going to do it. That was in 1890, and it's been upheld ever since with every attorney that I know. Thank you. I'm against this resolution.
Senator Boner.
Thank you, Mr. Vice President. On and for the resolution, symbolic though it is, I think it is important that we have this discussion. Coming from Converse County, we've had some difficulty with the federal nexus in recent years. Most notably, we worked really hard on the environmental impact statement that went through a lot of local input, came into a balanced conclusion, but unfortunately was opposed by radical environmentalists. In spite of all that local input, all that local buy-in, you have folks who are usually button heads, landowners, oil and gas companies, local school districts, everybody's standing up and supporting the CIS. All it takes is one lawsuit, Mr. Vice President, not determined here by a judge here in Wyoming, but back east in DC, to threaten all of that economic activity. That's where we're standing right now, Mr. Vice President. So I understand that we like our public lands. I hope that we can find some way to thread the needle here where maybe we do just get the minerals in return. And maybe we can continue to split the revenue with the federal government. I think we're being rather uncreative here in our discussion, assuming that it just has to be one way, Mr. Vice President. But if we can even just still split the revenue with the minerals as we currently do, we're going to see a significant increase in production because of the lack of red tape, the lack of political and legal risk associated with developing, in this case, oil and gas in the Powder River Basin. So on for the resolution, Mr. President. If we're not going to stand for ourselves after the past 4 years, I don't know when the time's going to be. This is a threat to my community. It's a threat to my constituents' property rights. And frankly, I've had enough. I think we could pass this symbolic resolution and move forward.
Thank you, Senator Boner. Senator Landon.
Mr. President, thank you. As we take up these resolutions, I always think about my good friend. When I first got down here, which is now many years ago, there was a gentleman who preceded the good man from Teton County, and I learned so much from him. He was quite the statesman, one of the best I've ever seen down here, but I can remember him standing up and telling us where these resolutions go, and he likened it, he didn't say it this way, I said it this way. It's kind of like the neighbor's dog on the back porch. He's over there barking at things, and generally barks at quite a few things, but it really doesn't do any good. And that's kind of what happens with these, unfortunately. These resolutions, they're kind of like the coffee shop deal, you're sitting around the coffee shop, what we ought to do is we ought to take on the federal government, and we ought to get some land back. And that's good too. I mean, sometimes it's okay because of the title of these things, you think, boy, I really ought to just take that home because people are going to ask me about it, and I don't have the heart to tell them that these resolutions really don't do anything. And they do have a title, but the problem is they've got all of this stuff in the bill too, Mr. President, and that's where I'm struggling with this one. I agree with the senator from Fremont County. I don't even have any idea how we would stand this up. I have no idea what that would look like. Ironically, the previous speaker, he and I took on our state lands folks here a couple of years ago in his neck of the wood. We couldn't get anywhere. sometimes our state agencies are as tough on us as the people that I work with around those reservoirs in the center part of the state. So I'm going to be on and against the resolution, not because I don't really admire the passion of my good friend from my county who's worked really hard on this and has his heart in it, but I can't quite get there with this one. So thank you, Mr. President.
Thank you, Senator Landon. Senator Dockstader, then Senator Scott.
Thank you, Mr. President. Point was somewhat made just a moment ago. Folks, resolution is just a resolution, that's it. We're not going to do a whole lot here. We've made some changes. I was okay with the national parks, okay, move those out. My concern over the years has been getting an actual national forest that's multiple use. Years ago, we shut down our timber industry out west because the forest was managed from a wilderness concept instead of a multiple use concept. We lost jobs, it hurt our economy. Can we ever come back to that? No, because somewhere in that management process, they're looking at those forests like a national park, and they're not managing them for multiple use. And granted, there's financial challenges too. You wait for money for roads and all of that, but somewhere along the way, we got away from managing our national forests as full multiple use and fully utilizing regional economies, helping regional economies with that approach. So I'll be for the resolution. I don't know that it does much, but that's where we are. We got to somewhere keep pushing back and saying, those of us who live here, live amongst those forests, get to have a say in it too, not just across the nation. So I'll be for the resolution.
Thank you. Senator Scott, you're next.
Mr. President, reluctantly, I rise, and I've been voting against this particular resolution for, by my count, 47 years now. And the problem with it, Mr. President, we look at the benefits to us, say, we could do a much better job, and we could, of managing particularly the mineral rights. But what we do is we look at the benefits to us. But legally, Mr. President, we've never gotten anywhere. Neither has anybody else with one of these lawsuits. The courts just don't buy the theories. What we need to do, if we want to get some of the lands, is to structure a deal that's a good deal for both sides, not just for us. And, Mr. President, I think that might be possible if we were to try to buy the mineral rights on a deal that kept the flow of royalties exactly the way it is right now, so we would manage them rather than the feds, because we would do a better job and a more profitable job for everybody. You could structure a deal that would make sense with that. But that's not what this is, and I don't think you could, within the title of it, you could change it into that. So, Mr. President, these things, they just aren't going to work. They don't pay enough attention to the rights that people really do have on the surface of the public lands. And our constituents feel strongly about that, at least mine do. So for all those reasons, Mr. President, on and against this particular joint resolution.
Thank you, Senator Scott. Anybody else? Senator Hicks?
Mr. President, just to add a little context to the discussion here, having sit through a task force that worked over a year on this issue, first I want to address the issue of can we afford it? Does this make us money? Now, we just exempted out with the adoption of the amendment, national forest, parks, monuments. And so this number's dated a little bit. It's about a decade old, but when we looked at this about a decade ago, at that point in time, the mineral estate operated by the federal government was generating about $3 billion a year of income. So that's just the mineral estate. It was costing the Bureau of Land Management about $1 billion a year to administer all of those. Because keep in mind, BLM manages the minerals under all federal lands, not just BLM lands. So even under, they have the leasing and the oversight of that. So to the issue of can we afford it, it's absolutely we could afford it if we acquired mineral estate. Because we've exempted national forests out. When we looked at national forests, because of the lack of commodity emphasis production, we're actually a net loser. Our national forest a decade ago, we're losing about $44 million a year of operating expenses. So, but with the amendment, we've taken care of that. And so absolutely we can afford to do this if we acquired just the mineral estate. The other things I just want to point out, as my colleague pointed out, under the Constitution, under Article 21, under ownerships, under Section 26, this section deals with people inhabiting the state do agree to declare that they forever disclaim. So the reason that's in the Constitution, and it was part of the Act of Admission, it basically said as you, the people, a private individual, can't claim the unclaimed federal domain. That specifically talks about people. Does not talk about states. And so that was designed so nobody could go out there as individuals and claim all this unappropriated. So in our Constitution, we said the people. But then if you go back and you look at our Constitution under Article 18, Section 1, and thank you for my colleague from Albany County pointing out to me, these are public lands. If the state acquires these under our Constitution, they're public lands. It's right there, Article 8. Oh, and then it talks about acceptance of lands from the United States, such sale of lands, the state of Wyoming. So one provision in the ordinances deals with individuals claiming the federal domain, and the other one talks about grants to the state or public lands under our Constitution. So you have to segregate the difference between an individual and the state and the Constitution. We, under that article, said we'll accept those grants of lands, the state of Wyoming will, and they will be public lands. And so not speaking for or against, but just to provide some edification for decision-making as you vote on this, I think those issues are important.
Thank you, Senator Hicks. Let's go over to Senator Pearson and then Senator Rothfuss.
Thank you, Mr. President. I have been 30 years or more watching what this federal government can do to industry in Wyoming. In the last 4 years, we've seen what they're willing to do. I know that our public is worried about the public lands, but if another president would have been elected, our public would have been off of a lot of public lands in southwest Wyoming. Think about that. We have got to start pushing back against this federal government who dreams to take over our state and tell us where we can and can't go, how we can and can't live. On and for this resolution. Thank you.
Thank you, Senator Pearson. Senator Rothfuss, over to you.
Thank you, Mr. President. Mr. President, on and against the resolution. You know, we talk about it as if it's federal land in a way that dissociates it from us the people. That land is federal land, yes, when we look at it from an administrative standpoint, but at the end of the day, the most important feature of it is it's our land. It's my land. It's my constituents' land. That's correct. This land is your land. You can feel free to sing that, Senator. But it's true. You know, I'm a co-owner of 30 million acres in the state of Wyoming. 30 million acres of land that, Mr. President, I have access to. Nobody's trying to keep me out of that, unless there's private property between me and it. That's a whole different story. But from the perspective of the government, it's land that I have access to. And that's incredible. That's one of the greatest resources we have. I think we take it for granted because we've had it for so long and we have so much of it, we forget. It is a rich, rich luxury that the people of Wyoming have, and the people of this country have, that there is so much federal land that we all have access to, our land, public lands. And then we contrast that with our state lands, which again are public lands, but we manage them differently. And this idea of multiple use of public lands, we contrast how the feds do it, and we don't like how they manage mineral resources. And that's fair, right? We have good reason not to like how they manage mineral resources on federal lands. Again, our public lands. But when we look at the state lands, many of those lands are managed to exclude public access for hunting, for fishing, for recreation, for enjoying. By the regular public, right? The people that want to spend their weekends on that land. My constituents. They care a whole heck of a lot more, candidly, about being able to access their public lands when they need to relax, when they need to enjoy this great state, when they need to remember why they live here. And they have that opportunity. Now, there's certainly, Mr. President, things that we can do better. I am absolutely convinced that we would benefit from having changes to how federal land is managed with regard to mineral development and multiple use. But when it comes down to that land ownership, I'll remind the chamber that the state of Wyoming has sold just about 1 in 6 of every acres it's had over time. Not the best track record in my mind. But that 30 million acres of federal land, that's something that I think we want to hold on to. I want to hold on to it for my kids. I want to hold on to it for their kids. I want to make sure that nothing we do in this chamber threatens that incredible legacy. It's the greatest richness this state has, and I don't want to part it out in the short term so we can make a few bucks and sacrifice the posterity of this state. On and against.
Senator Ide.
Thank you, Mr. President. Good discussion here. First off, I'd like to just make a comment that I'm glad that the third president of our United States in 1803 wasn't worried about the management at the Louisiana Purchase, or we might be speaking French right now. So, you know, this is all of the conversation here. A lot of it's political, you know, recreation, other peripheral issues. This is pure and simple about the legal issues, the supreme law of the land, our act of admission. Some of the comments here on our state constitution, Article 21, Section 26, you know, in our act of admission, Article 12, and the property clause of the U.S. Constitution, in Article 4. A lot of times we're comparing apples to oranges here. I mean, the U.S. Constitution has a mandate for them to dispose. In our act of admission, it does say we would receive no further grants. We're not asking for any further grants here. We're proposing to Congress to transfer those lands to the state when they choose to dispose. And on another note, you know, our congressional delegation, our executive branch, I've mentioned this before, with the Utah complaint, I mean, everybody agrees that there's something wrong here, and we need to act like a sovereign state and control those lands. I mean, that's the way it was. We were brought into the union on equal footing. A lot of the arguments on, you know, forever disclaim. I've got a list here of all of the states east of us here that literally have less than, you know, 5%, 1% federal lands. They had the identical language in there. And as the good senator from the Little Snake River over there, he was spot on. These lands are held in trust for the state until they dispose, like the property clause says in the U.S. Constitution. We forever disclaimed right and title, but not sovereignty and jurisdiction. It was to clear title so they could dispose with clear title. So With that, it was good listening to all the discussion. I've spent a lot of time on this. I think we need to defend our borders here. We're going to have different administrations. We've got one that's more sympathetic to us right now, but ones before and in the future, we don't know what is going to happen. And I think the feds have more of a motivation to sell our lands potentially than the state of Wyoming would to whoever. So I implore you to do our duty under the Constitution, the Wyoming and the U.S. Constitution. And at least this is, like it was said, it's just a resolution, but it starts the conversation, and we're asking nicely to engage Congress on this issue so we can come to the table and potentially negotiate or join some of our neighboring states that agree similarly to us. So thank you, Mr. President. On and for the resolution.
Thank you, Senator Ide. Ready for the question? Question being called, Senate Joint Resolution 2, having been read 3 separate times. The question is, shall the bill pass? The chief clerk will call the roll.
Third reading roll call, Senate Joint Resolution number 2. Anderson? No. Barlow? No. Boner? Aye. Brennan? No. Case? No. Cooper? No. Crago? No. Crum? No. Dockstetter? Aye. Driscoll? No. French? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. Hyde? Aye. Jones? No. Kolb? Aye. Landon? No. Larson? Aye. McEwen? Aye. Nethercott? No. Olson? No. Pappas excused. Pearson? Aye. Rothfuss? No. Salazar? Aye. Schuler? No. Scott? No. Smith? Aye. Steinmetz? Aye. President Beitman?
Aye.
Aye. Olson? Olson, no to aye. Closing vote. Closing. Vote closed. Senate Joint Resolution number 2, 15 aye, 15 no, 1 excused.
Senate Joint Resolution 2, having failed to receive the affirmative vote of the majority of the members elected to the Senate, Senate Joint Resolution 2 has failed to pass the Senate. Senator Case.
Having voted on the prevailing side, I ask for immediate reconsideration on Senate Joint Resolution 2.
Okay, it is not debatable. We will take a roll call vote on immediate reconsideration.
For reconsideration of Senate Joint Resolution number 2. Anderson? Aye. Aye. Barlow? No. Boner?
All right, don't interrupt third reading, please.
Anderson, for reconsideration. Anderson? Aye. Barlow? No. Boner? Aye. Brennan? No. Case? No. No. Cooper? No. No. Crago? No. Crum? No. Dockstetter? No. Driscoll? No. French? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. Ide? Aye. Jones? No. Cole? Aye. Landon? No. Larson? Aye. McEwen? Aye. Nethercott? No. Olson? No. Pappas excused. Pearson? Aye. Rothfuss? No. Salazar? Aye. Schuler? No. Scott? No. Smith? Aye. Steinmetz? Aye. President Beitman?
Aye.
Aye. Closing vote. Closing. Vote closed. For reconsideration, 14 aye, 16 no, 1 excused.
The motion to reconsider has failed. Bills on third reading that affect the Constitution that will require a 2/3 vote. Senate File 145, third reading of the Senate file.
Senate File 145, Local Governments Invest.
Order.
Senate File 145, Local Governments Investments in Equities, sponsored by Senator Nethercott, an act relating to public funds.
Discussion on the bill. See, Senator Hicks.
Mr. President, I was a no on this in committee of the whole, but after consulting with the sponsor on this and getting a little more information, I do think this is the appropriate way to go. I think we're going to end up with an opportunity for local governments to invest in equities much more expediently by going through this process. I would encourage you an aye vote on this bill.
Any further discussion? Question being called. Senate File 145 having been read 3 separate times. The question is, shall the bill pass the Senate? The chief clerk will call the roll.
Third reading roll call, Senate File 145. Anderson? Aye. Barlow? Aye. Boner? Aye. Brennan? Aye. Case? Aye. Cooper? Aye. Crago? Aye. Crum? Aye. Dockstetter? Aye. Driscoll? Aye. French? Aye. Guru? Aye. Hicks? Aye. Hutchings? Hutchings? Aye. Aye. No. Jones? Aye. Kolb? Aye. Landon? Aye. Larson? Aye. McEwen? Aye. Nethercott? Aye. Olson? Aye. Pappas excused. Pearson? No. Rothfuss? Aye. Salazar? Aye. Schuler? Aye. Scott? Aye. Smith? Aye. Steinmetz? No. President Beitman?
Aye.
Aye. Closing vote. Closing. Vote closed. Vote closed. Sorry. The vote on Senate File 145, 27 aye, 3 no, 1 excused.
Senate File 145, having received the affirmative vote of 2/3 of the members elected to the Senate, Senate File 145 has passed the Senate. Senate Joint Resolution 6, third reading of the joint resolution.
Senate Joint Resolution 6, School Capital Construction Constitutional Amendment, sponsored by Senator Scott. A joint resolution proposing to amend the Wyoming Constitution to transfer responsibility to construct public school facilities to school districts by providing mandatory and optional state funding mechanisms.
Discussion on the resolution. Seeing none, question being, yep, Senator Rothfuss.
Thanks, Mr. President. My concerns on this constitutional amendment remain. I think the intent is a good intent. And I wish it were as easy as this amendment to get to the point where we had an equitable approach that provides local options to fund new schools without all of the downside challenges. But the reality is this constitutional amendment, which we've looked at quite a few times in the past, isn't the solution. It doesn't get there. It provides inequity. Some communities will be unlikely to pass bond issues and they won't get new schools. just based on their community's preferences, and that's unfair. It's inequitable. A school shouldn't be deciding that it wants inadequate schools, or excuse me, a community shouldn't be deciding that it wants inadequate schools for its students, and then that's respected. At the same time, for those counties that have high assessed valuation, it's practically costless to those counties to build new schools. The implications on an individual's taxes would be trivial, and so it's easy for certain counties to then fund new schools if they so choose. So, Mr. President, again, while I respect the intent, and we all know that we need a new funding process for building schools in the future, we've run out of our COLEAS bonuses, and they're probably not coming back anytime soon. This solution is not the right solution, and I'd really urge caution, strong caution, and suggest that we vote against this, and again, keep trying to work it until we get to the point where we have an appropriate solution available, not just a convenient one. Thank you, Mr. President.
Thank you, Senator Rothfuss. Senator Boner.
Thank you, Mr. President. I'm for this constitutional amendment. Ladies and gentlemen, this is a balanced solution that addresses real problems we have in the state. The current system worked great when we were able to tax people who frankly can't vote for us, to have this very even system where the redistribution of wealth seems to be the only priority. And the problem with that sort of system is eventually you run out of other people's money. So this is the only solution that I've seen in years being offered by anybody. And if that's going to change, if the education establishment is finally going to come to the table and offer good faith solutions, then great, let's do that. But I haven't seen that in my entire time down here, Mr. President. We have to move this forward. We have to put it to the people, let them decide. I think they're actually pretty savvy what their needs of the community are. As if we never built a school in rural Wyoming in the first 90 years of the state's existence. So let's move forward. Let's offer this balanced solution that requires some responsibility, yes, of your local school board when it comes to raising revenues, but it does provide for a new revenue stream, which is currently lacking, on for this very balanced and proven to be successful system that we have had for a very long time. I hope we can have in the future.
You, Senator Boner. Senator Larson.
Thank you, Mr. President. On and for this amendment, we all say local control, local control, local control, and this is a local control. We built schools in my area that I think the citizens there would have said, I think this could go a bit longer with the high school we built, you know, and we were happy with it, but we were afraid that the Yellowstone would blow up. And so we had to build a new school because it'd be demolished. But our local citizens should decide this. If they think a school needs replaced, then let them vote for it.
Let's see, let's go to Senator Scott.
Mr. President, on and for the amendment. Mr. President, we've been struggling with this problem for some time. We've been looking for other solutions. This is the best we have come up. Frankly, it seems to be the only one we have come up with. And we have lost our funding source. If we do nothing, the money is going to come out of the school operating funds, which is the school foundation program, and then the general fund. And Mr. President, if we want to sustain some of the things we're doing in this session, like the property tax cut, we need to start controlling our expenses. And this amendment does that. This amendment is fair. It provides an equalization, which was what was lacking in the old system. So the counties that don't have the vast mineral wealth can afford to go forward with this amendment because the equalization is mandatory. And Mr. President, it does take us back to the old system where the local people who were going to get the benefit of the school were going to have their taxes go up if they voted for it. Mr. President, that system worked for 110 years. And it built schools all around the state. It won't build as many as we would with the current system, if we could afford the current system. But it built what was necessary, Mr. President, on and for the amendment.
Thank you, Senator Scott. Let's go to Senator Hicks.
Yeah, Mr. President, I just want to walk the Senate through the fiscal reality of what you're looking at here and in support of the amendment. And so I'd love everybody just to, if you got your goldenrod handy, just take a look at it. So if you got your goldenrod and you're on page 1, just go down to line 47 or 46, and it says school foundation programs, and this is appropriations. And we'll just talk about the Senate's position. So right now, as we left here last Friday, we had expended $2.82 billion out of the school foundation program. That's this biennium. And then if you pick up, and you don't have this, but if you have everybody's got one of these, it's called your data fiscal handbook that shows the revenues for the state of Wyoming. You had one of these laying on your desk when you come in. And so then if you go to school finances and you go to page 48. So this is how much money that actually came in this biennium to the state of Wyoming. And so you look at that number and you say, wow, we got $2.3 billion of revenue that came into the school foundation program account. So under the current budget that we're operating under, we had $2.3 billion coming in. And on the goldenrod, just the Senate's position, we got $2.82 billion going out. That's about, $500-600 million that we have a shortfall. So where's that money come from? So then I want you to flip over to the page 3 and you go to legislative stabilization reserve account. So this is your rainy day when it's really raining and the economy's bad and oil prices are down and tourism's down. We don't have those sales tax. So if you go over there and you go to column 29, beginning balance of July 1st last year, the start of the new fiscal year, the budget that we're under. So we started last year, July 1st. You run that column all the way over to $1.869 billion in our rainy day account for when it really gets bad. Now I want to take you all the way down to the next line on there, and you go down there to line 62, and then it says total balance available, $1.272 billion. So you now have a $600 million deficit. We've drained about the same amount out of the LSRA. Folks, you cannot afford to continue to build schools at the rate we've been building. In this budget alone, if you want to track that out, we've got about $468 million in new school construction. If you take that long-term fiscal profile that we handed out here a couple of weeks, it will show you that after we get through this thing, the expectation of continuing to build just a few modest elementary schools around the state, that continued expenditure for school construction, somewhere around a couple $100 million of increased expenditures. And so the reality is when you look at this, is you can't continue to do this, or you're just going to shift the whole LSRA into the school foundation program account. So we've had a lot of discussions, members, about how important it is to go back and talk to our local communities about property taxes and the impact of property tax revenue and where that money comes from and how we're going to do it. I would tell you, next to retirement, this is the second biggest looming shortfall that's actually going to come. This Piper's coming to do really quick. We've already spent $600 million out of our rainy day account, and it ain't raining, folks. We have record high sales tax. We had a great investment year the last couple of years. You know, sales taxes up, mineral severance taxes are up. It is not raining, and we are draining the rainy day account. For no other reason, we have to have an honest discussion with the people of the state of Wyoming about the cost of their education system. Our budget and fiscal task has told us for over a year now, you can't do property tax relief, ECAs, and continue to build schools at the rate you can because there's not enough money to do that.
Senator
We
Hicks,
passed
you're over your
property
5
tax relief,
minutes, sir.
Mr. Chairman, on and for this amendment.
Thank you. Let's go to Senator Landon.
Thank you, Mr. President. I appreciate it. It's been a privilege to serve on your school facilities committee for a long time, 12, 14 years. Just a couple of things. Just like I complimented my good friend from Casper Mountain, I want to compliment my friend from over the mountain. He's brought this down with great passion many, many times so that we could have this conversation about what are we going to do with our schools out across the state. And we always have a good and spirited discussion about that. So I want to tip my hat to him. The previous speaker, too, has opined several times on this and actually led the charge to make sure that all the money goes in the school foundation program. We used to have an account where we try to put some aside, school facilities, so that we had some, you know, to take care of that major maintenance thing we talk about every year. So we are where we are, and unfortunately, buildings are part of that school foundation commitment that we have to make. That's part of schools. That's part of funding schools. You have to fund places for our children to go. The problems with this resolution in my mind are several, but here's a couple. So we have a rural school out there, and they decide that they're going to build a new school. And we don't have a say in that because they just decided it. So we're going to have to come down here and we'll say to ourselves, well, okay, we owe that district, we owe them some money because they don't have a very good assessed valuation, but they just voted in a school, so it's up to us to take care of it. We're going to send our money. Now, I realize we didn't have a chance to fully vet that, or don't know if they really need one. So there's that issue. The second issue, Mr. President, that I see as a problem, this comes at a time when we're trying some new things. We're trying to think about, what if our kids can stay home? What if we stand up these charter schools? What if we allow for some private schools? Well, on the facilities front, once again, that's part of doing business, Mr. President. At a time when we're trying to do some new things, what do we say to a district that says, well, you guys just voted through a charter school for us, and now you're not going to help us fix the building? What's fair about that? Meanwhile, we've got schools online. Let's use over in Goshen County, for example. We've got a small school over there that's been waiting and going up the list, and now we're going to just chop it off and say, well, I'm sorry, you're going to have to float a bond issue. Folks, final thought. These $4 billion that we've helped our districts, 48 districts out there, that's a taxation that our people didn't have to pay. With all that we're doing for our local governments in this session, all we're doing, if we vote for this resolution, we're saying we're going to send that tax home to you too. On and against the resolution. Thank you.
Thank you. Senator Schuler.
Thank you, Mr. President. I think the good senator from Natrona took a lot of the thoughts that I was going to talk about, but and again, I give props to the good tall senator from Natrona County. I think we know that this is looming, that the coal lease bonus is gone. We've got to do something. I'm not sure, as the good senator from Albany County said, I don't know if this is the right venue or the right time. And the timing is really the thing that I'm most concerned with. We have recalibration coming. We have a lawsuit right now with their education. We have property taxes. We don't know how that's going to affect everything exactly. There's a lot of what ifs out there. And so with me, it's more of a timing issue than anything else. I think that people in Wyoming will try to support education, no matter how tough it gets, to a point. I think they believe in education. I think they'll try to support it, even if this resolution goes through. But I don't know. Once they start looking at, well, my district, what's this going to do to my district? Just as the good senator mentioned, if you've been on the list waiting for a new school, and now all of a sudden you've got to do a bond issue, and you're in a place where those haven't done well. I mean, you look in this county right here, they can't even pass a bond to get a rec center. So I think it's going to be a tough issue. I think there's some equity. Is there a better system out there? I think there might be, but I think the timing of this is just what bothers me the most. And I just think that if it goes through today, I don't know, if I was a betting person, I wouldn't bet that the people would vote for this when they start looking around at their own county. My county, like I said, we have some pretty nice buildings that are 40 and 50 years old. But if we wait another 10, 12 years and they're 50 and 60 years old and we need a bond, and I just don't know if we have that, what it takes to do that. So again, on and against the resolution.
Thank you. Senator Dockstetter, you're next.
Thank you, Mr. President. I represent two areas over there on the west side. One's north of the Big Canyon over there, the other south. One area has 111% property tax increase, the other 112%. And they're adjusting as best they can. And believe me, they're not appreciative, they're not looking past those new schools that they've had over there. They're very much appreciative of those. And we're still trying to get one project taken care of north of the canyon over there. And we find that we're having to shrink the size down because of inflation. There'll be a time maybe that we can do this, but I think one of the greatest things we can do as the state of Wyoming is build schools for our people. That's what makes us different in so many ways. We have a great education system. That was what kept me in my home area almost 4 decades ago. I was coming home to my wife and saying, look at these schools. Look at what's going on in these schools. This is where we got to raise our family. And I see it north of the canyon. I see it south of the canyon. I see it all across the state. We have solid schools. The least we can do is just continue to build these schools, set them up. We don't need to add this as one more expense during high inflation and during escalating uncontrolled property taxes. On and against this resolution.
Senator Scott, for your second time.
Mr. President, let me answer just a few things. First, the implication we weren't going to fix schools. Mr. President, this constitutional amendment does not change the major maintenance at all. That's a separate problem. I think we'll probably have to deal with it in recalibration, probably should, Mr. President, but it's a separate issue. Second, with regard to the taxes, we will, over the years, need some more schools. We will need to do that. Somebody's going to have to pay the taxes for that. And if we keep the current system, somebody's going to have to pay the taxes for that. Probably, in the first instance, by losing the homeowner's tax credit that we're in the process of giving this time. And then we'll see whose taxes are going to go up because of what we're doing. It isn't going to be free. I think the fairer system, Mr. President, is to go back to the local control where the people whose taxes are going to go up the most are going to vote for it or against it. Because that worked for 110 years. And the question is always going to be timing. And if you look at the chart that was passed out in Committee of the Whole, we had a big blip once the system we've got now got going. And everybody got the schools in the process. And then we had a trough where we didn't need to do as much. And now we're starting to see a blip again. So I will suggest to you, Mr. President, that the timing to fix it is now, because I think trying to fix it in the future is going to be a good deal harder. So, Mr. President, this is your chance to start controlling our expenses on and for the constitutional amendment.
All right, you ready for the question? Question being called. Senate Joint Resolution 6, having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Senate Joint Resolution number 6, roll call. Anderson? No. Barlow? No. Boner? Aye. Brennan? Aye. Case? No. Cooper? No. Crago? No. Crum? No. Dockstetter? No. Driscoll? Aye. French? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. Ayed. Aye. Jones? No. Kolb? Aye. Landon? No. Larson? Aye. McEwen? Aye. Nethercott? Aye. Olson? Aye. Pappas, excused. Pearson? Aye. Rothfuss? No. Salazar? Aye. Schuler? No. Scott? Aye. Smith? Aye. Steinmetz? Aye. President Beitman?
Aye.
Aye. Closing vote. Closing. Vote closed. Senate Joint Resolution number 6, 18 aye, 12 no, 1 excused.
Senate Joint Resolution 6, having failed to receive the affirmative vote of 2/3 of the members elected to the Senate, Senate Joint Resolution 6 has failed to pass the Senate. Well, Madam Majority Floor Leader, that clears the desk.
Mr. President, I move that the Senate resolve itself into committee of the whole.
You have heard the motion. All those in favor say aye. Aye. Opposed, no. Senator Rothfuss, come on down.
Committee of the Whole will please come to order. First Senate file for your consideration is Senate File 187. Will the reading clerk please read the Senate file?
Senate File 187, Public Employee Retirement Plan Contributions, sponsored by Senator Hicks, an act relating to public employee retirement. It was referred to Committee Number 2, which returned a committee recommendation that it do pass. Ayes, Senators Driscoll, Salazar, and Smith. No, Senators Guru and Larson. Senator Larson, Chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Salazar?
Mr. Chairman, I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 187 do pass. And to explain the bill will be good Senator Hicks.
Thank you, Senator Salazar. Senator Hicks. Oops, I clicked Pappas, sorry. Senator Hicks.
Mr. Chairman, you do have a handout on your table here that I will reference just for your edification as I talk about. First, just a little history. This was a bill that came out of the Joint Appropriations Interim Committee a year ago. What the bill does is it raises the employer, this is for the big retirement plan, raises the employer's contribution and the employee's contribution, the employer's contribution by 0.25%. And the intent there was to jumpstart the other actuarially sound retirement bill passed out of the legislature last year. It was to get this thing moving in a more actuarially sound direction. What the bill does is just go back in and picks up the second half. The governor did veto this bill last year. With that, it's good policy. I thought it was a good bill last year that the Joint Appropriations Committee worked on during the interim and brought that out. And so what the bill does is it goes in and it takes the second half of the biennium, It causes an increase by the employer and the employee by 0.25% increase. So, members of the body, I pulled the GASB report out on our retirement system, and I alluded to it a little bit earlier. So keep in mind that pension plan is a liability of the legislative body. And if you look at that based on the latest information, that plan is 78% actuarially sound. And keep in mind, we talk about 78%. That's projected in 30 years that will be at 100. So over 30 years, even if you go into the account report and the audit on there, they say, 30 years is a long time to project anything. We've had a good investment year. These things can move up and down several percent a year just based on investment returns. Keep in mind, the Wyoming retirement system, 70% of all disbursements are investment earnings. So the biggest thing that affects the long-term actuarially soundness is investment returns. The model we use now uses about a 6.7% return. But all the bill does is going in for this year would require the employer and the employee to kick an extra 0.25% in prior to the new system come in. It doesn't change whether that 30-year actuarially thing is going to change that much. What it does, though, is start to build a graduate increase for those employees to maintain that actuarially soundness. So keep in mind, if you go back to the Government Accounting Standards Board report on this, you, members of the legislature, have a $2.3 billion liability. Let me repeat that. This plan has a current liability of $2.3 billion. And so often you get, over the year, you'll run into people, all the school teachers, all state employees, a lot of local, we want a COLA. We need a COLA. We haven't had a COLA in a long, long time. Folks, you can't do COLAs when you're at 78% of actuarially soundness. I thought it was good public policy last year to jumpstart this and start moving this a little quicker in that direction to be actuarially sound. It's just a policy issue. It does have a fiscal note. So if we were inclined to do this, members of the legislature, it would be $1.74 million out of the general fund. That's our employer contribution. And then $3.4 million out of the school foundation. Keep in mind, those schools are the largest participant in this large retirement program. Stand for any questions. Clearly a policy issue as to whether you want to start this process a year earlier or let it kick in next year all on its own. So it just gets us there a little quicker as far as being actuarially sound. Stand for any questions.
Thank you, Senator Hicks. Discussion on Senate File 187, Public Employee Retirement Plan Contributions. Any discussion, questions? Seeing none, all those in favor of Senator Salazar's motion that when the Committee of the Whole rises to report, do so with a favorable recommendation on Senate File 187, please say aye. Aye. Those opposed, no. No. Senate File 187 has passed the Committee of the Whole. The next Senate file for your consideration is Senate File 166. Will the reading clerk please read the Senate file?
Senate File 166, Political Party Formation Amendments, an act relating to elections, sponsored by Senator Pearson, was referred to Committee Number 7, which turned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Landon, and Steinmetz. Excused, Senator Dockstader. Senator Case, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Case?
Mr. Chairman, I move that when the Committee of the Whole rises to report, that it do so with a due pass recommendation on Senate File 166, Political Party Formation Amendments. And for an explanation of the bill, I ask you to call on Senator Pearson.
Thank you, Senator Case. Senator Pearson.
Thank you, Mr. Chairman. So, members of the body, this is just another amendment that the clerks were asking for relating to party formations, political party formation amendments. As you can see, all this is doing is moving the dates up a month in order to form a political party, and so it's moving Says any group of persons desiring to form a new political party within the state shall file a petition with the Secretary of State not later than May 1st now instead of June 1st. And then in any general election year in which the party seeks to qualify for a general election ballot. The petition shall be circulated no earlier than March 1st of the year preceding the general election. So if you all remember, there's been some changes to our elections where in order to change a political party, you had to do that by, I think it was May 15th, if you wanted to change your political party. And so this is just giving the clerks more time for that, and also giving anyone that wants to change their political party a 15-day window. So, because if it was June 1st, obviously they wouldn't have time to register for that other political party. So, did that make sense? Yes? No?
I think so, Senator.
Okay, thank you.
Thank you, Senator Pearson. Any questions or discussion on Senate File 166, political party formation amendments? Seeing none, question's been called. All those in favor of Senator Case's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 166, please say aye. Those opposed, no. Senate File 166 has passed the Committee of the Whole. Madam Majority Floor Leader.
Mr. Chairman, thank you. I move that the Committee of the Whole beg leave to rise and sit again.
You have heard the motion. All in favor say aye. That one person said aye. Does anyone say no? Sketchy, but we're going to go with motion carried. All right.
Messages from the House.
From the House of Representatives, Mr. President, the following messages are dated February 10, 2025. The following bills passed the House on third reading. Message number 216, House Bill number 234, Second Amendment Financial Privacy Act Amendments, ayes 56, noes 3, excused 3. Message number 217, House Bill number 264, Central Bank Digital Currencies Prohibitions, ayes 50, noes 9, excused 3. Message number 219, House Bill number 311, Exemption for Transported Fuel and Power Sales Amendments, ayes 55, noes 4, excused 3. Mr. President, the following bills passed the House on third reading in an amended form. Message number 214, House Bill number 81, Regulatory Reduction, Mortgage Loan Originator Licensing, ayes 59, excused 3. Message number 215, House Bill number 219, County and Municipal Roads on State Lands Easements Granted, ayes 58, noes 1, excused 3. Message number 218, House Bill number 299, Online Sports Wagering Amendments, ayes 45, noes 14, excused 3. Message number 220, House Bill number 323, SNAP Benefits Waiver Request, ayes 48, noes 11, excused 3. Sincerely, Katie Talbot, House Chief Clerk.
Thank you, Randy. Madam Majority Floor Leader, how about a break?
Mr. President, I move that we stand recessed until 2:50 p.m., 2:50 p.m.
You've heard the motion. All those in favor say aye. Aye. All those opposed, no. Senate will stand at recess until 2:50 p.m. We have a quorum. All right. Senate will come back to order. Before we go back to committee of the whole, I'm to remind you, there is a joint resolution on the desk, or not a joint resolution, yeah, a resolution on the desk for supporting Taiwan. While we're in committee of the whole, if you could come up and sign that if you wish. It's up here on the front desk. And with that, Madam Majority Floor Leader, we're at that order of business for bills on general file.
Mr. President, I move that the Senate resolve itself into committee of the whole.
You've heard the motion. All in favor say aye. Those opposed, no. Senator Rothfuss.
Okay, we're back. And we're back. And we're back. Committee of the whole will come back to order. Next bill for consideration, Senate File 156. Will the reading clerk please read the Senate file?
Senate File 156, Expenditure of State Funds on K-12 Public Schools, an act relating to K-12 public school facilities, sponsored by Senator Driscoll. It was referred to Committee Number 4, which returned to committee recommendation that it do pass amended. Ayes Senators Brennan, Olson, and Scott. No Senators Rothfuss and Schuler. Senator Schuler, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator Schuler.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 156 do pass. There is a standing committee amendment. You can have that read in.
Senate File 156, Standing Committee Amendment Number 1, page 5 after line 21, insert.
Thank you, and I'll let the good senator from Kirk County explain the amendment in the bill.
Thank you, Senator Schuler. Senator Driscoll, over to you.
Mr. Chairman, thank you. I move Standing Committee Amendment Number 1 to Senate File 156. Folks, I'm going to start with the amendment because it kind of helps out on the bill as far as tracking it in a little better. This amendment, so what this does, our major maintenance money, folks, has basically flex money in it in our schools right now when we do major maintenance. And kind of has come out, a lot of that money doesn't really get spent on major maintenance. We get 10% that they allow to do other things, part of it enhancements, part of it other. I found out the issue is incredibly complicated as I've got into it, probably a lot more than I thought. But here's the amendment on it, and it says, nothing in this act shall prevent a school district from expending funds generated by the foundation program that are transferred to a special reserve fund to complete a project that is in progress. A project shall be deemed in progress only if expenditures for planning, design, or any phase of construction were made prior to the effective date of this act. The school district shall report to the foundation program amounts expended on a project pursuant to this section to the state superintendent of public instruction, and the state construction funds are expended. The Wyoming Department of Education, the State Construction Department shall report to the Joint Education Interim Committee, the Select Committee on School Facilities, and the Joint Appropriations Committee not later than September 1 of each year, in what report on these funds is provided to the State Superintendent, Public Instruction, the State Construction Department. That lays right in, and it almost explains what the bill does. They've flexed 10% of those funds over the years. A lot of them have things, and it goes back to exactly what my intent of the bill is. When you talk about it in the amendment, it was brought kind of by them. It talks about construction in it. And basically, what my intent of this bill is, major maintenance money should be spent on major maintenance. All the time in the schools, we give them money, and it doesn't go to exactly what we want. And this bill's making an attempt to go from this point forward to make sure that major maintenance money gets spent on major maintenance. So I'm going to leave the amendment kind of hanging open and go in just a little bit, and then I'll come back and actually ask for the vote on the amendment. So what this bill really does, it says, going forward, major maintenance is exactly that. The money will be spent on major maintenance. A big part of it now, folks, is spent, as you look around the room, probably all of us, in fact, I don't think there's a district out there that doesn't have enhancements in it. Some of those enhancements were wide hallways, they're over space. We talked about it earlier, the good fellow sitting in the chair from the Ivory Towers talked about it a little bit earlier, about the percentages that we kind of move on. I in no way want to impinge on any school that's over size-wise and is using major money to keep that up, nor for anybody that has done enhancements in, i.e. swimming pools, gymnasiums, whatever, in the past. I'm happy with that. But my personal belief is this. if you want to enhance your school, and I'm specifically talking about facilities of some kind, which is gymnasiums, different places, you know, a lot of times they'll give, like in our district, they'll give you a gymnasium that's not legal size, that's a lunchroom and an auditorium as well. They're pretty hard to use, but we've got a couple other gyms. We did not enhance ours, but a lot of them do. And then what happens is when we do these enhancements, they use local dollars to do them, and then they ask us to come back and pay the maintenance on them. And I don't think that's fair. If you want to do an enhancement, you want to build a swimming pool in your district, you want to build a new barn, you should have a sinking fund and you should take care of that for as long as it goes. This will be a bit of a referendum on that because that's where it's at. So with that, you've kind of heard what the bill does, and I would ask for your aye vote on the amendment.
Any discussion on Standing Committee Amendment number 1 to Senate File 156? Any discussion? Seeing none. All those in favor of Senator Driscoll's motion to adopt Standing Committee Amendment number 1 to Senate File 156, please say aye. Aye. Those opposed, no. Standing Committee Amendment number 1 to Senate File 156 has been adopted. We are back on the bill.
There's
Senator
another
Driscoll,
amendment.
do you want to do that one now? Let's have
I'm
it
going to
read in.
withdraw it.
You're going to withdraw it? Okay, let's have it read in.
Senate File 156, Committee of the Whole Amendment number 1, page 5 after line 21, insert.
Senator Driscoll asked that be withdrawn.
It is a carbon copy of the first one. It was just by error, so
Okay.
I asked for it to be withdrawn, please.
Without objection, Committee of the Whole Amendment number 1 to Senate File 156 has been withdrawn. Back on the bill.
With that, I've explained the bill fairly well. I will tell you that I'll be coming with a second reading amendment to allow them to put insurance premiums in it. That's one of the things that's come out. I also would ask for all the districts out there to get a hold of me and tell me where they need held harmless looking backwards on this, because there's no intent of mine to cause damage to districts that have past practices in place, things they're doing. I'm told by other members that statute basically says if that's the case, this bill's not needed. I guess I maybe put some in there that's put some good sideboards on to make dang sure that we're right. I'd stand for questions, ask for your favorable consideration.
Thank you, Senator Driscoll. Discussion on Senate File 156. Senator Landon.
Well, thank you, Mr. Chairman. Appreciate it, and really have appreciated the opportunity to visit with the good senator about this. And this is really just a policy call, and we can certainly do this by legislation through this body. Through the years, there has been some flex authority given to our districts out across. Some of that arrives to them in the ability to move their block grant around for a plethora of reasons, some of which could be exactly as the senator pointed out. It could be some enhancements, but bear in mind that the enhancements that we talk about aren't always something that's been built brand new. We had a school out on the reservation, for example, that had a beautiful gymnasium that they wanted to keep. But the square footage was a little bit more than what the state allows nowadays. So that becomes a little chunk of enhancement square footage, for example. That's just one example. There's hundreds of examples out across. What this does is not just sideboards, but it prohibits your local districts out there from moving any of these funds. Remember, on the major maintenance funding too, Mr. Chairman, we allow for a 10% to be set aside for, that allows those districts to use that major maintenance funding. All of that is cataloged, by the way, and the state agency tracks every bit of this. They've got a list and they know exactly, how these funds are being used. It's just a matter of whether we want to lock that down, put the handcuffs on a little bit and tell the district you're not going to be moving this money around. But bear in mind, that's how they are allowed in that block grant model. That also allows them, if they are fiscally responsible and they have a little bit left over, that's what allows them to put that in a reserve fund. Or they can call the state agency and say, we've needed that electrical panel in this room off of this wing for a long time. Can we utilize some of that funding and put it in there? So that's how that all takes place. And again, it's kind of a policy call. Thank you, Mr. Chairman.
Thank you, Senator Landon. Any further discussion? Senator Guru.
Thank you, Mr. Chairman. I guess I'm a little unclear and just want a little more discussion on this, on the major maintenance side. From talking to school districts around the state, including my own, I was under the impression that when you did enhancements, you were, and I've been to a couple of school facility meetings where the good, right chairman of that committee was pretty strict on saying, you do an upgrade, you do an enhancement, the major maintenance is on you. And we're gonna, and as we build, we're gonna catalog that and demand that you do it. So I worry too, and kind of building off the last speaker about prohibit, I don't know if it ties their hands, you know, just a little discussion about it. Are we tying the hands too much with this? Or I guess, Mr. Chairman, the only way I can explain it is I got a call one time on it from my other committee appropriations about a school district that was wasting money like you wouldn't believe. They bought a souped up car and they were running mail back and forth during the district. Well, so I made a couple of calls and checked into it, called the school district, and what had happened was they'd spec'd out a car in their budget, and the local dealer called and said, I got this car that somebody in the mines ordered, souped up car that was painted a weird color, and he said, he left, and I can't get rid of it. I'll give it to you. So that's how the school district was driving the souped up car. No backroom deal, no dirty deal, no waste, fraud, and abuse. Just a car dealer trying to get rid of something he couldn't sell and actually save the school district $14,000. So I guess my question is, when we prohibit, do we start violating the law of common sense? So just a little discussion on that, I'd appreciate it.
Thank you, Senator Guru. Senator Cooper?
Thank you, Mr. Chairman. In these smaller districts, we're running into a lot of issues with the enhancements. What's considered an enhancement now in some of these schools is little things that most of you take for granted, like a CTE building. In two of my districts, the CTE buildings are the enhancement. In another district, they heat the gym with this 10% money. So when we restrict the way we can spend these funds, we really hurt these little districts. It just cripples them. It's not so much on a bigger district. You maybe got a little more money you can move around, but when we're talking about a few dollars here and a few dollars there, it's critical on these little districts that we'd be able to move that money around where we need it. Thank you.
Thank you, Senator Cooper. Any further discussion on Senate File 156, expenditure of state funds on K-12 public schools? Before we go back to the sponsor, don't see anyone rising right now. Senator Driscoll, back to you.
Thank you, Mr. Chairman. I think the argument was made exactly right by my great friend from Casper College. I guess that's proper too. So, you know, it's a policy decision, and mine's been this. We've allowed great latitude to the schools all the way around. And every time I get into one of these, I find where the good policy flexes kind of get pushed hard on the edges. And when I kick back a little, rather than getting help on it, I get told you can't do this. We don't have any new cars in what I'm talking about here. It's a policy decision. Do you want your major maintenance money spent on major maintenance? Or do you want it to build, you know, and I hate to say that, CTE buildings, barns for livestock in my county keep up. I agree with those. I agree with them fully, and I represent a lot of small districts. They're not very happy with this. But do we want, going down the road, to make sure that major maintenance, these are state dollars that are spent to keep up our buildings. Do you want them to buy new playground equipment? Do you want them to buy stuff that is outside of what you would consider on an operation like mine, major maintenance? My operation, I consider major maintenance, HVAC and major repairs, maybe that electric panel that was talked about, that's maintenance. But when you start buying new stuff, it's not maintenance. And when you start asking the state to pay for enhancements that you built that made your school better or different than another school, and you want the state to pay for that part of the enhancement going forward, That's not what the courts ask us to do when they ask for equality in our schools. That's what the Supreme Court cases all were, equality. So every time you create something that another district doesn't have, what you're gonna get ultimately, and we're starting to hear it already, is, well, 18 school districts have a swimming pool for enhancements, and you're paying for the upkeep on it. Why doesn't my district have one? I think these are legitimate arguments. Let's set our policy, let's set it hard. If we want flex money, let's take 10% out of major maintenance and let's give it to them for actual flex money so that they don't have to kind of make the edges fudgy on the thing. Let's make it where it's a bright line and go ahead and give them the other money. We can easily take 10% right now out of major maintenance and say you can put it in a reserve account. Last part, I will be bringing an amendment to allow insurance to go in there, because that's absolutely a part of major maintenance, is to having a policy in place to make sure if you have a disaster, you're covered. I'd ask for your favorable consideration.
Thank you, Senator Driscoll. Back to you, Senator Landon.
Yeah, so, Mr. Chairman, thank you. And I do want to salute the senator for bringing this to us, because, you know, periodically, I think it is good to take a look at how things are going out across and what we're up to. These are a couple of issues that would be great topics for the select committee, for example. Or we can, you know, we can adopt this legislation and send it through. That's a good conversation to have as well. But really, just to kind of emphasize a couple of points, one of the things we do on that major maintenance funding is we do give some flex to the districts, and it is 10% for safety, security, and the ability to maybe fund what this extra square footage. You remember earlier in the session, we talked about, do we go ahead and broaden what we provide back to the districts, those who have that extra square footage? Well, we limit the square footage that we pay them for. So that enhancement has to come out of somewhere. And that's why we provide a little bit of flex, Mr. Chairman. And I'm looking at you because you have served on that select committee a long time, and we've had these debates a lot. And so part of that flex is because we don't fund all of those extra square footages out there. So I hope that helps a little bit to understand. Thank you, Mr. Chairman.
Absolutely. Thank you, Senator Landon. Any further discussion? Seeing none, all those in favor of Senator Schuler's motion that when the committee of the whole rises to report, it do so with a favorable recommendation on Senate File 156, please say aye. Those opposed, no. Chair is in doubt. All those in favor, please stand. Those opposed, please stand. 14 ayes. Yep, it's a mandate. 1413. By your vote, Senate File 156 has passed the Committee of the Whole. Next file for your consideration is Senate File 190. Will the reading clerk please read the Senate file?
Senate File 190, Election Transparency, an act relating to elections sponsored by Senator Beitman. It was referred to Committee Number 7, which returned a committee recommendation that it do pass amended. Ayes Senators Boner, Case, Dockstader, Landon, and Steinmetz. Senator Case, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Case?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, that it do so with a do pass recommendation on Senate File 190, Election Transparency. Mr. Chairman, there is a standing committee amendment. I'd ask that it be read in.
Senate File 190, Standing Committee Amendment Number 1, page 1, line 10, delete.
Mr. Chairman, I would move the standing committee amendment, and I'd like to yield to the bill's sponsor, and perhaps he can take us through the bill, and if he wants to handle the standing committee amendment, that's fine, or if he wants to toss that back to me, I'd be happy to do so. Senator Beitman.
Thank you, Senator Case. Senator Beitman, over to you, Mr. President.
Hey, thank you, Mr. Chairman. I bring you Senate File 190, Election Transparency. Hopefully, you all will get behind this good little bill. Obviously, there's a lot of election integrity bills floating around out there, but I think this one is the most concise, gets straight to the issue that everybody cares about, and is probably the least controversial out of all of them. So what this bill does, it ensures that elections in Wyoming are secure and verifiable by requiring paper ballots as the default method. Paper ballots provide a tangible, auditable record of every vote cast, reducing the risk of electronic manipulations. That's the first thing it does. Number two, enhancing transparency in vote counting. This bill mandates automatic tabulation of paper ballots while also requiring hand recounts in certain close races. So this is where the hand counting comes in. Close elections, particularly those, in this case of this bill, within a 2% margin, current law is 1%, this moves it up to 2%, will be hand recounted to ensure accuracy and restore public confidence in the electoral process. And the third thing it does, Mr. Chairman, it ensures only eligible citizens vote. This is the U.S. citizenship factor. The bill requires proof of U.S. citizenship for voter registration, preventing non-citizens from voting. Acceptable documentation includes passports, birth certificates, certificates of naturalization, real ID, compliant driver's license. And this is for voter registration only, right? And then we go, the other thing this bill does, I've heard from folks across the state that think our early voting is way too long. I know as candidates, we all find that particularly annoying when we go door to door a month before the election and they've already voted and you don't even have a mailer out yet or something like that. It's like they're voting just on the first day, I guess. So this would shrink it down to 2 weeks before. Still gives people plenty of opportunity to get out and vote early if they want to, if they know they're going to be out of town, but they want to do an absentee ballot, they like to vote in person, they can still go down to the courthouse and vote 2 weeks early. Just a common sense approach there. The standing committee amendment will take that out, but we'll talk about that later. It provides accessibility for disabled voters. Paper ballots will be the default, but the bill also ensures that electronic ballot marking devices will still be available for voters with disabilities. These devices will comply with all federal laws while preserving the security of paper-based voting. So as long as the machine spits out a paper ballot, so we have something to audit, we're good to go. So the voter can see the paper ballot, see how they voted, and they put it in a box, and that we have a paper trail, good to go. This thing establishes a dedicated election recount fund. So in the case there are more hand counted ballots, by increasing the threshold from 1% to 2%, Mr. Chairman, it has an appropriation of $200,000 to an account to pay for those in additional recounts if they're needed. And Mr. Chairman, by implementing these measures, Wyoming will increase voter confidence and safeguard election results against potential errors or fraud. These reforms align with best practices for election security while maintaining efficiency in vote counting and reporting. And that's what I'm aiming for, Mr. Chairman. Keep the system we've got, make a few tweaks around the edges, enhance what we've got, make sure we've got paper ballots, make sure we've got an opportunity for hand counts if needed. Allow exceptions for folks that need to use those hand marking devices to print out paper ballots for them. Mr. Chairman, I think this is a common sense bill. And for the explanation of the standing committee amendment, I would love to toss it back to the chairman of the committee, and he can walk you through what the good committee came up with.
Let's do that. Thank you, Mr. President. Senator Case.
Thank you very much, Mr. Chairman. Ladies and gentlemen, the standing committee amendment does several things. But one of the things it does is it deletes the appropriations. And to tell you the truth, that's not a policy decision. It was a Friday afternoon decision that if we had to re-refer the bill to appropriations, it might not get out in time. So, if you, appropriations, you can see it in the bill title, and you can see it on the last page, section 4, page 26. It's $200,000. And so we didn't take a policy position on appropriations. We merely deleted it so that this bill wouldn't have to go to appropriations on Friday. So I want you to understand that. So if you want to reinstall the appropriations, you could, I'll help you to divide this amendment to do that. You could defeat that portion of this amendment. And that would, in essence, be lines 1 and 2, and lines 20, 21, and 22. Those deal with the appropriation. The rest of the bill, Mr. Chairman, you know, I think we thought this was a really common sense election reform bill that went a long ways towards being more sane than perhaps the other things that we've heard about in this legislature. But there is a wrinkle. There's a wrinkle in the fact that this is talking about hand counting ballots by and large, but there is an exception. One county in Wyoming uses electronic touchscreen machines. We learned in the committee that those touchscreen machines produce a paper ballot. In a lot of ways, that paper ballot is indistinguishable from paper ballots that are used through all the rest of our counties where you hand mark them. It's really, the difference is that they're marked with a machine, not by hand. The testimony in committee was that those machines are preferred in that county. They like them. It happens to be one of our largest counties, maybe our largest county, and so they find it more efficient. And it's very, very expensive to move away from that setup that they've spent a long time developing. It's also important to know that those ballots that are produced by the electronic touchscreen machine are available to the voter to inspect. So they can see the paper ballot, and the paper ballot can go through the reader. The paper ballot can be retained for recount purposes, and the paper ballots can be counted by hand, Mr. Chairman. So part of this is to allow for those machines to continue. And the bill had provided that those could be used by people with disabilities. And it is true that many people with disabilities do use those machines and find them better. But what the Standing Committee amendment is also allows those machines to be used by any elector that chooses to do so. And we did that after being persuaded that they produce a paper ballot, in a lot of ways indistinguishable from the other paper ballots around the state. So that's really the parts of lines 3 through 13 of the bill, Mr. Chairman. It kind of, and you can see on page 3, it gets rid of the being only for disabilities, and it's going to say, as used in this section, electronic ballot marking device means any electronic device, da, 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 da. So it's available for any voter who requests it. And let me just make sure I'm not missing anything. And Mr. Chairman, when we get to page 11, I was wrong that the Disabilities Act and the electronic machines are lines 3 through 10. Page 12 is a different, line 12 is a different issue. It's page 11, lines 16 and 18. What the bill does, the law, if you look at your bill on page 11, this has to do when absentee ballot polling places can be open. And there's a long sentence, and I'm going to try to just cut into the middle of it. Shall be open the same hours as the courthouse on normal business days during the time period the current law is allowed for absentee voting. The bill had proposed to strike allowed for absentee voting and say beginning 14 days before the date of the election and ending at the close of business on the day before the election. The committee wanted to return to the current law, which is a little bit longer, but it better matches our other timeframes in the law. And so this would not allow for that 14-day period. It would be as wide as the absentee voting period, which is, I believe, 45 days. So, you know, that's what the Standing Committee amendment did. There was a small error in the Standing Committee amendment, and there will be a Committee of the Whole amendment that deals with that error. In this same section, there are two types of these places you can go before the election. One's at the courthouse, and the other is called a satellite facility. And in our amendment, we only dealt with one of the places. And if you turn the page, you'll see at the top of page 12, we didn't deal with that one, and that's the other deal. So there's committee of the whole amendment to deal with that. Okay, then page 18, line 8. See here. The existing language, or the proposed language said it under E, the county clerk shall have the discretion to recount any ballot proposition either by precinct, election district, or precinct. Mr. Chairman, we didn't think it should be limited to ballot propositions. We think that if you think about it, you want it to be for anything that you're voting for. So we say to recount any ballot proposition or race. We inserted the words or race. And then on page 23, line 12, this is how you can use funds to provide for the recount. And it lists what the recount funds can be used for, 23, line 12. Line 12 says reasonable expenses are limited to wages per diem of $25 a day and mileage for election judges and county clerk staff. We added facility fee rental to that list of funds that it could be used for, because we were persuaded by our good friends, the clerks that run Wyoming's elections, that sometimes they might have to, if they're doing a hand count, they might have to get a big place. It turns out the stadium in Arizona isn't available free of charge. So actually, probably it'd be the fairgrounds in most counties, but there might be a fee for that. So, or there might be a fee for a different place that they use. And that's what that does. We already talked about the appropriation. That's the standing committee amendment. I'll help people divide it if they wish to, but I hope you'll support it.
Thank you, Senator Case. Go ahead, Senator Guru. Over to you. We're on standing committee amendment number 1.
Thank you, Mr. Chairman. I would like to divide the amendment, and I would love the help of the good bringer of the amendment. The appropriation, it would be first, so that would be, you say lines just 1 through, actually lines 1 and 2 there, lines 1 through 10, is that correct?
That's part of it.
And then the other part of, the other part would be the language about the touch screen voting machine that prints out the paper ballot. How would you divide that out with, did we say lines 3 through, well, no, I'll let you do it. I won't even try.
Let's defer to Senator Case to break it out if we're asking for a division. Senator Case, provide some recommendation.
I can help. I need a mic, Mr. Chairman.
My apologies. Senator Case, you've got a mic.
Okay, so the appropriations is lines 1 and 2 and 20, 21, and 22. Line 1 and 2 of the amendment is just the title. And then if you go to I think it's section 4 on page 26, it's lines 20, 21, and 22, which actually, so that's the appropriation issue. That is, I think, divisible, Mr. Chairman. And then the issues about the touch screen, I think that would be lines 3 through lines 11. And let me check the bill again, Mr. Chairman. Yes, so page 2, line 3 says page 2, line 16. That's the first with respect to the touch screen. There's an amendment on page 3, line 2, where there's a deletion. It continues lines 4 through 6. Then on page 3, line 8, there's a renumbering that occurs, and that is the entirety of the touch screen issue. So of the amendment, lines 3 through 11, Mr. Chairman.
Thank you. And then we have the balance would be 12 through 19. We could call that Division 3 for now, unless there's a desire to have the further division into 2 pieces.
Correct, Mr. Chairman. And just lines 12 through 19 deal with the 14 days and go and restore it to the 45 days. That's what that division, if you call it 3, would do, sir. And I think that takes care of everything.
All right, I find it divisible. So to reiterate, Division 1, lines 1 and 2, and lines 20 through 22.
Correct?
Division 2, lines 3 through 11.
Correct.
And Division 3, lines 12 through 19.
Also correct.
And we actually have an extraneous lines 23 and 24. Those actually would go with, they would go with Division 1, I believe. Yeah. So we've isolated those, but those need to be part of Division 1. So my apologies. Reiterating Division 1, lines 1 and 2, and lines 20 through 24. Division 1 is lines 1 and 2 and lines 20 through 24. Division 2, lines 3 through 11. Division 3, lines 12 through 19. Any concerns, any points of order on that? Seeing none, back to Senator Grew.
So just a question to the dividers, or folks helping me divide this out. And I am, but I just want to make sure I'm doing it the way we want to do it right. So we want to say the Division 1 is about the appropriation.
Correct.
Division 2 is about the touchscreen.
Correct.
And Division 3 is about the time, the 45 days to 14.
Correct.
Okay, thank you. Oh, point of order.
On the point of order, Senator Beitman. Mr. President.
Yeah, not to be nitpicky about the third division, but it also includes the facility fee rental language in there. So that takes in, so it lumps in the 14-day deletion and the facility rental. So if you only cared about the 14-day part, you'd have to divide it further in order to get that fourth division in there.
And
Not making the motion, I'm just pointing it out.
excellent point, Mr. President, and we certainly can do that. Let's do it. I hear, let's do it. All right. Senator Case.
The gentleman is absolutely correct. So you need a further division. You could call 3 lines 12 and 13, and you could call, and that would deal with the 14 days. And then you could have lines 14 through 19 would be a new Division 4. Stand corrected.
All right, Senator Case, so we will go with that division. That is in order. So again, to go over it one more time, Division 1 will be lines 1 and 2, and lines 20 through 24, that deals with the appropriation. Division 2 will be lines 3 through 11, that deals with the touchscreen. Division 3 will be lines 12 and 13, that is the 14 to 45 day. And Division 4, lines 14 through 19, deals with the facility and the proposition. All right. Well, that was fairly straightforward. We're good to go. With that, Senator Grew, would you like to speak on any of those divisions?
I think it's my call on the order of the division, so I'd like to
Which one you want to start with?
I would like to start with Division 1.
Division 1. We are on Division 1. Senator Grew, for your first time on Division 1.
Thanks. Point of order? No. Okay. Division 1, on and for Division 1, I apologize, I guess, as a member of Appropriations, we were whipsawing, and I know I look back at the good chairman, we were certainly riding ourselves hard to make sure that we got all of our referrals done. And so if we didn't get to this one, and I think we need to deal with the appropriation, if nothing else, to help help the county clerks and help the folks that are going to be, that this mandate is going to fall to. So I would speak on and for Division 1.
I think you would like to be on and against Division 1.
Oh, I'm sorry, on and against Division 1 to delete it. I'm sorry. I apologize.
Based on the prior
Division
rhetoric.
1.
Yes.
Thank you.
That's my expectation. Thank you, Senator Grew. We're on Division 1. Senator Hicks. Yep, there you go.
A little information. So how did we come up with $200,000? Is that based on what? Information went into the discussion that if we have to go back through one of these recounts, and what all would be covered associated with that? Are we paying election judges, the county? So two questions in that. So how do we come up with that number, and who would actually receive those funds? associated with any paper recounts.
Thank you, Senator Hicks. Any additional discussion on Division 1, the appropriation? Mr. Vice President.
Thank you, Mr. Chairman. Yeah, I'm with the good minority leader. This bill requires that appropriation. Had we heard it, I think there would have been probably widespread support in the Appropriations Committee. So I stand against the amendment.
Thank you, Mr. Vice President. Any further discussion on the first division? Senator Case.
Mr. Chairman, this bill wasn't reported in until Friday afternoon. It was not going to be, because the amendment was a little bit more complicated, it was not going to be possible to have it re-referred to the Appropriations Committee.
Thank you, Senator Case. Anyone have an answer to good Senator Hicks' question? Senator Guru? Maybe not.
Mr. Chairman, I don't know, and maybe that's something we could bring on second, but definitely vote no on this First Amendment so we can get the appropriation ball rolling on this to make sure we can.
Thank you, Senator Guru. Anything further before the vote? Seeing none, all those in favor of Senator Case's motion to adopt Division 1 of Standing Committee Amendment Number 1 to Senate File 190, say aye. Aye. Those opposed, no. Division 1 to Standing Committee Amendment Number 1 to Senate File 190 has failed to be adopted. Division 2. Anyone like to speak to Division 2? Senator Case, I see you up.
I think Gru originally called it.
Sure. Senator Gru.
I guess my question on Division 2, I think I'm for, but a question before, I just was trying to understand, if you have a touchscreen machine that prints out a paper ballot that is acceptable to the committee and the bringer of the amendment, why wouldn't we just go with those machines across all the counties, and then you could tabulate electronically and then have a paper backup for every single ballot that was there if you needed it? Why wouldn't that be was there discussion on that, or I just question on that division?
Thank you, Senator Gru. Anyone like to address that? Senator Case?
So, Mr. Chairman, let's be careful here. These machines just produce the ballot. They don't count the ballot. They're not tabulating. They're not connected to the internet. Just a person can use the machine on a screen. They see something that looks like the ballot, and they mark it, and then it asks if it's okay. The nice thing about these machines is they cause you to not have any overvotes, all right? That's a great thing, because they actually stop the voter from, they say you pick too many, this race calls for 3, and so you can't mark 4. Now, when you think about that, that's going to save, that's a good thing, because that means those ballots don't have overvotes. And if they don't have overvotes, then when we get to the recount, when you're looking at a stack of paper ballots, you can't count a race that has an overvote in a paper ballot world where they've marked it by hand. You just got to set it aside, because you cannot tell. So that's a good thing about these machines. But they are not tabulators. They only mark the ballot. The existing law, or the bill, the new language of the bill, page 2, talks about paper ballots are required, but then there's an exception. It says subsection A of this section shall not prohibit any county clerk from providing electronic ballot marking devices for use by persons with disabilities, period. The county that we were talking about earlier uses them for everybody. And when we heard how they work and what they do, and they just produce a paper ballot, we decided that was okay. So we needed to change the language that says persons with disabilities to something broader. And we came up with persons with disabilities, delete persons with disabilities, electors who choose to use them. Maybe that's not the best language. Maybe it's going to have to be at the clerk's choice. But why don't we use these all around the state, Mr. Chairman? These things aren't cheap. Each system has its pluses and minuses. They use and like this system in the one biggest county in the Wyoming. They use other systems. Everybody else uses a different system starts with you filling out a paper ballot. But we were persuaded that the end result is the same, and we don't want to restrict that big county from using them just for people with disabilities. He's back on his feet.
Thank you, Senator Case. Let's go to Senator Kolb.
Yeah, thank you, Mr. Chairman. These machines are more and more sounding like a coaching machine, not an exact duplicate machine of what you're pressing to make a paper ballot. They're in fact guiding you. I mean, if that's what we want to do, call it what it is. It's not a machine that marks the ballot as you did. Apparently not. It's just testifying to the fact that they coach you. I think that's a little bit of a different slope here. I think if folks want to have a machine, say they have an issue about filling out the little circles on the paper ballot, I understand that. But a machine that actually coaches you? Really? I mean, I have some severe reservations about this, and I thank God we don't use these in my county. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Madam Majority Floor Leader.
Thank you, Mr. Chairman. The machines don't coach. Stop. It's just an electronic screen with a ballot with a line across it. Everybody surrounding you in this room votes that way. Let's not go down a rabbit trail of nonsense. It's just an electronic screen that you tap it and it goes across, just like on the paper ballot. And then you said, are you finished? Do you want to go back? Yes. Print the ballot. Print your ballot. And then you can check it and there's your paper ballot. You can verify whether or not the electronic device did mischief. You can see it in paper and you can hold it right in front of you and you can drop it off. There is no coaching. There's a paper ballot that verifies it. Everyone, deep breath. Laramie County does the elections best.
Thank you, Senator Nethercott. Mr. President.
Thank you, Mr. Chairman. On and for Division 2. This is a friendly amendment to the bill. It's a good carve out for the one county that needs it. They still are within the spirit of the bill, which is paper ballots that are, you have a paper trail, you can look at your ballot before you submit it to make sure it's accurate, and we have an auditable process. So on and for the division.
Thank you, Mr. President. Senator Grew.
Thank you, Mr. Chairman. Yeah, I too, now that I got the explanation from the good bringer of the amendment about what the machine does and how it does it, I see now that I'm still on and for the amendment. I think it's a good system. I can also see why. Maybe someday every county will have them if this bill passes and they end up going that way, but that's up to them. But I understand it now, and I promise that I was not coached to say that by anyone, including the majority floor leader. So thank you, Mr. Chairman.
There was no coaching.
No coaching.
Thank you, Senator Grew. Anyone else like to speak on this second division? Seeing none, all those in favor of Senator Case's motion to adopt Division Number 2 to Standing Committee Amendment Number 1 to Senate File 190, please say aye. Those opposed, no. Division Number 2 to Standing Committee Amendment Number 1 to Senate File 190 has been adopted. We are now on Division Number 3, which is the 14 to 45 day discussion. Would anyone like to rise to that, Mr. President?
Thank you. I'll be on and against this one. I think I'll stick to my guns on the 14 days. I think 45 days is a long time. And like I mentioned, if you're out campaigning, going door to door, and it's early summer and the primary election just started and people have already voted, it's kind of, you're like, what am I doing here? Why do I even have to campaign? Because they obviously don't know what I stand for, what my opponent stands for. They just voted already. So let's shorten it down. I would love election day, but election 2 weeks would be better than election month and a half. So let's stick to 14 days.
Thank you, Mr. President. Further discussion. Senator Scott.
Mr. Chairman, my instinct is to support this amendment with the longer period. And I would like to know if there's something wrong with my reasoning here. I represent a district that has a lot of people that work in the oil patch. And they're often, Mr. Chairman, having to be away from home for more extended periods of time. And I'm afraid that if we cut the time down to 2 weeks, there won't be a time when they're able to get the voting done, and we'll disenfranchise some people that with the longer the 45-day period, Mr. Chairman, would be able to vote. So am I missing something in the way this works? If so, let me know, please.
Thank you, Senator Scott. Senator Landon.
Thank you, Mr. Chairman. And no, the good senator from around the mountain is not missing anything. That's exactly the testimony that we received. It really didn't have, we totally got where the sponsor was coming from. I had a good discussion in committee, but it was all based on, there are some locations, including my community, where this early voting at the courthouse is hugely popular. Maybe 1 out of every 2 voters do it that way. And the concern of some of our clerks was, if you compress this down, you're gonna have lines down the block and around the corner trying to get in to get the vote done. So that was the reason that we suggested in this standing committee amendment that we take that language back to 45 days. So.
Thank you, Senator Landon. Mr. President?
Yeah, on that, what we're missing is this still allows for absentee ballots. So if you do work in the said oil field, and you know you're not gonna be around, you can still request an absentee ballot. This is for in-person early voting at the courthouse or a satellite location. Yes, it's popular, but this is a policy choice, and I didn't think that county clerks should be making policy choices. I think we should be making policy choices. If it's popular, it's popular. This division will pass, and if it's not, then I think, if we want to shrink it down to 2 weeks, that's our prerogative. So I would support defeating this division. Thank you.
Thank you, Mr. President. Senator Grew.
And thank you, Mr. Chairman. On the floor, I think the election is about the voters. And I do appreciate the bringer of the bill. And I too, going door to door, it is tougher to say, yeah, I've already voted. Sometimes we think they're saying it because they just want you to shut the door. They want to go back to watching the ball game. But be that as it may, the voters, almost 50% of the voters in my district take advantage of this and liked the longer time and didn't like the shorter time frame that we had this year. They liked the 45 days. It's, whether it's just working, living, raising your kids, whatever, being able to stop in when they're picking up other paperwork or doing other work at the courthouse, to be able to slip in and get their vote taken and done, they like it. While it is harder on us candidates, I understand that, but this is about the voters. So on and for.
Thank you, Senator Grew. Further discussion, Senator Boner, to you.
Thank you, Mr. Chairman. I was, I think, the lone no vote on this particular part of the amendment in committee. And just a little bit further background. So we had a bill 2 years ago that actually reduced the early voting period for everybody, both mail-in and in person, to 28 days. Just so we're clear, I heard 45 days being thrown out there. That's still the case if you're active duty military or overseas for some reason. That's a federal law. We're going to comply with that. But for everybody else, it's at 28 days. And so when we were working on that bill 2 years ago, the clerks thought a good time frame for everything was about 21 days. That's for mail-in and in person. We ended up at 28 because concerns about the Postal Service for mail-in, making sure that they get everything to everybody in time. So that's why we got the impression that maybe 2 weeks is right at a good spot for the clerks, even though they're concerned about their workload during those 2 weeks. If you don't like 14 days, maybe 21 is a little bit better. That would be consistent with the previous position from the clerks. So on and against the amendment for that reason, though, I think maybe we could find some happy middle ground on second reading, perhaps.
Thank you, Senator Boner. Any further discussion? Yep, Senator Case.
Thank you, Coach. Spring training starts tomorrow, Coach. I'm kind of excited. Mr. Chairman, I hope that we would resist this. This bill does a lot of good things. But our citizens really like to vote. This provides an opportunity. Going and voting in person on election day has become intimidating for a lot of people. There seem to be a lot of lines. People are asking for your information. You don't know if you brought the right information. You're always worried that you're going to get up there and they're going to bump you. It's not a normal thing for a lot of people. And it's kind of gone, there's a bit of there's a element of hostility sometimes. Either that you come by candidates on the street before you get to the distance from the polling machine, then you have poll watchers that can be kind of aggressive and kind of luring, and it's not the pleasant thing it used to be, Mr. Chairman, Coach Chairman. So where we've kind of involved is a lot of people take advantage of walk-in early voting. They feel like they can be more relaxed, they can take their time, they don't have a big line, and there's nothing wrong with it. It helps people vote comfortably. These are legitimate voters. And it does, I suppose it does make it hard when you're out walking door to door and you're trying to hand out your literature and you're trying to time it for this particular period. But isn't it better that they have a chance to vote in a comfortable way and it encourages voting and participation? So I hope you'll support the Standing Committee Amendment Division 3, Mr. Chairman. I appreciate it.
Thank you, Senator Case. Further discussion, we're on Division 3. Question's been called. All those in favor of Senator Case's motion to adopt Division 3 of Standing Committee Amendment Number 1 to Senate File 190, please say aye. Aye. Those opposed, no. No. Chair is in doubt. All those in favor, please stand. Twelve ayes. Those opposed, please stand. Sixteen noes. Division 3 has failed. Division 3 to Standing Committee Amendment Number 1, Senate File 190 has failed. We are now on Division 4. Would anyone like to speak to Division 4? Senator Grew.
Mr. Chairman, while I'm a person of deep faith, I'm agnostic on Division 4. Voted up, voted down. Thank you.
Thank you, Senator Grew. Senator Case.
I'll yield.
All right, over to President Biteman.
Friendly amendment, vote your conscience.
A lot of enthusiasm. All those in favor of Division 4 to Standing Committee Amendment Number 1 to Senate File 190, please say aye. Aye. Those opposed, no. Division number 4 has passed. So Division number 4 to Standing Committee Amendment Number 1 to Senate File 190 has passed, has been adopted. All right. That does it for one of the 3 amendments. Let's go. All right. So we have 2 more Committee of the Whole amendments, but we can get back on the bill at this point if anybody has any discussion on the bill before we go to a Committee of the Whole amendment. Mr. President.
Yeah, Mr. Chairman, I just wanted to reiterate the standing committee, the division about the 14 days, that's the least important to me. So if this really matters to you, that you want to keep it at a certain date or I'm going to lose your vote, trust me, we can work out a compromise on that. The meat of the bill to me is the paper ballots and making sure we have a traceable, auditable system and verification of citizenship, which we didn't have any problems with. So let's stick to what the good parts of the bill are, and if we want to come to a compromise on the time frame of early voting, please get with me and we'll be happy to do second reading amendments. But before we get on the other amendments, I just wanted to make that point. Thank you.
Thank you, Mr. President. Mr. Vice President.
Thank you, Mr. Chairman. Before we get to the other amendments, I simply want to say this is a reasonable approach, this bill. There are other bills coming to this chamber that I think are less reasonable. This is a reasonable approach. This is something that I can support. I think that we all should support it. Thank you, Mr. Chairman.
Thank you, Mr. Vice President. All right, any further discussion, or is it time to go to a Committee of the Whole amendment? Let's do a Committee of the Whole amendment.
Senate File 190, Committee of the Whole Amendment Number 1, page 3, line 19, after.
Senator Steinmetz.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1 to Senate File 190 and ask for your favorable consideration. Fellow Senators, we heard in 4 hours of testimony, I believe the other night, how many folks are very skeptical of our voting machines and they would like to see hand counting. However, that would be a major change and we didn't want to go that way at this time. But in listening to what they had to say, and when this bill came before us and the good sponsor brought it, I asked if he would mind if we looked at an audit component that would allow for hand counting. And so this would just go into the post-election audit section and require that they do a hand count for not less than one of the machines. And this is the 30-day, within the 30 days, the audit that they do every election cycle on the election machines. And so with that, Mr. Chairman, I'd stand for question.
Thank you, Senator Steinmetz. Any discussion on Committee of the Whole Amendment Number 1 to Senate File 190? Senator Case?
Mr. Chairman, I think I'd like to ask you to resist this amendment. The bill provides for hand counting. It's kind of a optional hand count, or a candidate or someone sponsoring a proposition can request a hand count, but they have to come up with a little bit more money for that hand count, and that's kind of what the fund's for, and there's a process. So I think the bill does a really good job of accommodating hand counts. This says that in any audit, you have to do it by hand count, at least for one machine. You know, I think that's kind of, it's mandatory, I guess is my point. Whereas the bill is about providing a way to move forward a hand count in kind of a voluntary with compensation way, Mr. Chairman. So I think it's kind of against the spirit of the bill by saying, if you do this audit, you have to do one of the machines by hand count. Hand counting may or may not be that easy, Mr. Chairman, and I don't know how many's on these machines and what the time is, but I think we should talk to our clerks about this before we go down this road.
Thank you, Senator Case. Further discussion? I'm happy it's not divisible. Back to you, Senator Steinmetz.
Thank you, Mr. Chairman. Just responding to the volume of people we saw at our meeting and giving the body an option. It's obviously a policy choice on our part. Thank you, Mr. Chairman.
Thank you, Senator Steinmetz. Any further discussion? Senator Kolb.
Yeah, thank you, Mr. Chairman. Was there any discussion about sunsets for this? I think that, there's a lot of discussion about people being suspicious, but I haven't found much of any evidence to verify that. I just wonder if we do this and we find out in a couple of years that there hasn't been a problem, do we just get rid of this? Because frankly, there isn't a problem. I just wondered if the conversation had anything to do with sunsets. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Senator Case.
Mr. Chairman, there was not a discussion of a hand count, or I'm sorry, of a sunset. The truth is, I'm not sure that anybody, the electronic machines, they're not going to prove themselves. There will be people in 10 years, we'll have a perfect record for 10 years, and there will still be people that are suspicious of it. The beauty of this bill, and why I support it, is it gives a way to bring in use of the paper ballots and hand counting those paper ballots, but in a way that's fiscally responsible, that kind of puts the onus on the requester, but has money to assist with that, provides a framework that seems fair and kind of considers all that are concerned. So there's no sunset on the bill. By all accounts, there's pretty broad support for this bill. It is definitely kind of something that's been fairly thought about. This instant amendment is an addition to, which requires the hand count. And I think that's inappropriate, and I would ask you to say no until we talk perhaps to our friends that run elections, and you all know them, and we'll take it from there.
Thank you, Senator Case. Any further discussion, final thoughts? Seeing none, all those in favor of Senator Steinmetz's motion to adopt Committee of the Whole Amendment Number 1 to Senate File 190, please say aye. Those opposed, no. Committee of the Whole Amendment number 1 to Senate File 190 has failed. We have a Committee of the Whole Amendment number 2. Oh, but first, Madam Majority Floor Leader.
Mr. Chairman, thank you. Privilege of the floor. I normally wouldn't interrupt an amendment and a bill, but because it's a great one. It's an emergency, Mr. Chairman.
It's an emergency. If it's an emergency, the floor is yours, Madam.
I have been secreting these flowers in this balloon for quite some time, and the good senator caught me because the governor called him away. But before we lose him, good senators, it is Senator Cooper's birthday today. It is his birthday week, so if we could all sing him happy birthday, and then he could have the balloon and the flowers on his desk, I think that would be wonderful. Happy birthday to you. Happy birthday, dear Ann. Happy birthday to you.
Senator Cooper.
Well, Mr. Chairman, I thought I might get away without this, but, oh no.
Oh no.
Apparently not. This is my 5th birthday while sitting in this chamber. And I gotta tell you what a privilege it is to have my birthdays here. I read a deal a couple days ago that said if you want to do great things, you have to surround yourself with greatness. And I think that applies to every person in this room. I'm just honored to serve with every one of you. We have our differences, but we work them out, and what a wonderful, great bunch of people. Thank you very much for this.
Thank you, Senator Cooper. Happy birthday from the Senate. Senator Hicks.
Yeah, Senator, could you wait a minute? I just wanted to say I appreciate those comments from my colleague from up in the basin, and to commemorate his birthday this weekend, I watched the movie Jurassic Park. And so, thank you, Senator. It was a great movie. You're a great senator.
Thank you, Senator Hicks. Anything else before we get to Committee of the Whole? Amendment number 2. Seeing none, let's read it in.
Senate File 190, Committee of the Whole Amendment number 2, page 3, line 18, delete.
Senator Case.
Mr. Chairman, a little bit of leeway here. This amendment deals with the exact same subject we discussed earlier with regard to the number of days. It was, there's this satellite vote places, and then there's the courthouse. And it was matching up. And in the spirit, I could push this amendment through because it deletes the whole section, and if you voted for it, we'd have it back to where it was, which is 28 days. But I don't think that's really fair, and I appreciate the spirit of the sponsor of the bill, and I would ask to withdraw that amendment at this time. But let's talk about this 21 to 28 days more.
All right, without objection, Committee of the Whole Amendment number 2 to Senate File 190 has been withdrawn. We are back on the bill itself. Is there any discussion? Senator Guru.
Well, just say, and it kind of goes with what the good senator was just talking about in his birthday greeting. This is one of these bills that when I thought, I said, no. And then when the good bringer brought it up and said, this is just a simple common sense bill, then I was really starting to worry. But through the discussion, and through the amendment process, as tortured as I made it, I'm kind of for it now. So on and for. Thanks.
Thank you, Senator Guru. Further discussion? Question's been called. All those in favor of Senator Case's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 190, please say aye. Those opposed, no. Senate File 190 has passed the Committee of the Whole. The next file for our consideration is Senate File 178. Will the reading clerk please read the Senate file?
Senate File 178, Fixing Reading Failure, an act relating to education, sponsored by Senator Scott. It was referred to Committee number 4, which returned a committee recommendation that it do pass amended. Ayes, Senators Brennan, Olson, and Scott. No, Senators Rothfuss and Schuler. Senator Schuler, Chairman.
All right, right before we go to that, Senator Schuler, I'm going to get over to Senator Jones, who I missed for I assume, a privilege of the floor. Senator Jones.
Mr. Chairman, privilege of the floor, please.
It is yours.
I would like to introduce my dearest friend, Annie Wedgwood, who is president of the Organization for People Who Sell Homes this year for 2025. Please welcome her to the Senate. She's hiding over here by me.
Welcome to the Senate.
All right, and with that, you have heard the reading of the Senate file. What is your pleasure, Senator Schuler?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, to do so with the recommendation that Senate File 178 do pass. There is a standing committee amendment, if we could have that read in.
Senate File 178, Standing Committee Amendment Number 1, page 1, line 2, delete.
And with
Senator
that, thank you, Mr. Chairman. With that, I will turn the time over to the bringer of the bill and let him explain the amendment as well.
Thank you, Senator Schuler. Senator Scott.
Mr. Chairman, you know, we've spent a lot of time talking about Education Day. We're going to spend a little more here. And I think that's appropriate, Mr. Chairman, because when you come right down to it, education is about the most important thing that Wyoming state and local government does. And it is well that we discuss it thoroughly. Mr. Chairman, I'm going to suggest we explain the bill first, and then we'll go to the standing committee amendment, because I think it'll make more sense that way.
Sounds good.
Mr. Chairman, origins of this bill. When I came back to the Education Committee after a fair absence, I started to read and catch up with what's going on. One of the first documents I read, Mr. Chairman, and this was in 2021, was the report from our consultants in the dated December 2020, and there was the consultants on the recalibration. And they were very blunt. Mr. Chairman, they said we were not getting our money's worth from our education system. And they pointed specifically to third grade reading. And they said third grade reading was the key. The business of the first few grades in school is teaching reading, and after third grade, the child is assumed to know how to read for the rest of their schooling. And if they don't, they're in real trouble. And the consultant said very bluntly that the children who were testing basic and below basic, as opposed to proficient advanced, but basic and below basic, on our statewide assessment test, the YTOP, were not going to be able, as adults, to participate in the modern high-tech economy we're trying to develop. And that was quite an indictment. Because at that time, almost 45% of the kids were not performing adequately, Mr. Chairman. And so we said, okay, why? What's going on? And as we looked into it, we looked at the assessment test results across all the districts in the state. And we did a ranking. It was included in the handout that has to be passed out. I think you've all got it. Shows not only the most recent results on that test, but also the results that the consultant was relying on, which were the last ones before the COVID was hit out. And COVID made things worse, and we've now mostly recovered, Mr. Chairman. In fact, we're closer to what the consultants were talking about. That's leaving way too many kids behind. So when we looked at it district by district, there was a surprising variance in the performance, all the way to 70% of the kids getting an adequate education with only 30% basic and below, to districts that were down as low as 10% getting an adequate education. and everything in between, Mr. Chairman. So he said, why do we have this big difference among the several districts? First thing we looked at was cost, and what we found first was some of the best districts were some of the worst funded per pupil in the state. So we did a correlation coefficient, and it was mildly negative, saying that the more you spent, the less we got. I think what it really said is that we're doing a pretty good job with our funding formula, focusing the money where the problems are. But it is apparent the lack of funding is not the source of the problem. We looked at size of district, and they're all over the place. That doesn't seem to be the cause. We looked at the rate of poverty, which you can tell, Mr. Chairman, because there's a free and reduced lunch category, and those are reported separately. And that did make a difference. When we did the correlation coefficient, it was positive 0.46 is my memory. It was in that range. And then we looked and found that that's a problem that can be overcome because the better managed districts were able to get their children that were in poverty to a level that was better than for the state average for all the children. So it's a factor, Mr. Chairman, but one can be overcome. So what we finally came up with is it looks to be what the priorities and probably secondarily the competence, but really the priorities of the local school district management, school board, and their local superintendent are. If they value reading, they value the fundamentals of education, they did pretty well. If they were trying to build a bureaucratic empire or a sports empire, and frankly, my district, I think, was doing both, they were not doing very well. So, what are we going to do about it? This bill tries to provide an answer. It does invade local control. Let me be blunt about that. It invades local control, Mr. Chairman. But it does, based on data that is showing that our performance is simply inadequate and that we're leaving way too many kids behind. What the bill does is it divides the districts into two classes. The ones that are doing 60% or better in the proficient and advanced, and the rest of them. The ones that are having the more success, it is less prescriptive. It does across the full spectrum, Mr. Chairman, insist on opportunities for parental involvement because we think that is one of the keys to success. That if the parents in the school district are on the same team, that will influence the child. Those are some of the most important adults in the child's life. They're all on the same page. The child will respond better, and the parents know the child better than anybody else, so they can have some very positive input, Chairman. So it insists on that, and it insists on informing parents when troubles are discovered. Mr. Chairman, for the rest of the districts, we're a good deal more prescriptive as to what they do and how they do it, because there's problems there, Mr. Chairman. We need to focus our attention on those. The bill does speak ultimately to retention. In the early grades and starting next school year in the early grades, we give the parents the right to tell the school district they have to retain the child in grade. And the reason we do that there is usually the issue, Mr. Chairman, is the maturity of the child. Kids mature at different rates, and the parents are the ones that best know that. So it isn't working for the child at that level. We give them the right to tell the school district, you've got to keep the child back. I don't think that's particularly controversial, Mr. Chairman. But then ultimately, and it's a ways out, the 2028, 2029 school year, we say the fourth grade child that is not reading adequately, after all the efforts we've made to cure it, and we try to cure the problems early, if the fourth grade child is not reading adequately, then we'll retain them for up to 2 years, try to get it right. And Mr. Chairman, that offends a number of the school districts, probably most of them, who have been saying that's going to be hard on the child. They're going to feel singled out. They're going to feel like they aren't a success. But I say to you, Mr. Chairman, it is better for the child to have their feelings hurt a bit at that age than it is to spend the rest of their life behind the 8 ball because they have not been able to learn how to read adequately. And that's what the current strategy of social promotion is doing. It is putting the child behind the 8 ball for the rest of their lives. So, Mr. Chairman, that is an element in the bill. There's a couple of other things you need to know about. There is a provision that if the school districts do not perform, the parents have the right to sue them. They don't get the notifications. They don't follow through on the individualized plans that are supposed to be done when the child's in trouble. They don't implement them. And that's there, Mr. Chairman, because in good part, on an earlier iteration of this bill in 2001, many of the school districts just flat ignored the requirements of the bill. And we don't want to see that report. We've got to have some enforcement because, again, you are hurting too many children by not adequately teaching. And then there's a provision in there that strengthens gives the state superintendents the ability to get, we've called it an operations research staff, because that gives her great flexibility in who she hires and how she does it, but give her the ability to go out and help the districts that are in trouble. She insisted it be done in a budget neutral fashion, so there's no appropriation. She'll gradually move some vacant positions, I think, into that area and be able to fund them with the existing appropriation. Mr. Chairman, that's a quick summary of the bill. At this point, I think it would be appropriate to take up the standing committee amendment.
All right, thank you, Senator Scott. I believe it's been read in, but it has not been moved.
Chairman, if it's not been moved, I'll move it. Mr. Chairman, standing committee amendment does two things. It does a little, there was one technical correction where on the first opportunity, the State Department had to make some suggestions. We missed one of their suggestions in one page in the drafting process, and that got corrected. But the first main part is it took us a while to get the attention of State Department of Education. We started way back last year, really, trying for it. We finally had a meeting with them early December. They made some suggestions we incorporated. They had a whole bunch more suggestions the day before the session started, and we accommodated to the best we could and still get it out on time, but that's why the bill number is so late. It took a while. And then they had more suggestions, and we discussed those with them, came up with the ones that we could turn into reasonable amendments, found some others, Mr. Chairman, that could perfectly well wait for regulations, and some others that were really wordsmithing that didn't make any difference. So, Mr. Chairman, that's the major part of it. And then second, a committee member reduced some of the provisions on the ability to sue, took out the monetary damages part, left in the essentials. So, Mr. Chairman, I don't think that did any harm. So that's a standing committee amendment. I'd be happy to answer any questions.
Thank you, Senator Scott. We are on Standing Committee Amendment number 1 to Senate File 178. Is there any discussion on the Standing Committee Amendment at this time? Any discussion? Seeing none. All those in favor of Senator Scott's motion to adopt Standing Committee Amendment number 1 to Senate File 178, please say aye. Aye. Those opposed, no. Standing Committee Amendment number 1 to Senate File 178 has been adopted. Back to you, Senator Scott.
Mr. Chairman, that's the bill. I'd be happy to answer any questions. It is an important piece of legislation. Mr. Chairman, it's time we lived up to our responsibilities to see we have what we could have. What university president Ed Buchanan, I think his name was Ed, said once that there is no excuse for Wyoming not having the best public education system in these United States. And he said in kindergarten through graduate school, this is the K-12 part of it. Mr. Chairman, we ought to be the best. And I think this is the first further step down that road to make us the best.
Thank you, Senator Scott. That was University President Tom Buchanan. All right, Senator Guru, over to you.
Thank you, Mr. Chairman. On and against, I understand the bill and I understand what the bringer's trying to do, and I think it's laudable. I think he's hitting a lot of those points right on the button. My only question and what gives me pause is timing. We're about to step into recalibration. We're starting to step into a real meaningful discussion about the basket of goods. And it's a question issues that a lot of us have been really waiting to really get into. This kind of puts the cart before the horse, in my view. It adds more before we even start looking at the basket itself and how we attack this whole problem. So for me, while I think it's well-reasoned and well-intended, I think not now, not here. Let's wait, let's get this discussion going in our Good Education Committee and work through this in the interim, and I think that'd be the best course. So on and against. Thank you, Mr. Chairman.
Thank you, Senator Guru. Anyone else like to speak? Senator Schuler.
Thank you, Mr. Chairman. Again, I was one of the no votes on this bill, and not because I don't like it. There's just parts of it I don't like. I was kind of hot and cold throughout this. It's almost 30 pages, and there's parts of it that I really like. There's parts of it that I just don't think quite work for me right now. I appreciate the bringer of the bill because he did a lot of work on this and also brought in the State Department of Education, and we all worked a little bit with them. I think you can see that from the amendment that was brought in. A lot of work done. One of our other good chairmen on education worked with the State Department as well. We're all trying to get it right. I'm not sure that this is right yet. Our goal of trying to have 85% is what we should all be shooting for. The incentive part of it, I really like. I think we should, incentivize those districts that are doing well. I like what we've done there, or what the good bringer of the bill. I didn't have anything to do with it, but, and then, of course, the stick part is the retention. And if you do a lot of research on retention, the data's not really good. And right now, you can retain kids. Not a lot of people like to do it in those first 3 grades because of some of the things that the good senator mentioned. Socially, it's tough. Do we need to do it? Maybe down there, probably. But that's kind of the stick that might be a little difficult. But the other part that kind of concerns me is that we're going to have to grow government a little bit with our State Department to get the help to monitor the things that are asked for in this bill. But I do like the fact that we have some, alternatives for these kids if they're not meeting the basics, with summer camps and tutors and all of this nature. So like I said, I'm just so hot and cold on different parts of this bill. I could show you the parts I really like and the parts I really don't care for. If the bill goes through, I'll probably bring some amendments. But I certainly like the intent, and I know that we need to do better with our little ones in those first 3 grades. And I do think, though, if you take a look at that data that the good senator brought forth, you will see there is a bit of a connection between the poverty levels. Just in my district alone, one of them that's in the top 10, the poverty levels at 25%. One of them that's 33rd, their poverty is 50%. So there is a difference there sometimes with poverty levels and how that affects our little ones. But regardless, we don't use that as an excuse. We always want to do better and try to do things better. So I think it's a good intent. If it goes forward, I'll try and bring some amendments to fix the things that I have some issues with. But again, vote it up or vote it down, depending on where you are with this. And it's a lot. It's a very complicated bill. And, I think it's trying to get to the right place. And I'm just not sure, kind of like the good senator from Teton County, I'm not sure if it's the right time again yet with everything else we're doing right now with education, but certainly up to you.
Thank you, Senator Schuler. Mr. President?
Thank you. On and for the bill. We've got a lot going on, yes, but there's nothing more important than making sure our children are reading. And we owe it to them to do whatever we can, because where we're at now is not acceptable. And looking at the test scores, it's not good. We can do better. We're Wyoming. We can be the best. We have to be the best. And I applaud any efforts to make our system better. And even if it's a 26-page bill, let's do it. It's a general session. Now's the time to do it. When next year's budget, it'll be, we don't have time to do it next year because it's a budget session. This should wait another year. And we'll study it. We'll kick the can down the road. And then half of us will be gone, and then there'll be new people, and then they'll see the test results, say, hey, we got to do something. And I'll have to realize how long of a process this is, and nothing will ever get done, Mr. Chairman. Let's get to work. Let's move this forward. Let's bring amendments. Let's work together. Within the 31 people in this chamber, we can get this thing right, and we can do good by our children. So I'll urge an aye vote.
Thank you, Mr. President. Any further discussion? Senator Landon?
Thank you very much, Mr. Chairman, and really appreciate the words just spoken. And I'm going to try to get there. It's just an awful lot. And I have to say, the other day I stood and talked about our fourth grade National Assessment of Educational Progress. We call it NAEP, our national scores. And I indicated that we were 7th in the nation. Well, I was wrong. In this part of things, our fourth grade readers scored number 2 in the nation 2 months ago. That's pretty remarkable. And so I'm trying in my mind to connect all of this. There are a couple of things that I was going to ask about. This is very prescriptive to a district that says the district shall provide the following. And can all 48 of our districts do this? Can they find a highly effective teacher of reading as demonstrated by student reading performance data, teacher performance evaluations, and teacher licensure to include a passing score on a professional teacher standards board approved literacy interventionist reading knowledge and skills assessment? My question is, does that test exist? Does that national accrediting authority exist? And can our district stand that up? I'm trying to drill down into the bill a little bit and just get my arms around it, because this is an awful lot, folks, and we've got 48 districts. I think my district can stand this up. In fact, they're probably already doing it. But folks, there's a lot in this. Thank you.
Thank you, Senator Landon. Any further discussion? Senator Hutchings?
Thank you, Mr. Chairman. On and for the bill. I just know when I was in education, it was the same old thing. Recalibration's coming up. Let's move this down the road. Let's move this down the road. Our scores may be good, but there's a saying that we have the least dirty shirt in the laundry. The scores may look good, but they're not the best, and we all know it. So on and for this bill. Thank you, Mr. Chairman.
Thank you, Senator Hutchings. Any further discussion? Back to you, Senator Scott.
Okay, Mr. Chairman, try to wrap this up. Let me deal with the question first on the highly effective teachers. Mr. Chairman, that part of the language came from the Department of Education And they know what they're doing on this one. So I think that's important to understand. It does apply to the districts that are perhaps not as effective. So it's important. And there is time, Mr. Chairman, the things that go into effect right away are not particularly controversial. The things down the road are, and we'll have plenty of time to adjust those. Mr. Chairman, the discussion on our relations to the rest of the states, how we stand. Yes, we do relatively well, always have, in the NAEP tests and those assessments given by the U.S. Department of Education are highly regarded. They're sort of the gold standard in this area. Why does Wyoming do better, Mr. Chairman? One of the reasons, I think the principal reason, is that Wyoming does not have a big inner city school district, because we don't have a big inner city. And those have all kinds of cultural and management problems. We just don't have that, Mr. Chairman, so we should do better. We should do a lot better than we are, because we're not teaching so many of the kids how to read. And then, Mr. Chairman, in response to the timing's not right. That is always the argument against any kind of a reform. Mr. Chairman, the timing is right because we're leaving way too many kids behind. If we procrastinate, that'll be just that many more kids left behind. We probably should have done it a few years ago, but it took us a while to figure out what to do. We probably should have done it with the original bill in 2001. We tried. We need to move forward now because we're leaving way too many kids behind, Mr. Chairman, on and for the bill.
Thank you, Senator Scott. Any further discussion? Seeing none, all those in favor of Senator Schuler's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation on Senate File 178, please say aye. Aye. Those opposed, no. Senate File 178 has passed the Committee of the Whole. The next bill for your consideration is Senate File 181. Will the reading clerk please read the Senate file?
Senate File 181, Eminent Domain Energy Collection Systems 2, an act relating to eminent domain, sponsored by Senator Craigle. It was referred to Committee Number 7, which returned a committee recommendation that it do pass amended. Ayes Senators Boner, Case, Dockstader, Landon, and Steinmetz. Senator Case, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Case?
Well, Mr. Chairman, I would tell you, but I can't because there's a gigantic hot air balloon between me and the screen. But I think I move that when the Committee of the Whole rises to report, it do so with a do-pass recommendation on Senate File 181, Eminent Domain Energy Collection Systems 2. And there is a Standing Committee amendment. I'd like it read in at this time.
Senate File 181, Standing Committee Amendment Number 1, page 3, line 10, delete.
And Mr. Chairman, I would move the Standing Committee Amendment number 1 to Senate File 181 and ask that you now call on Senator Craigo to explain the bill and the Standing Committee Amendment. He's under the balloon somewhere.
Somewhere down there. Thank you. Senator Craigo.
Thank you, Mr. Chairman. It's my pleasure to bring to you today Senate File 181. I ask for your favorable consideration. Mr. Chairman, members, this bill relates to eminent domain. It's actually a private property rights bill, despite the title. So going back a little bit, if you happen to open up your green books and you look in Title I, 126.815D, there's actually a provision in the green books that allows for the use of eminent domain for energy collector systems. And as the statute's currently written, after the sunset of the moratorium contained within that particular provision, eminent domain can be used for energy collector systems. And there really are no sideboards put on that process, other than those already contained within statute as far as compensation, et cetera. What this bill attempts to do is put some reasonable sideboards on that process to protect property rights, both for those folks who may want to put this type of project on their property, i.e. wind, solar, could be other types of energy generation later on, but right now we're talking about wind and solar for the most part. And then also for the folks who would be burdened by the transmission lines coming from that particular project. And so we actually worked this bill in the interim in Agriculture Committee. And we worked another bill side by side. We brought forth two bills, and at the end of the interim work, we ended up passing the other bill out of the interim committee. And we did not pass this one out. I actually like this proposal better, so I ended up bringing it as an individual bill because I think it strikes a better balance. The other bill prohibited the use of eminent domain completely for these types of systems, which I believe impeded on someone else's property rights, the person wanting possibly to put up one of these projects. We listen to a lot of testimony. There are a lot of landowners nowadays who are paying for their agricultural businesses, ranch businesses, et cetera, by putting these projects on their land. It's keeping land in ag, and so that's something I always try to do when I'm as a person that's involved in that myself. And so, Mr. Chairman, I'll walk through the bill, then we'll get to the amendment. Page 2, start in. We create a new section 126.715, and that's for compensation for condemnation. And so if you, in your green books, in Title 1, Chapter 26, in the 700 series, there's a whole lot, which is actually a fairly new set of statutes, and it has to do with compensation related to eminent domain. What this does is say, hey, for these specific types of projects, you have to also refer to not only the 700 series, but this new section we're going to create in 126.818. Which is right below that. And so that starts talking about the process for using eminent domain. And essentially it says you can use eminent domain, but only under certain circumstances. And so those circumstances begin on page 3. And what it says there is before, and this is where the whole balance comes in, before you can bring in action for eminent domain for one of these projects, you have to go and get approval of not less, and this says not less than 85%. This is actually the subject of the standing committee amendment, which we'll get to in a minute. Not less than 85% of those folks upon which the transmission lines would be located, or not less than 85% of the owners of the land upon which the energy collector system will be constructed if not less than 3 landowners are involved in the potential condemnation action. And so the math in that wasn't quite right, and we felt like the percentages weren't quite right. And so the committee, our Good Corporations Committee, did some good work on that. And that is really the subject of the first part of the standing committee amendment. And it changed the number from 85 to 66%. And the whole point of that is so that if you have one person, they can't hold up a project for a lot of people. And that's what this does. It gets the math gets the math where it should be. And I think at some point when we actually have discussion on the amendment specifically, I think members of the committee will explain kind of why they thought that. I know one of them right behind me had some good ideas on this, and so the committee did good work on that. Moving on, so that's the math part of it. Then you have, moving to the bottom of page 3, you have to legend the complaint. You have to show that you've complied with part 1, which is the math, right? You have to show you have approval from 66%, and then in addition to that, you have to show to the court, and this will probably be something we do on a subsequent reading amendment, but you have to show the terms and condition of your agreements with all the other parties, so that the court knows if you're asking for condemnation, hey, here's what we've given to everybody else, here's what we're going to give here, so that the court knows what's fair and reasonable for the condemnation action in terms of compensation. The reason we may have a second reading amendment, or most likely I'll probably bring it myself, is one of the concerns was from the landowners as well. When I file something in court, the whole world can see it. And these agreements don't necessarily need to be shown to the whole world, they just need to be shown to the opposing party. So I think we can bring an amendment that just says they're filed under seal to be shown to the other party, so that we're not letting the whole world know what's out there. And I think that's a fair request. And I'll work on that as we move forward. And then the next thing you have to show, Mr. Chairman, is that it is for public use, that the commercial facility generating electricity constitutes a public use. Moving down, the parts, subsection little c on lines 15 through 17, that talks about calculating compensation, and part D is the same. It just refers us back to the statutes that are already in place for calculating compensation, and I talked about those earlier, Mr. Chairman. Turning the page, page 5, and this talks about easements that are already in existence, and we had a lot of conversation about this through the interim too, and one of the concerns was, well, will this particular bill be used to allow existing easements to be expanded? So you have for example, there's a pipeline easement. Can that pipeline easement then be used for one of these projects? And we felt that wasn't really what we were trying to get at, and so this essentially says, look, if there's an existing easement that's not specifically for this, then you have to follow the same process unless the language of the easement allows you to do it. And that's really what lines 1 through 15 talk about. Moving down, there was lines 17 through 22, they're on page 5. That's talking about giving notice to your Board of County Commissioners or city or town 30 days before you file a condemnation action. There was actually quite a bit of discussion about this during the committee. I think we could have this, that's also another point for everybody to look at moving forward, whether we want to keep that in or not. I personally do, but it's something that the body should be aware of and at least look at. Part G, top of page 6. This is one that's important to a lot of our landowners out there, and it just says that the clauses relating to liability of the parties related to the particular projects are the same across. So if you give it to one party that's part of the that you made an agreement with, that the people you condemn or use eminent domain against get the same. It's, you know, we call it, in the legal world, we call it a favored nations clause. It's essentially the same thing there. Moving down, these are the exclusions under the act. On page 6, line 8, says this section shall not apply to. So this is also part of not only the standing committee amendment, which we'll get to, but then the subsequent committee of the whole amendment. And the second half of the standing committee amendment deletes lines 14 through 17 because the language, and admittedly so, I did not do a good job on that, Mr. Chairman. It's not clear what we were trying to get at. The standing committee, or the committee of the whole amendment, which you will see in a few minutes, actually does do what I was trying to get at, and it's a much cleaner version, and so the good senator in the back of the room will bring that up for us. Moving down page 6, the bottom there, we're just getting into the definitions. And that's actually existing language within our green books in section 815D. Both of them moving on to page 7 as well. And then page 7, we begin some of the conforming amendments. Actually, all the conforming amendments. Page 8, at the bottom there, we create a new subsection E because we have a repealer. So 815D is repealed. So we then have to go in and insert 815E and refer back to 818, which we are now creating through this particular bill, Mr. Chairman. And I think I would also point out section 4, page 9, I think it's important. We're not trying to create any ex post facto issues here, and so we exempt out any projects that are in process or going through the permitting process right now. So if you've started down this road, this particular bill would not apply to you, Mr. Chairman. So moving back to the, and I'll do this real quick, Mr. Chairman, moving back to the standing committee amendment, again, it changes the math from 85 to 66, and then also takes out the language there on page 6, lines 8 through 17, and then puts back in the language about public convenience and necessity. And so and then the very bottom on the standing committee amendment, that's actually just, we missed a word from the definition in the statute, and we're just adding the word up, which I don't know how I caught that, but somehow we did, Mr. Chairman. And so I would move standing committee amendment number 1 to Senate File 181 and ask for the body's favorable consideration.
That's already been moved by Senator Case, but I appreciate that, Senator Craigo. We are discussing the standing committee amendment number 1. Any discussion on the standing committee amendment? Any discussion? Seeing none, all those in favor of Senator Case's motion to adopt standing committee amendment number 1 to Senate File 181, please say aye. Those opposed, no. Standing committee amendment number 1 to Senate File 181 has been adopted. We are back on the bill, and we do have a committee of the whole amendment, but on the bill, Senator Landon.
Mr. Chairman, I would move committee of the whole amendment number 1 to Senate File 181 and.
We're going to have to read that in. Please pause.
Senate File 181, Committee of the Whole Amendment Number 1, page 6, lines 8 through 17, delete.
All right, Senator Landon, now for the motion.
My apologies. Mr. Chairman, I would move committee of the whole amendment number 1 to Senate File 181 and ask for your favorable consideration. Senator, this goes right into page 6, lines 14 through 17. The sponsor of the bill did a great job of explaining what was up with that language. We wrestled with it in the standing committee, and I took it home, talked to a couple of folks, came back to the sponsor, and we kind of visited about this, and I think you'll find that this language plugs back in an exemption that I thought was very important, Mr. Chairman, and clarifies what we're talking about. Bottom line is, given all the dollars made by the various companies to build and operate these 28 existing wind farms out across our state, many of them are not operated by the major power producer that you think of. My concern, I kept thinking, what if property next to you sells? Somebody comes in from out of state, and one landowner can literally hang you up on something that has existed for quite some time. So these other collector systems, and that's defined right below that in the bill, the other collector systems would be exempted as well, and I think that's really important for the bill. I don't want to spend any more time on it. We're getting late in the day. I think this improves the situation, brings an exemption back in. Thank you.
Thank you, Senator Landon. Discussion on the amendment. Discussion, seeing none. All those in favor of Senator Landon's motion to adopt committee of the whole amendment number 1 to Senate File 181, please say aye. Those opposed, no. Committee of the whole amendment number 1 to Senate File 181 has been adopted. We're back on the bill. Discussion on Senate File 181, eminent domain energy collection systems 2. Do we have another? Oh, we've got another. I didn't see it. By all means, yes, we do. There it is. And it's, let's have Committee of the Whole Amendment number 2 read in, and Senator Craigo.
Senate File 181, Committee of the Whole Amendment Number 2, page 7, line 11, delete.
Senator Craigo.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 2 to Senate File 181. Ask for your favorable consideration. So, Mr. Chairman, this was actually some language that was caught by our good commission that handles our public utilities. And the way this reads, if you turn to page 7, line 11, talks about a commercial facility generating electricity, and then the end of the clause says selling electricity at the retail market price. Well, those are actually our utilities, and utilities are exempted from this act. And so just to make that clear and clean that up, and really we're talking about anybody that's generating electricity except those utilities. And so this is just a cleanup, make sure we're not confusing the situation. And so it deletes the language at the retail market price from the bill. Stand for any questions.
Thank you, Senator Craigo. Any discussion on Committee of the Whole Amendment number 2? Any discussion? Seeing none, questions called. All those in favor of Senator Craigo's motion to adopt Committee of the Whole Amendment number 2 to Senate File 181, please say aye. Those opposed, no. Committee of the Whole Amendment number 2 to Senate File 181 has been adopted. We are back on the bill now, finally. I think we're out of amendments. Senator Ide.
Yeah, thank you, Mr. Chairman. I was on the committee, the bill that we lost is the one that I liked. It required 100%. I think that this was a good start at 85% of the landowners, and now it's going backwards a little bit, so I'm having my reservations. But I still think it's a good bill. It puts some sideboards on this thing. I didn't quite, the amendments that came up, I wasn't tracking entirely with those, but in my opinion, property rights are absolute, and this is about as close as we're going to get, like the good bringer of the bill brought here. I was in favor of having 100%, like I said earlier, but with that said, I think we're headed in the right direction, so honored for the bill. Thank you, Mr. Chairman.
Thank you, Senator Hyde. Any further discussion? Further discussion, seeing none, all those in favor of Senator Case's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 181, please say aye. Aye. Those opposed, no. Senate File 181 has passed the Committee of the Whole. The next bill for our consideration is Senate File 189. Will the reading clerk please read the Senate file?
Senate File 189, Uniform Commercial Code Investment Securities Amendments, an act relating to the Uniform Commercial Code, sponsored by Senator Beitman, was referred to Committee Number 2, which returned to committee recommendation that it do pass. Ayes, Senators Driscoll, Larson, Salazar, and Smith. No, Senator Garud. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Salazar?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate File 189 do pass. And to explain this good bill, I'll ask the President of the Senate.
Well, let's go to the President of the Senate then. President Beitman.
Senator Beitman works, but ladies and gentlemen, I bring you Senate File 189. Keeping within the theme of property rights here, this bill establishes, basically it answers the question, what would happen if you own stock indirectly, you don't physically own your stock certificate? What happens in a major financial crisis? Would you be first in line in front of your creditors, or would the creditors take your stock? Mr. Chairman, let's talk about that. So, what we do here, it strikes two exceptions we have within the Universal Commercial Code. And I know you all sit home at night and read the UCC. What we do here is we go into Section 8 of the UCC, and we go to Section 8.511, which is priority among security interests and entitlement holders. So this gets directly to my question. What happens if the too big to fail? And so what my bill does two things. The first thing you'll see on page 1, choice of law, changes it so that state law governs. Because if we're going to go into a uniform code, we've got to make it so Wyoming, our law governs. That's the first thing this bill does. Then the only other thing it does here is the rest is conforming language on page 2. Look at page 3 where the repealers are. The first two repealers in 110, E and F, that's the choice of law that we just changed. So that repeals the language regarding choice of law, which changes it from current law to Wyoming law governs, okay? Pretty simple. Second thing it does in 511B and C, it repeals those. And let me read those to you real quick, Mr. Chairman, because it's important. 511B says, a claim of a creditor of a securities intermediary who has a security interest in a financial asset held by a securities intermediary has priority over claims of the securities intermediary's entitlement holders. So an entitlement holder would be me owning a stock through a too big to fail, but I don't have the physical stock certificate, and they can commingle those assets. So I'm already second in line here. Who have security entitlements with respect to that financial asset if the creditor has control over the financial asset. Now B, and that's C. Look at C. If a clearing corporation does not have sufficient financial assets to satisfy both its obligations to entitlement holders who have security entitlements with respect to a financial asset and its obligation to a creditor of the clearing operation who has a security interest in that financial asset, the claim of the creditor has priority over the claims of the entitlement holders. So while Section 8 does a lot of great things to make our system work. And the current system that we have where we can buy and sell electronically does a lot of cool stuff. The only thing that the problem is that I see with it is that B and C language in the event of a major insolvency or a run like we saw in 2008, and the priority issue. So if you own your shares physically, you're covered, you're good to go. But if you're one of millions of Americans that don't, you could get caught up in this. And Mr. Chairman, that's what I'm trying to fix. And before we go in a deep dive into all this, I'll stand for any questions, but that's the gist of the bill.
Thank you, Mr. President. Discussion on Senate File 189. Senator Case.
Thanks, Mr. Chairman. Mr. Chairman, I've received some communications from some folks that are concerned about this. And they're folks I respect, Mr. Chairman. This is a uniform law. And we have an entity called the Uniform Law Commission, Mr. Chairman. And I heard from 2 members of the Uniform Law Commission that are very concerned about this bill and suggest that we shouldn't pass it forward. One of those members, sir, is a former Supreme Court Justice. So I don't take this lightly. And I also heard from the association that represents commercial banks in Wyoming. So I'm going to tell you, here's what I hear from one of the members of the Uniform Law Commission. Today, I watched the Senate Appropriations Committee pass Senate File 189, which amends some of the Article 8 of the Uniform Commercial Code. The amendments deal with provisions that facilitate electronic investing. Unfortunately, the committee primarily heard only from a proponent of the changes. I checked with the Uniform Law Commission, where I'm a life member, and no one from the committee nor the bill sponsor asked for any input from the ULC, Uniform Law Commission. I only learned of this bill 2 days ago and was unable to be at the committee meeting. The issue is far more complex and not as nefarious as the proponent of the bill represents, with all due respect. The proponent of the bill represented that the UCC, as it now exists, permits brokerages and clearinghouses to own and use their client stock as collateral without consent. I strongly disagree with those representations to the committee. To the contrary, a brokerage who did that would be violating both federal and Wyoming law. Furthermore, I'm concerned that these proposed changes will convince clearinghouses and out-of-state brokerages to simply write off Wyoming, harming both individual investors and financial institutions in our state. I believe Senate File 189 is ill-advised. Similar bills failed last year in Oklahoma, Tennessee, South Carolina, and Minnesota. This year, Mississippi rejected the bill, and New Hampshire referred it for study. A legislative committee in South Dakota, however, recommended the bill on a 7-6 vote. At the very least, the issue should be studied and discussed with an opportunity to hear from the Uniform Law Commission, investors, and the financial industry. That's from a person, that lifetime member, somebody I respect. I'm wondering if this is just a great idea for interim study. And you know, it's kind of a big lift in an important area where our uniform laws are important. Thank you, Mr. Chairman.
Thank you, Senator Case. Further discussion, Senator Landon.
Thank you, Mr. Chairman. I too heard from some folks, and one was my local banker. And I really think she is someone I try to pay attention to. Really have a lot of respect for her. But just one specific thing that she pointed out to me seemed reasonable, and so maybe we could discuss this for just a minute. Generally, she indicated that the UCC gives priority to customers. But if you have a security that you put up for a loan, that's one of the exceptions that's in the UCC code. That seems pretty reasonable to me, that if you've given that up as collateral for a loan, that kind of doesn't belong to you anymore. Maybe I'm being too simplistic here. And then, of course, the other exemption is for clearinghouses, and I won't get into that one, but it did seem reasonable to me if you've given that up for a loan. So, thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Crum.
Yes, Mr. Chairman. Well, I appreciate the thought and the idea and the general direction of the bill. I really do. It concerns me, we're dealing with the Uniform Commercial Code, which is uniformed in theory across the United States and transactions taking place. I don't want to repeat what our good senator from Fremont County and Natrona County said, but the borrowing aspect of this thing, not people being able to borrow on their securities, and then also to margin their securities as it becomes a real issue. So it might be a great topic for the interim. It truly might be a great topic for the interim, how to bring this home, make it more local, protect our Wyoming citizens, but yet I am concerned about when we get out of uniform with everybody else, what business and what will that hurt us on our commerce by being out of sync with everybody else. So thank you, Mr. Chairman.
Thank you, Senator Crum. Senator Ide.
Yeah, thank you, Mr. Chairman. On and for this bill, I think it is a small step forward to protecting private property rights of the Wyoming citizens, and it does align with Wyoming law instead of seeking alignment with other states. So on and for the bill. Thank you.
Thank you, Senator Ide. Senator Driscoll.
Thank you, Mr. Chairman. Sometimes a small step forward is a big step backwards. And, unintended consequences are what this body should never take a chance at. I asked some pretty hard questions at the committee, didn't really get them answered. I went ahead and voted it out of committee. The more I've looked into it, the more I've talked to people, sometimes really nice to make a good statement about what you're doing for your private property rights or you're doing for your rights. But the unintended consequences, maybe you may have no one to trade with, because literally all of these bigger firms is where it goes. And it's easier for them probably on a large scale to exit Wyoming, and we'll end up just like we are in healthcare. You'll have a couple firms that are left here and that's all you get to do business with, or you don't have them. And for me, maybe they leave, maybe they don't. It's not worth the chance. It literally is not worth the chance. And it also, I think it bodes ill to go against any time you've got a universal commercial code that covers the entire country, to take a state of our size and try to stand up against windmills. Making statements is fine. We had a letter to Santa this morning. We could do one on this one. But to stand up and actually do it and take a chance for all of our constituents that they might not have the choices they do now is the wrong way to go. Let's either look at an interim or doing something different, but let's not do a decision that we might regret later.
Thank you, Senator Driscoll. Back to you, President Biden.
Thank you, Mr. Chairman. I haven't heard anybody refute B and C of 511. Priority among security interests and entitlement holders. Read it. Tell me I'm wrong. It says what it says. Like I said, Section 8 gives you protection and is great. Those two are problematic if you're worried about a systemic collapse like we saw in 2008 or worse. B and C allow financial institutions to use securities as collateral, introducing systemic risk. We bailed out the big guys before. They were too big to fail. Our citizens and possibly our funds, state funds, that could be at risk. This is a wake-up call, and it deserves attention. We hear a lot about all this, you can't tweak with the UCC. A couple of years ago, we passed a bill and changed Wyoming laws away from what the UCC did. I think it might have had to do with blockchain or something like that. So we do it, and the sky didn't fall. Let's take a close look at this and prove me wrong. Don't just read platitudes and opposition from the people representing the too big to fails. I'm here representing the little guy and all of us, so thank you.
Thank you, President Biden. Any further discussion? Seeing none, all those in favor of Senator Salazar's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 189, please say aye. Aye. Those opposed, no. No. Senate File 189 has passed the Committee of the Whole. Next bill for your consideration is Senate File 195. Will the reading clerk please read the Senate file?
Senate File 195, Small Business Emergency Bridge Loan Programs, an act relating to the Department of Agriculture, sponsored by Senator Biden, was referred to Committee Number 5, which returned to committee recommendation that it do pass amended. Ayes Senators Craigo, French, Ide, McEwen, and Pearson. Senator French, Chairman. Was re-referred to Committee Number 2, which returned to committee recommendation that it do pass. Ayes Senators Guru, Larson, Salazar, and Smith. No, Senator Driscoll. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator French.
I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 195 do pass. And for an explanation, I call on President Beitman.
Thank you, Senator French. President Biden.
Thank you, Mr. Chairman. This is what happens when you get everybody else's bills out before yours and you're up against it at the end of the session here, trying to get bills out. So I'm working hard here. I bring you 195, Small Business Emergency Bridge Loan Program. Mr. Chairman, what this bill does is sets up an emergency bridge loan program for small businesses affected by natural disasters declared by the governor. Obviously, this came to mind after the fires we had this summer, and trying to figure out a way to make sure that if this were ever to happen again, Mr. Chairman, we would have something to make sure Wyoming doesn't miss a beat and our small businesses can get back up and running within days, not months, not years, but within days of a disaster, and specifically a fire disaster. If you need to move livestock around, you need to buy hay, you need to replace animals, you need to fix fence, you can apply for a 0% bridge loan through the state and through your local bank, who will do the vetting process for you. And I just think this is a win-win for everybody. I'll walk you through kind of what the eligibility, the key provisions of the bill. Eligibility. So businesses must be physically located within Wyoming in a disaster-declared county. Like I said, the governor will declare whether or not a disaster has occurred. Businesses must have been operational before the disaster. You have to be a 50% owner with a credit score of at least 550 and guarantee the loan. You have to put up collateral. This isn't just free money. We're not going to risk the state's money here. Certain industries are excluded, such as gaming, lending, and investments. You can't grow your business. It has to actually be used for specific purposes, and they'll promulgate rules to make sure that this isn't abused. The term of the loan is up to 3 years, up to $1.5 million per business. It'll be secured either through insurance proceeds that may be coming or other disaster relief monies that could be coming, or business assets. If none of that applies and you want to put up assets of your own to secure this loan, you can do that as well. 0% interest. It's a revolving fund, so as these loans get paid off, that money goes back in the account. Also has a mechanism for charitable donations into the account, because when we were on the fighting fire, people came to our fire department looking to just give us money. And people felt the need to help out. They felt helpless. They wanted to help. So they would just bring money by the fire hall. This allows for them to put the money in a safe place like this account that can help pay off your neighbors' loans and things of that nature. This is administered by the Department of Ag. They must approve or deny within 24 hours. There's an amendment to fix that to 5 days. We'll get to that later. But it's quick, it's instantaneous. You go to the bank, if the bank participates in the program, there's a 2% origination fee, 1% paid by the applicant, 1% paid by the state to cover the bank's cost of administering the program. But your relationship, Mr. Chairman, is with your local bank. So that's where you'd go first to get help. The funding, we create a fund, $50 million allocated from the general fund, and the loan repayments go back into the fund. That's about it for that. I think I've covered everything else. There is a standing committee amendment. I wish we could read that in right now.
Senate File 195, Standing Committee Amendment Number 1, page 4, line 8, after.
And I'll move Standing Committee Amendment Number 1. to Senate File 195. What we came up with also is we wanted to include infrastructure failure. There's a specific dam in the central part of the state that is on the verge of failure. We wanted to be able to include that into this program as well, so to make sure that that's covered. So that's what the idea is here. You'll see it on page 4, line 8, after occurred, insert. For purposes of this paragraph, the government may declare a natural disaster for purposes of making loan available upon the failure of infrastructure, including but not limited to roads, bridges, dams, and irrigation infrastructure. So remember the big irrigation ditch failure on the good senator from Goshen County's area. This would have covered that as well. So I'll stand for questions on the standing committee.
Thank you, President Biden. And we are on Standing Committee Amendment number 1 to Senate File 195. Is there any discussion? Seeing none, all those in favor of Senator Biteman's motion that to adopt Standing Committee Amendment number 1 to Senate File 195, please say aye. Those opposed, no. Standing Committee Amendment number 1 to Senate File 195 has been adopted. We're back on the bill, and I know we do have a Committee of the Whole amendment, but let's go on the bill. No? All right. Anything on the bill before we go to the Committee of the Whole amendment? Seeing none, let's go to Committee of the Whole amendment. Let's have it written.
Senate File 195, Committee of the Whole Amendment number 1, page 6, line 6, delete.
Senator Biden?
Thank you, Mr. Chairman. I'll move Committee of the Whole Amendment number 1 to Senate File 95. What this does, it changes that 24 hours, which I get it. That was pretty ambitious on my part. I'm a doer. I like to get stuff done. But the department asked for 5 days, and by golly, let's help work with the department. They said they can get it done sooner, but they want up to 5 days to be able to make those decisions. The banks will determine eligibility through a certain set of criteria, credit score, collateral, all that stuff. They can do that real quick. It goes up to Department of Ag to disperse the loans, but let's give them 5 days. Hopefully it won't take 5 days, but stand for any questions.
Thank you, Mr. President. Any discussion on Committee of the Whole Amendment number 1? Seeing none, question's been called. All those in, my apologies, Senator Hicks, you are out of my vision over there.
Well, Mr. Chairman, I do appreciate the intent. In fact, this is the discussion that we had up in the Joint Ag Committee last fall, is about looking at some of these programs. But I have a number of questions associated, and I think the idea is good. I'm just curious about the mechanisms. I'm not aware of typically when we run these type of loan programs, Department of Ag doesn't do bank loan programs, and many of our state agencies, normally those run either through the state lands office, because they do a number of federal or the treasurer's office. Just a couple of questions on the mechanics as to why the Department of Ag, which is way outside their traditional things, would they be involved in all of a sudden? Because basically this is just a banking function of loaning money out. And so I don't understand why Department of Ag would be the ones doing this.
Yeah, we're on Committee of the Whole Amendment number 1, Senator Hicks. I was waiting to see if you were going to hit on that.
What's that, Mr. President?
We're on the Committee of the Whole Amendment number 1. I'm suspecting you're not.
Well, let me see here. I can.
Do you want to finagle it, or you just want to?
Roads, Mr. Chairman. Roads.
Roads,
Why
all right.
are we paying for roads?
We'll go ahead and take that final action, and then we'll get right back to
Hold that
speech.
last comment. I'll be back.
We're ready for you. All right. All those in favor of Senator Biteman's motion to adopt Committee of the Whole Amendment number 1 to Senate File 195, please say aye. Aye. Those opposed, no. All right, we're back on the bill. Senator Hicks, would you like to say anything about this particular piece of legislation, maybe with regard to the Department of Agriculture?
I'm on the bill, Mr. Chairman.
Back on the bill, good. Yeah,
Back
perfect.
on the bill. So, back to my previous comments, I'm just curious as why we would assign this duty to the Department of Agriculture when surely it's kind of outside of their normal function. The other thing is when we designate these, so the $50 million, anytime we designate this, they're called public purpose investments. And regardless of the amount of money, and you can go in there and there's a whole list of these that we do over the years from different accounts, but when you do that, that basically puts a hold on those money because the treasurer's office never knows when they're going to have to liquidate and spend that. So, and I think that's probably the reason you look at the interest rate is in the agency pool, because they literally just have to say, we can't invest this money for a higher rate of return because we don't know when it's going to be drawn upon. And so what they typically do is it's absolutely the lowest rate of return that you're going to get on investments. And so it's a concern of mine when we throw numbers out like $50 million that right now, if that was in the Permanent Mineral Trust Fund, would have generated 11.1% investment return last year versus something that they have to keep in a very, very liquid asset. So usually it's cash or it's very short-term US Treasuries because they never know when they're going to have to spend that money. So the more we designate on these accounts like this, the more that it costs us in investment returns. And I would remind you that's our third highest rate of return. The other question, and maybe it can be answered, is typically the federal government has a number of grant and loan programs for emergency disasters, and particularly it's administered through the Farm Service Agency, that when these type of things happen, there is federal disaster money available. Sometimes it's FEMA money, depending on the nature of the money. What happens if somebody gets grant money from the federal government and then also borrows against this? How do we know who's doing what, and if this is repayable, if the covered expenses they borrowed money for is covered by the federal government through any of those programs, through ag disaster loans and financing? So just a couple of questions, Mr. Chairman.
Thank you, Senator Hicks. Senator Salazar.
Thank you, Mr. Chairman. You know, I like this idea. I really do. This is quick action for our constituents who need it quickly, particularly in an emergency. They're not waiting 10, 11 months for us to come back into session when they need the money now to take care of their business, specifically small business. And you know, there are protections. They are going through a credit check. They are dealing with collateral. So this, to me, makes sense, particularly for our small business community that can't wait for months, whether it's a federal agency or the state legislature to take action. Here is an opportunity where we can help our small business constituents in an emergency without having to wait for months, because they need that help ASAP.
Thank you, Senator Salazar. Senator Scott.
Mr. Chairman, first addressing the concern on the rate of return in the permanent funds. In the past, there's been quite an overreaction of segregating funds for all the things that may happen. And they always have segregated too much, especially as the state has enough funds, you can do a lot with interfund borrowing. I would suggest that if that's a concern, there may be a simple second or third reading amendment that could fix most of that and tell them not to do that sort of thing. Mr. Chairman, then I have a question. On page 5, lines 1 through 8, it says these businesses have to have a person who owns not less than 50% of the business and can apply and be guarantor and have a credit score of 550. Mr. Chairman, there's various kinds of credit scores around. What is intended here? That's one question. Does this need to be further spelled out, or is it spelled out somewhere elsewhere in the bill that I missed? Second, think of your typical small family business, Mr. Chairman. And I'm worried about having somebody who owns 50%. Suppose you have a family business. Husband and wife owned it originally. They're passing it off to one or more children who are active in the business. That typical good estate planning in a successful small business. Or you have two families involved. You can very well get a family business where there is no one who owns 50% or more. It's all owned by various branches of one family. But you don't meet the 50% test for any one person. Is that a problem we need to consider? Because I think that provision may exclude quite a number of the small businesses in the state, Mr. Chairman.
Thank you, Senator Scott. Anyone before the president rises? Let's go to Senator Driscoll real quick.
Mr. Chairman, I'll probably pile on just a little bit. That the 50% deal, and I've seen actually in front of the state with this happen, is almost never can you go borrow money without either a corporate resolution or all the people agreeing. You know, husband and wives, you see cases all the time. Somebody goes out and tries to borrow money or gets it done, and then the other one's not liable for it anymore. So I think there's a little bit there. And then there's one other piece I think that will require an amendment, is on page 6, if you go to line 4, it says, upon receipt of recommendation from the institution, department shall, not later than 24 hours after receiving, which we've amended that recommendation, review. But you go on down to line 8, and it says, if you qualify, the department shall disperse funds. So really what it says is if you qualify for it, they're going to disperse the funds. And you actually need an amendment. I'm not doing it to kill the bill, but you're going to need an amendment that says if the bank doesn't think it's a good loan, even though you've met all the requirements, that you're not going to disperse the funds. And I think that's fairly important. But I like the idea behind it. I voted against it. I don't like the $50 million. I think we got better places for $50 million. These loan programs and these help are very necessary in a lot of ways. But I think we really need to go to an interim or something similar if we're going to go into this is a 1980s farm loan type program that the state had. We got into that when it was tough in the 80s. And I think it requires quite a bit more thought than we're doing here on doing it, and participation from the banks and the financial institutions to make sure the state's covered, they're covered, and we're doing it right so we don't get in a bind. I'd hope we go to an interim on this.
Thank you, Senator Driscoll. Senator Crum.
Mr. Chairman, I'm in favor of the bill. I just have a question on, these loans are going to be at low interest rates. Credit score of 550 is, you can't buy a house probably if you're not in the upper 600s. So 550 is not a high threshold. What keeps somebody from borrowing this money and then paying off a bank loan that maybe the bank's a little concerned about and shifting that liability over to the state? What keeps somebody from getting a low interest loan, maybe a good loan, and then just shifting the interest rate, moving it from up here down to here? What are the safeguards from some manipulation in the loan process? Thank you, Mr. Chairman.
Thank you, Senator Crum. Senator Beitman, that's a few. Sorry, we heaped them up.
Yeah, that's a lot. And if I miss your question, I'm sorry, because there's a lot there. I guess we'll work backwards. The bill, if you read the bill front to back, it specifies that you can't do that. You can't use this loan for anything other than purchasing the needed equipment, supplies, moving stuff around. You can't just package loans and pay off other things or use it to grow your business. The department shall promulgate rules to make sure that doesn't happen. Over here, we're talking about on page 6, right there, line 4, upon receipt of a recommendation from a financial institution, the department shall. So if the bank doesn't give the recommendation, there's no money dispersed. So that answers that question. As to the placeholder of credit score of 550 and 50%, so you can aggregate to get more than 50% if this is family business and you really want this. You don't have to participate, Mr. Chairman, in this program. You have to have something. You have to have a placeholder. So we said it, you got to be more than 50% of the business. If you guys want to monkey with that, go for it. The spirit of the bill is still there. The 550 placeholder, yeah, we can adjust that as well. But the idea is to open this up to as many people as possible prudently. They still have to put up collateral. And if the bank doesn't think it's adequate collateral, you're not getting approved. So if your credit score is 551 and you put up flimsy collateral and the bank says, no, they don't have to approve you. So you're done. That's it. The state's fine. So you can try to pick it apart. I encourage you to pick it apart, but honestly, I think we're in a pretty good place. And I would also remind The Sunshine State has a very similar program to this for hurricanes, and it works very well. And I modeled it after that as well. Once I started doing research on this, I saw that they did it, so why not do something similar to what they're doing? Why the Department of Ag? Because that's primarily who we're dealing with, is ag folks, and they know this stuff. And this is more or less just a place to disperse the money. Once the banks are gonna do most of the legwork, they're gonna be and they know the people. So if I forgot anything, I'm sure I'll hear about it. Thank you.
Thank you, Senator Beitman. We are on Senate File 195, Small Business Emergency Bridge Loan Program. Senator Scott.
Mr. President, page 5, line 1. Have a person who owns not less than 50% of the business. That language suggests to me that you cannot aggregate it. So I think maybe a second reading amendment is needed there.
Thank you, Senator Scott. Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a question about not ag. What about regular businesses? What about a commercial business? What about somebody who's wiped out by a tornado or some such event? Is there any preclusion of them being able to apply for said loans? I know we're talking about ag because we had the fire and people have lost a lot of assets, but this has to be broader than just ag. And I'm just wondering just how that would be addressed. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Senator Anderson.
Mr. Chairman, I'm going to be on against this bill. I have a lot of friends in Johnson County and Campbell County that have been burned out, and one thing they don't need is another loan. They're looking for grants, some way to put some animals back on the field, but they are up to their ears with loans, and they're not looking for more loans. This is a feel-good bill, but I'm afraid there isn't very many people that use it. Thank you. On and against.
Thank you, Senator Anderson. Any further discussion? Let's go back to Senator Beitman.
To answer the first question, page 2, at the bottom of page 2, the Small Business Emergency Loan Program is hereby created to provide short-term bridge loans to Wyoming businesses after declared disasters. Doesn't say ag businesses, applies to all businesses. And of course, everybody wants free money. That's not conservative and that's not financially prudent. And this is a sensible way to help people with 0% loans. It's not costing them interest, it's helping them out, but they still have to pay it back. It's not giving money away to private individuals. It's just giving people a chance. Thank you.
Thank you, Senator Beitman. Senator Hicks.
Yeah, Mr. Chairman, so I've got a question here, and it kind of gets back to have the person who owns not less than 50% of the business. So a real-world example we had not that far along in the past up in Fremont County is we had some flooding going on, and one of the major canals breached and blew out. But most of the canals are owned by canal companies. Now, there's different owners, and they're small businesses because they're small businesses incorporated under the bylaws of the state of Wyoming. They're specifically for the purpose of agricultural purposes. But the way I read this, I don't think that those canal companies would be eligible because, well, and maybe they are. They got to get 50% of all the canal company owners. But where it says individuals, I don't know, are those type of small businesses, canal companies, because of they have to be incorporated in the state of Wyoming as a business entity. I don't think they would be eligible for this program. I'm trying to make it, would they or would they not be with that existing language? And is that something that, if they're not, that we should incorporate, that those, and a lot of them are ditch companies. So you have canal companies, you have ditch companies. Obviously, districts are not going to be involved in this loan. It's more specific for those private entities. But just a little conversation or clarification on that.
Thank you, Senator Hicks. Vice President Salazar.
Thank you, Mr. Chairman. You know, I wish the state had oodles and oodles of money to give to everyone so they wouldn't have to take loans. But the fact of the matter is that we don't have that kind of money. But at the same time, we want to come in and help small business at a critical time when they need to immediately get back on their feet and do business. This is an alternative. But to give free money to every single emergency without any type of repayment, I think is a bridge too far.
Thank you, Mr. Vice President. Mr. President.
Okay, back, everybody's hung up on the 50%. Don't know if it's just a debate tactic or what, but look up the definition of person within the realm of the business world, and it includes corporations, other companies. Term person applies very broadly. Shouldn't have to be having this discussion. Everybody knows that. I'll leave it at that. We'll call for the question.
Thank you, Mr. President. Further discussion? Question's been called. All those in favor of Senator French's motion that when the committee of the whole rises to report, it do so with a favorable recommendation on Senate File 195, please say aye. Aye. Those opposed, no. Senate File 195 has passed the committee of the whole. Next bill for your consideration is Senate File 197. Will the reading clerk please read the Senate file?
Senate File 197, Wyoming Generational Investment Account 2, an act relating to the investment of state funds, sponsored by Senator Driscoll. It was referred to Committee Number 2, which returned a committee recommendation that it do pass amended. Ayes, Senators Driscoll, Guru, Larson, Salazar, and Smith. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Salazar?
Thank you, Mr. Chairman. Mr. Chairman, I move that when the committee of the whole rises to report, it do so with the recommendation that Senate File 197 do pass, and with that, I will call on Senator Driscoll.
Thank you, Senator Salazar. Senator Driscoll.
Chairman, thank you. Amendment, we have the amendment read in.
Senate File 197, Standing Committee Amendment Number 1, page 3, lines 19 through 21, delete.
Senator Driscoll, back to you. And we can have if you want to work that, feel free. If you'd rather have the Appropriations Committee work it, we can go back to Senator Salazar. Or you are Appropriations, I guess, so up to you.
Thank you, Mr. Chairman. I probably will not work the amendment. I'm probably going to.
Okay, we'll give it back.
Work it. I haven't got it tracked in good enough to do it, to be honest with you.
All right, well, let's have you do the bill then.
Thank you, Mr. Chairman. I bring to you Senate File 197. It's a little bit misnamed. It's the Wyoming Generational Investment Account 2. Actually, what this bill should be called is the Personal Income Tax Killer Bill. Because what this really does, folks, is when you look back at the PMTF, the Permanent Mineral Trust Fund, it now generates about 30% of our general fund income. And what this actually is, folks, is it creates another fund very similar to this, that is actually on a longer horizon even than the PMTF is. And what that means is when you go to a little longer horizon, and by longer, I'm talking 20 plus years, actually going out close to 30, your returns that we've been getting, we start talking about 7 to 10% returns, they run 4 to 5% higher when you go into that time frame. So you start, when you get into the rules of 7 on the compounding, it gets pretty wild what it can do. So what this really does is you take money and you put it in yearly into the fund, and it's, as you go into page 2 on it, we create a statutory trust. This is not a invalid, it's a statutory trust. And you put it in, and it's anticipated to put $100 million in it to start with. You'll be seeing an amendment come that will delay that somewhat or whatever because of where we're at. The amendment also will ensure that 100% of the money that goes into this fund is not tax money, it's investment income. So really what we're doing is reinvesting the state's proceeds on income. So it's exactly what we're doing now that we spend that money. It'll make it going further out. So as you work your way through it, you fund it done. Consists 85, bottom page 2, 85% private equity, 15% private credit investments. Adopt the investment policy statements of the account. The board seek to preserve the balance of the account in a manner that strives for the highest possible risk-adjusted total net return. So that's really what we're doing. The entire process of doing this fund is to get that next level up. On line 9, begin on July 1, 2025 annually, and on each July 1 thereafter. That's the amendment will deal with till July 1, 2055. That's a 30-year time frame. State auditors will transfer $100 million, or is there as much available? So if it's not available, it will not go in from the LSRA account, which it will not come from that. It's actually, the amendment's going to move that. So I'm just ahead of time. To the Wyoming Generational Investment Account. Transfer under this subsection will occur only after all other transfers and appropriations, the LSRA required by law are made. So if we don't have money, it doesn't go in there. Line 19, transfers under subsections, this section, investment transfers shall be in accordance with the following. This is kind of, you're getting into the meat of it. Page 4, separately account for each annual transfer under it, which that's your statutory trust. Annual transfer shall not be withdrawn for the account. 3 I's, investment earnings from the annual transfer shall not be withdrawn except in accordance with subsection E. Subsection E is after year 30. So we're actually investing money, folks. It's a little like your IRA or whatever. We're not going to draw on it. It's going to draw interest pulled together. And after 30 years, 37.5% all investment incomes in generational account, rising from the transfer made for the 30 years earlier deposited in the general fund. All remaining investment earnings shall remain in the Wyoming Generation Investment Account for continued investment in accordance with subsection B. So the account continues to go on. This 37.5% that comes in would probably, the way it looks, basically fund all our school or our capital construction on the schools. So what this really is, and that's why I say it's an income tax killer, is really we've got to figure out long-term how we're going to fund some of this stuff down the road, all of us. We've got money now, we can see it out for a while, but if you look at our profile, there's almost no doubt that we're going to run short. You're going to have to come up with money somewhere else. This is a pretty unique way to do it, that you actually put money away to go ahead. It's what everyone does with a whole lot of end of it. So on page 5, investment earnings be distributed under this section 30 years after the initial, 30 years following each of the respective contributions. State treasurer may liquidate or sell investments according to the fiduciary obligations with the investments. Not later than November 1 of each year, the state treasurer will report to the Appropriations Committee and Select Committee on Cap Fin investments regarding the investment of funds in the Wyoming Generational Account. That's basically the long and short of it. I hope you can grasp the concept of it. It's, you know, really investing for the future. It's always painful to do that. We always can find a place to spend our money. But when you look back on the PMTF, where would we be today if we wouldn't have done what we did there? This really does for the next generation what the generation before did for us. With that, I'd ask for one of my members to track in the amendments, and I'll stand for questions.
Thank you, Senator Driscoll. All right, we are on the amendments. It looks like Senator Grew is on the amendments, and it has not been moved, if you would do that.
Yes, I'd like to move Standing Committee Amendment number 1 to Senate File 197 and ask for your favorable consideration. Ladies and gentlemen, Mr. Chairman, what this amendment does is merely track it in. When we talked about this bill in committee, it was talking about taking the $100 million a year from just basically the LISR or the general fund, wherever. This amendment changes that to the first 100 million of our investment earnings each year. So take any year, take this next year, possibly. It's been discussed that we have $300 million, say, in unrealized interest income in our investments. The first 100 million then would peel off into this account, and the other 200 million would go to the general fund. That's basically what this amendment does. What it does is take it out of any general fund, anywhere else that it was before, and just take it right out of our direct investment earnings. And I'm looking over across the room to one of the folks that helped craft this amendment and see if he might want to elaborate on that further. But that's basically what it does. And with that, I'd ask for your approval on this good little amendment on this great bill.
Thank you, Senator Grew. Any further discussion on Standing Committee Amendment number 1? Senator Case.
Sorry.
Senator Case just coincidentally stood up. All right. So no further discussion, I'm gathering. All those in favor of Senator Guru's motion to adopt Standing Committee Amendment Number 1 to Senate File 197, please say aye. Those opposed, no. Standing Committee Amendment Number 1 to Senate File 197 has been adopted. We are back on the bill. Discussion on Senate File 197, Wyoming Generational Investment Account. Over to Senator Guru.
Thank you, Mr. Chairman. Folks, I say this a lot, but I'm not joking this time. To me, this is the bill of the session. Back in the 60s, a governor took the oath of office out front, walked into the office, sat down, his chief of staff walked in, said, "Governor, congratulations. We have $465 in our general fund." We were broke. With the help of legislators, people of great vision, that governor and governors who followed, set up the PTMF. Today, due to the hard work of legislators, elected leaders, governors, treasurers across since that time, today we have $31 billion in our investment accounts that fund over 30% of the general fund. 30% of our general fund come from those investment earnings. It's a legacy that makes us proud. We even named a scholarship fund after the fella and helping school children to this day from the money that was generated from that. This bill, Bill 197, creates what I think is the next generation of that type of return, where we take a portion each year of the income that's being created from that fund and put it into a fund that's inviolate, that holds for over 30 years. And in that time frame, in a 21-year time frame, which is really not that far when you think about it. We all think about 5-year rolling averages. And when we're talking about investment income and talking about all this stuff, whether it's in cap fin or appropriations or alike, this is a time frame that's not that far of a horizon where we could fund every need for schools, a capital construction, as far as the eye could see. The good bringer of the bill called it an income tax killer. I think it's even more. I know it's a bit, it's a bit far-fetched to think about these kind of numbers and these kind of dollars. But members of the 68th, I am convinced other countries in the world are using this fund. Countries around the world, few are using this, and they're using it and it's working well. And if we can pull this off, if we could get past kind of the short-term nervousness about such a bill, set it up correctly, monitor it correctly, we can have a fund that could take care of our needs and really be able to tell the citizens of this state that we don't need your tax dollars. We don't need this. We can fund state government with this. This is something that could be a game changer for this entire state. I urge you, if nothing more, let's continue this discussion. Vote yes on this bill. I think it's the right thing to do. Thank you, Mr. Chairman.
Thank you, Senator Guru. Senator Landon.
Mr. Chairman, thank you. My friend from the tower has led me down some paths that have gotten me in some scrapes before, but when he showed me this thing, folks, I agree with the previous speaker. This one has a chance to be one of the biggest things we've done in this session, maybe in the last few years. One of the hardest things I've found in my long time in the Wyoming Senate, one of the hardest things is to save money. That's the toughest thing. This time around, we're down here and we're spending some that we've saved. That's because we saved it and we have the ability to give some of that back. And that's all well and good. But this right here, this is a game changer. And some of you might think, well, heck, 20, 25 years down the road, we're not gonna be around. You know what? You might surprise yourself. I didn't think I'd be here 20 years, but here I am. This is really big. And I hope you'll support this bill. I think, maybe we can work it as it goes through, but this one has a chance to be really, really special. Thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Salazar.
Thank you, Mr. Chairman. Not on or against this bill, but I want the chamber to understand this is an investment of $100 million every year. Every year, $100 million. I understand the power of compounded interest. With all due respect, I'm not sure any of us are going to see this in 30 years. But again, I'm not speaking for or against the bill, but I want everyone to know it is an investment of $100 million every year.
Thank you, Senator Salazar, Senator Kolb, and then Senator Anderson.
Thank you, Mr. Chairman. Well, to the good speaker from the windiest city, I hope I can remember who I am in 30 years. Now, that all being said, in the beginning of the session, I thought back about, the PMTF and just how it came about. And I thought, it's really a tremendous thing that they had that much foresight to create that fund, which has given us a situation where we can fund the state with 30% less tax money. And it is a big choice, but sooner or later, we're gonna have to work on the Wyoming retirement account. And I kind of consider the PMTF and this as being one of those things. Will it make the income tax, or no income tax or less than taxes? It certainly will. Will it ever go to zero? I don't know. But I do know with this, in this direction, it will certainly make it a lot less than it would have been without it. So I think these things do take foresight, and you're gonna have, both sides of the argument is, what are we doing? Well, I think we're ensuring the future of the state of Wyoming. Now, is the $100 million the right number? I don't know. But I do know putting it in a more inviolate account to ensure people getting, I don't know, wanting to spend that money because, well, it's easy, it's sitting right there. But this has ramifications for generational wealth, not just, I don't know, today we're gonna put some money aside for some natural disaster we have, whatever be the current case, or is gonna have something that's unforeseen for the future. This is in fact a way of safeguarding a better future for Wyoming, safeguarding what my grandkids and your grandkids and their kids would be benefiting from. So I think it's certainly something that I am supportive of. I realize, it's going to have some changes that we're going to have to expend differently because we won't have the money to expend in another way. But this ensures a better future for Wyoming. It ensures a retirement plan for Wyoming because we're not always going to have minerals. We all know that. Who knows what's going to happen with the federal government and whatever they do or don't do in the future. But I do know this is a good choice for a more secure future for Wyoming on and for the bill. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Senator Anderson?
Mr. Chairman, I have a question that I'll get to, but I'd like to talk about that permanent mineral trust fund. It's kind of a fun story. There was a fellow running for a Democrat governor candidate, and his platform was to establish a permanent mineral trust fund. And the Republicans that were running against him just attacked it terribly and defeated him. And he went down in defeat, and we've got Governor Hathaway. That year, 1966, he came to Boise State, and some of us were there, and he bragged about how he was going to get a permanent mineral trust fund. And he did. He got it put through the legislature, which was really good that he got that done. My question is, on page 3, we asked for the auditor to put that $100 million in there. Is that some kind of mechanism that works? Why isn't it the treasurer that's putting that money in there? I believe it's on page 3 down there where it talks about the $100 million.
Thank you, Senator. Senator Ide.
Thank you, Mr. Chairman. Yeah, just a question, not on or for the bill. Not sure what the parameters of the generational fund are. Account number 2, equities, bonds. Is there any room in there for a little bullion, a little gold? Thank you.
No, I didn't see it coming. All right. Thank you, Senator Ide. Let's go to Senator Driscoll to answer a question, and then we'll go to
Mr.
Senator
Chairman,
Scott.
I'll answer that last one first, and it's easy as the answer is absolutely yes. The treasurer is directed to find the best return he can. So, he uses all the parameters he can to invest the best he can, but that's the whole idea on the long-term deal. If he thinks that bullion or Bitcoin or whatever it is there, and the investment team thinks that over a long window, and that's the key with this whole end of it, is the long window they think is at least a 5% better return on it. When you start running into that with numbers, you get there. Back to the good man from Bitter Creek, exactly what he talked about. He asked about the 100 million, is it right? That was the number the treasurer thought actually what it would take to get into these sovereign wealth type funds. And that's really, you have to get into bigger numbers. Answering the last question there's two more. One, the auditor's who writes the checks. So everyone we get into, the auditor's actually who writes the checks. You know, when we do money, you look at it. Back to all you budget hawks, interestingly enough, when we do things like this 100 million a year, it profiles the spending, folks. So everybody's going to come to you and say you're spending way too much money, because that's how we profile it. When that auditor writes the check, it shows that we spent the money. We actually put it into savings, but we spent it. So this really it's been hit all the way across the board really well. This is transformational for Wyoming. I didn't steal the thunder of the good senator from up by the park, because I knew what he was going to say, and I really wanted to say it ahead of him. But I didn't want him to shake a broken arm at me. So this is really a good one. It makes sense. Oh, the very last. What happens if we don't have the 100 million, if we hit bad years? And that's covered in there. It says if we don't have the money, it does not transfer. So you might go years 1 through 4 and then have 2 years, 3 years that you don't put anything. And if we don't, we still have our tips. What this does, and for all you budget hawks, it's going to make it where we're not going to spend $100 million a year on something maybe you don't like. We're going to put $100 million away for the future of our grandkids and our great-grandkids. It's not going to be me. I'll guarantee I wasn't around in Boise State in '56. I wasn't even a good twinkle in the eye yet then. 66. But this is going to work the exact same way for our grandkids and great-grandkids. They're going to say thank you to you that someone had the thought to think ahead.
Thank you, Senator Driscoll. Senator Scott.
Mr. Chairman, regarding the story that was told about the origin of the previous attempt in this area, the Permanent Mental Trust Fund. Mr. Chairman, the moral of that story is one of the principles of good legislation. When you find a good idea, steal it.
Thank you. Thank you, Senator Scott. Yeah. And I hear the question called on that closing note. All those in favor of Senator Salazar's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation on Senate File 197, please say aye. Aye. Those opposed, no. Senate File 197 has passed apparently unanimously the Committee of the Whole. Next bill for your consideration is Senate Joint Resolution 10. Will the reading clerk please read the joint resolution?
Senate Joint Resolution 10, Legislative and Executive Authority, Taxation and Spending. A joint resolution, a joint resolution to amend the Wyoming Constitution to specify that the power and control of taxation and spending belongs to the Legislative Department and the Executive Department as specified. Sponsored by Senator Larson. Was referred to Committee Number 3, which returned a committee recommendation that it do pass amended. Ayes Senators French, Ide, and McEwen. No Senators Case and Pappas. Senator McEwen, Chairman.
You've heard the reading of the Senate file, or the joint resolution for that matter. What is your pleasure? We should probably have Senator McEwen. Yeah. Senator McEwen.
I move that when the Committee of the Whole rises to report, it do so with the recommendation that Senate Joint Resolution 10 do pass. And I will turn it over to Senator Larson.
Thank you, Senator McEwen. Senator Larson, to you.
Thank you, Mr. Chairman. Can you read in the amendment? Standing Committee Amendment?
All right, let's read it in.
Senate Joint Resolution 10, Standing Committee Amendment Number 1, pages 3, lines 8 through 12, delete.
Go ahead, back to you, Senator Larson.
I move Standing Committee Amendment Number 1 to Senate Joint Resolution Number 10 and ask for your no vote. It was my mistake that I put that amendment to the committee, and I can explain on page 4. I didn't read my bill very good. And page 4, page 3 has a bunch of blank there. And so I didn't think there was any more to the bill when I went to the committee. Anyway, please vote no on that standing committee amendment, because it's all on page 4.
Thank you, Senator Larson. Do you want to get that vote now? All right. So we're working standing committee amendment number 1. Does anyone want to rise to that before we call for the vote? Seeing none, everybody seems comfortable with that. All those in favor of Senator Larson's motion to adopt standing committee amendment number 1 to Senate Joint Resolution 10, say aye. All right, we had one defector. All those opposed, no. Standing committee amendment number 1 to Senate Joint Resolution 10 has failed. Back on the joint resolution, Senator Larson.
Thank you, Mr. Chairman. I will just go brief on this. This is just a joint resolution I kind of stole from somebody, and it was maybe the last one to speak on our last bill. I think it's a good amendment, or a proposal that we take this to our citizens and ask them their thoughts. Mainly, I'm just going to read the back part, which would be on page 4, which would be on the ballot if we did go forward with this in 2026. Page 3 is pretty simple. Wyoming Constitution divides the powers of government into 3 branches: legislative, executive, and judicial. No branch shall exercise any powers properly belonging to the other branches unless the Constitution expressly permits that. But the meat of it comes on page 4, and I'm just going to read it. You can all read it too. This amendment would expressly provide that the power of the taxation and spending belongs only to the legislative and executive branches of the state government. The amendment would allow the legislature to delegate taxation and spending authority to political subdivisions, and would allow the legislature to delegate ministerial tasks to the executive branch, with the judicial branch authorized to enforce the performance of those delegated duties. The meat of the bill is now, for funding operational costs of public schools, the legislature would be required to develop a funding formula, which would be subject to judicial review, which we already have. The amount of any appropriation based on the formula would not be subject to judicial review. If the legislator's appropriation is insufficient to fund the spending provided by the formula, then the expenditures for the school funding would be reduced uniformly. I think it's time for us to take control of our legislative branch. We shouldn't be told by another third-party branch on how much we have to spend. If we don't have the money there, I think in a couple years or more, it's going to be very, very difficult for us to come up with all the money to fund our schools. So that's the question. I'd be open for questions.
Thank you, Senator Larson. Discussion on Senate Joint Resolution 10. Senator Hicks.
Yeah, Mr. Chairman, I'm trying to figure out with this, when I walk through, just what problem are we trying to cure here? And so when I read this, what it looks to me like, this is a vast expansion of the executive branch, particularly when it talks about executive branch agencies. Are we really going to give constitutional authority to executive branch agencies? Most of this we already do or have the legislative ability. When I read, and it's just the formatting, is we've also expanded judicial review now. And so when I look at this, we've expanded the authority, and I'll point out a couple of places just so I can be specific, maybe we can have some discussions. So when you go into page 2, and you go right up there and you go to line 4, 5, and so it says the power of the taxation and spending is reserved to the people in the legislative department. We already have that. we're the only ones that can pass taxes. But then it says, and the executive department. Well, executive department probably is much larger than the chief executive, which is the governor. And so I worried about that, and now we're giving the governor some taxing authority or spending authority, either one, which is already relegated under our Constitution to the legislative branch. And so I worry about that language. And then when we get down, we talk about more on the debt service. The legislature may delegate by payment of debt service and the establishment of tax rates to accomplish that service to the executive branch as an administerial task. I'm not exactly what we're trying to get to there. We've set up above that the executive has taxing and spending authority, and now we're going to relegate that down there. But the other part that worries me about that then, and then it says the judicial department may enforce the performance. That's kind of outsourced the normal function of the judicial department to go in and enforce those type of actions on an executive branch agency. It's the separation of powers issue that I worry. Now we've granted more authority to the executive or the judicial branch of government to now make sure that the executive branch of government is administering their ministerial activity for their taxing and spending authority that we've granted above that. And so I think I understand the intent of the author, but it becomes circular in a number of places. And then here's the one that just kind of scares. If you go over to page 2, and you go down on the line 22, and it says the legislature shall fund the formula by appropriation. The amounts of this appropriation shall not be subject to judicial. That puts an absolutely duty that once we pass that formula under our Constitution, we don't have no discretional ability as to make a determination. And the scary part of that for me is when we get over to the back part, where it brings us back in. And so let me get to the page number. So if you go to page 4, and you go down to lines 12, and you go to the last sentence that starts with, if the legislature's appropriation is insufficient to fund spending provided by the formula, then the expending for the school funding would be reduced uniformly. We already have that statutes. That's already there. But if we put this in the Constitution, my concerns is who determines what insufficient amount of money is? So is it the entire general fund, or is it just the common school permanent land fund? It's a very dangerous position to give judicial review now to make a determination of what constitutes insufficient funds to fund a model. And I'm afraid, folks, that provision there would just be fair game to come in and have the courts come in and say, well, we don't care how much money you have, raise taxes. It's insufficient, right? So you have to raise taxes under this potential constitution, or we're just going to gut every other function that government has. And so I think that provision swings the door wide open. I'm all about constraining, government expenditures, but the way I read this expands executive and judicial power into areas that are already restricted under the separation of powers. And so, again, I like the intent, but constitutional amendments really do words matter. And there's a lot of what I see circular language in here that gives me pause for concern. So I just wanted to articulate those and get them out there for discussion.
Thank you, Senator Hicks. Senator Scott.
Mr. Chairman, responding to that, frankly, I think that the amendment is not being read carefully enough. Let me go through it specifically. Power of taxation, spending reserved to people in the legislative and executive department. The executive department does have a function, and it's known as the veto and the line item veto. So that's what's, you have to include them there because they do have a role. The governor has a very, very specific role in the Constitution. With regard to the language at the bottom of the page, in the event the appropriation insufficient to fund the spending provided by the formula, spending shall be reduced by a uniform percentage. That is an instruction as to what you do. You can't have a court order to say you got to spend more. You got to reduce. If it's not, the appropriation is insufficient to fund the formula, you got to reduce the spending by a uniform percentage. Meaning if there's needs 10% cut, every district takes a 10% cut. Every item takes a 10% cut. Read it carefully. Frankly, and then the question was raised, Mr. Chairman, what's the evil we're trying to correct? As it stands right now, Mr. Chairman, the problem that this deals with is there's widespread belief within the educational community that the court has ordered us to spend as much as they want on education. And that is a widespread belief. This amendment would put a stop to that belief. That's the practical effect on it this time. If it was brought, if the judiciary ever ordered us to spend a specific amount, then this would be the mechanism to overturn that. They haven't done that, Mr. Chairman. I don't think they're going to. Because I think basically what this amendment does is spell out the current division of constitutional powers. And so I think if it's read carefully, it doesn't do any more or less than that, but it does clear up a fair amount of confusion. So, and I'd be happy to talk offline to anybody who still is a little uncertain of that, and we can go through it in some detail, Mr. Chairman. But the amendment does what it's intended to and provides the restraint. I think it's a interesting question as to whether we ought to take that to the populace at this point or whether we ought to rely on this is already basically what the Constitution says, and we don't need an amendment at this point because nobody has really stepped out of line at it. The good part of the educational establishment is confused about it, and this would clear that up. But is that worth a constitutional amendment at this time, Mr. Chairman?
Thank you, Senator Scott. Further discussion, Senator Ide and then Senator Landon.
Thank you, Mr. Chairman. My good friend from over the mountain there said a few things that made me want to stand up. I think it is a little unclear, and that's why I'm in favor of codifying this into law. It gives the legislature the authority of taxing and spending and allow the legislature to cut public school spending without lawsuits from a third branch of government. I think they kind of legislating over there on the school stuff. So I'm in favor of codifying this and getting it on the ballot. Thank you, Mr. Chairman.
Thank you, Senator Ide. Senator Landon.
Thank you, Mr. Chairman. I'm having some of the same queasiness that my friend from the southern part of the state. We're talking about amending our Constitution. And we're throwing that around a lot lately, more than ever. And folks, I get pretty queasy when you start saying, I'm gonna amend the Constitution. It's been really good to us, folks, and I would just caution on this front. But we already have the statutory authority to do all this. And speaking to the point that was made that, boy, we need to codify this. Well, it's already there, and we just have to have the courage to run it up the flagpole. And you know what? I think we can win some of these. And who knows? We may win the one that we're in right now. I'm interested in the way this is constructed. We use the word department and executive branch in the same paragraph. I'm not sure what that means. And I also have never seen where we want to do this, and then it says in here that the Secretary of State shall endorse this. What would a Secretary of State have to do with this? I don't understand that section. I'm just curious about the drafting. I feel just like my good friend up in the front of the room, it just feels pretty circular. Thank you.
Thank you, Senator Landon. Let's go to Senator Hicks, and then we'll go to Senator Larson.
So to my colleague from Natrona County, if you go back to the power of taxation, so go to page 2, line 2. And so you're right, governor can line on veto. He presents his budget to us, it goes to the Joint Appropriations Committee. I am not aware of anywhere, and I'm asking the question to my longest serving colleague in here, if somebody can show me where the governor has the power of taxation, I've never seen that anywhere. And that really worries me about giving the chief executive the power of taxation. As far as the provision to reduce expenditures, it's already in statute. So when your LSRA, your Legislative Stabilization Reserve account, gets to $500 million, we no longer backfill the school foundation program. That's in statutes already. We don't need to put that in the Constitution. That triggers an automatic reduction, prorated across the entire model for all 48 school districts. We don't need the constitutional amendment. We've already got that in statute. $500 million, when that LSRA hits that number, it causes the superintendent of public instructions, because we're no longer going to backfill schools at that point in time. We've already got that in there. We don't need a constitutional amendment to be able to do that. So again, to question on giving the governor the ability to set taxes is a little question I have from my colleague.
Thank you, Senator Hicks. All right, let's go to Senator Scott, and then we'll go to Senator Larson.
Mr. Chairman, 2 things. Easy one first. Secretary of State shall endorse the following statement of proposed amendment. Mr. Chairman, that's the standard language for telling the Secretary of State to put the ballot language on the ballot. It's been a provision in every constitutional amendment at least since the formation of the LSO and standardization of such things. Don't misread that, Mr. Chairman. Second, with regard to the ministerial functions of the executive branch, if the state were to borrow, and there are provisions for the state to borrow money, that were going to be paid off with a mill levy, you would need that language. The executive branch would set the mill levy to get what you need to service the bonds. That's what the executive at the county level does ministerially every year. If there's a bond outstanding in the county, you set the mill levy to recover what's needed. That's what's going on there and nothing more. So, Mr. Chairman, on and for, and I do think maybe codifying some of this, I think we've got a bill coming through that might be a good place to codify some of this. Would be a good idea, Mr. Chairman. I think for now, let's go ahead and pass the amendment.
Thank you, Senator Scott. Senator Larson.
My good senator that kind of prodded me a couple years that maybe this ought to be brought. Well, I think he answered all the questions for me, pretty much. There is one that was very simple. Up there, we're referencing on page 2, line 3, where we talk about legislative department and executive department. That's actually language from the Constitution. So I was ready to get that out of there also, but I think we ought to follow what's in the Constitution already, paragraph above this one, if we got it passed. So I'd urge an aye vote.
Thank you, Senator Larson. Any further discussion on Senate Joint Resolution 10? Senator Crago.
Thank you, Mr. Chairman. I guess just want to point out that this language is going to create all sorts of inconsistency within our Constitution. And I think we're going to have to figure out which section overrides. And if it's the intent that this section proposed section overrides every other section, so be it, but I think we're gonna have to put language in there. For example, you go to Article 3, Section 35, except for interest on public debt, money shall be paid out of the treasury only on appropriations made by the legislature. There's no mention of the executive branch. So we will be creating some sort of inconsistency there. Section 33, right above that, all bills for raising revenue shall originate in the House of Representatives, which we all know that rule. No mention of the executive branch on that. And then I think it's also going to create some sort of, I guess, inconsistency in Article 7, Section 1, the legislature shall provide for the establishment and maintenance of a complete and uniform system of public instruction. And it goes on. And so I just think we're going to create all sorts of inconsistencies, which is fine, but we're going to need to create some sort of, I guess, order of operation, which section is going to control. So if this passes or moves out of the committee, I think we need to think about an amendment. Thank you, Mr. Chairman.
Thank you, Senator Craigo. Further discussion? We're on Senate Joint Resolution 10, Legislative and Executive Authority, Taxation and Spending. No further discussion. Question's been called. All those in favor of Senator McEwen's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation on Senate Joint Resolution 10, please say aye. Aye. Those opposed, no? No. Chair is in doubt. Those in favor of Senate Joint Resolution 10, please stand. Nine ayes. Those opposed, please stand. Does appear to be more than 9. Twenty noes. Pursuant to Senate Rule 6-5, having failed a standing division, a roll call vote is required. Will the reading clerk please call the roll?
Senate Joint Resolution 10, Committee of the Whole, roll call. Anderson? No. Barlow? No. Boner? Aye. Brennan? No. Case? No. Cooper? No. Craigo? No. Crum? No. Dockstetter? No. Driscoll? No. French? Aye. Guru? No. Hicks? No. Hutchings? No. Ide? Aye. Jones? No. Kolb? No. Landon? No. Larson? Aye. McEwen? Aye. Nethercott? No. Olson? No. Pappas excused. Pearson? No. Rothfuss?
No.
No. Salazar? Aye. Schuler? No. Scott? Aye. Smith? Aye. Steinmetz? No. President Beitman? Aye. Closing vote? Closing. Vote closed. Senate Joint Resolution 10, 9 aye, 21 no, 1 excused.
Senate Joint Resolution 10, having failed a roll call vote pursuant to Senate Rule 6-5A, is deemed indefinitely postponed. Next bill for your consideration is Senate File 174. Will the reading clerk please read the Senate file?
Senate File 174, Constitutional Apportionment, an act relating to state legislative districts, sponsored by Senator Driscoll, was referred to Committee Number 7, which returned to committee recommendation that it do pass. Ayes, Senators Boner, Case, Dockstader, Landon, and Steinmetz. Senator Case, Chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Case.
Mr. Chairman, I move that when the Committee of the Whole rises to report, that it do so with a do-pass recommendation On Senate File 174, Constitutional Apportionment 2. And for explanation of the bill, I ask you to call on the sponsor.
Thank you, Senator Case. The sponsor is Senator Driscoll.
Thank you, Mr. Chairman. I bring you Senate File 174, Constitutional Apportionment 2. I don't have a fancy catcher's one for this one. Folks, what this is this came out of a bunch of my constituents that have had this for a long time. For those of you that have been here for quite a while, I'm looking at a smiling senator from the center of the state. Wyoming Constitution's really clear, folks, and the guys that wrote it were very clear about it, of what they wanted. And so if you go to the first part of the bill is just definitions, basically, and explanations. So it says drives power from the Constitution, acts must be conformable to it. Legislature's creatures of the Constitution goes on through. Really, when you get into it, you go to page 3, and here's what's in our Constitution. And folks, that's still here. You'll hear a lot about Supreme Court decisions and cases and following the end of it. I truly believe in that. But what the group and myself, I believe, is either we should follow our state constitution or amend it. So what it says in the Constitution right now, each county shall constitute a senatorial and representative district. Senate and House representatives should be composed of members elected by legal voters. The counties respectively every 2 years shall be apportioned among said counties, may be according to the number of their inhabitants. Each county shall have at least one senator and one representative, but no time shall the number of members of the House of Representatives be less than twice, nor greater than 3 times the members of the Senate. And goes on to Article 3, Section 48 of the Constitution. First budget session, legislature following federal census, legislature to reapportion membership, goes on through it. So we all went through that this year. Few of us didn't in here, but everyone did. We know the one man, one vote ruling. They're not trying to turn anything over. And by they, I'm talking me and with a group of my constituents. They're not trying to turn anything over. What they're saying is, we really, during the interim, and as you go into page 5 on it, here's what it really says. Legislature shall make a good faith effort to apportion itself as required by the 14th Amendment to the Constitution with the principle of the vote of any citizen, approximately equal in weight to that of any other citizen. I make a good faith effort to apportion itself as required in Article 3, Section 3, and 48 of the Wyoming Constitution by providing for legislative districts to follow county lines, and legislative districts have at least one representative, one senator per county. Section 3, Management Council, Wyoming Legislature shall assign a committee of the legislature to study apportionment of legislatures provided by this act. During the 2025 interim, the assigned committee shall conduct meetings in communities around Wyoming and take input on apportionment options from members of the public and other interested stakeholders. Committee shall report its findings to the legislature no later in December 2025. Committee on Management Council may introduce legislation to constitutionally apportion legislature for introduction in 2026 budget session. Folks, this is really a good common sense piece of legislation. If you remember last year, we didn't follow what our Constitution says. We had a chance to pretty much follow county lines. We chose not to. We not only did not follow county lines, we added a senator and 2 representatives and still stayed out all the way around. Apportionment was, I've been through 2 of them. I actually will go back 3 for you. If you want to go back 3, we've had 2 lawsuits out of the last 3 apportionments. They're always contentious. We really don't have much for sideboards in the legislature as far as how we go about our redistricting. And I represent to you, it would help all of us to take a good look, both forward and back, do a no harm look at it. They may come up with nothing, but we may come up with some sideboards that more follow our state constitution and the federal court rulings. And if not, I represent to you, we probably should change our state constitution to conform to what we're doing today. I tend to agree with anybody. The courts, I understand the rulings and I stand behind them. But it makes no sense to leave our Constitution standing against federal court rulings and the federal Constitution. So I think this makes sense. I think the the best time to look at redistricting is not in the year you're doing it, which I found that out by the fire. I chaired the committee, and I can tell you this, I took a drubbing like I've never had, trying to figure out how to be fair in reapportionment. And I can guarantee I did. I looked at everybody. I tried to look at all sides of it. We had no sideboards, and so what we actually had was a classic wrestling match on the committee that was incredible. And I mean, we traveled the state, we listened to people, and we did it. So I think this is common sense to see what can we come up with that leaves reapportionment next time being more fair and have better sideboards. Do we want county lines? Don't we want county lines? How do we want to look at our representation and how take a look at it? This is common sense to do now. I'd ask for your favorable consideration and stand for questions.
Thank you, Senator Driscoll. Discussion, Senator Landon?
So the moral of that story is, be careful which committee you ask to chair, because you might get torn apart doing it.
Yeah.
So, no, I just wanted to commend the sponsor for bringing an issue that I thought we had a really good discussion in committee, Mr. Chairman. And frankly, I rise in support of the bill because I really see no harm in us putting some energy into this and taking a good, hard look at it. At a time when we don't have it staring us in the face in the next few months, for example. Having served on that conference committee last year, I can tell you that we didn't get really what we wanted over in the western part of the state. We didn't get what we really should have had and wanted up in the northeast part of the state, and we sure didn't get what we wanted in my district. I maybe gave up the most square miles of anybody. So, but we arrived at something we could kind of hold our nose and vote for. That's probably not the best we could have done, and maybe this is going to net some better results. I think it's worth passing this bill and moving that to our management council to decide how they want to go from there. So thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Scott?
Mr. Chairman, I've been here through 5 reapportionments. First personal bill I ever passed all the way through the legislature was the reapportionment after the 1980 census. We passed it in the general session year. That was for through so many computers, and they got the numbers out a little faster without the computers. And that bill was upheld by the United States Supreme Court, Brown v. Thompson. And frankly, Mr. Chairman, I thought I was done with legislative reapportionment. So let me tell you what the result will be. If you want to go to a reapportionment that will meet the requirements of the Wyoming Constitution and the requirements of the federal Constitution, as the courts are now interpreting, you will have a Senate size, just doing crude mathematics, of 210 members, unless there's a district with that's between 1 and 2 members in size and forces us to a higher number, because otherwise it would produce too much deviation. That's a real possibility, Mr. Chairman. But think of a Senate of 210 members and a House of 420 members. Our predecessors thought about that in 1965 and didn't hesitate to say, okay, the US Constitution is going to govern, we're going to have to do things differently and combine some Senate districts. That's where things started, Mr. Chairman. We don't need a big study to do that. Maybe an interim study could look at it, calculate those numbers precisely, which will be different from what I can do right off the top of my head at this hour of the night. But that's basically what you're going to find, is you have to comply with the requirements, you have to have districts that are so few people that you have just tremendous sizes down here that aren't going to be very practical, Mr. Chairman. So I think we can think about this. I think the proper approach, if we really want to do something, and maybe now is the time, is have the Management Council assign a committee. I would ask the Management Council, Mr. Chairman, to assign it to a committee I'm not on, but some committee that can do the necessary calculations. It's not very hard, and tell us what size we really would have to have. I'm against the bill.
Thank you, Senator Scott, for certainly not volunteering. Senator Cole.
Yeah, thank you, Mr. Chairman. There may be another way of skinning the cat, as they say. We could change the amount of votes per number you would cast as an individual. You know, you may get one per county that has, you know, very, very small population, but there may be a multiplication effect per another individual's vote as it pertains to a larger area. I mean, there might be a couple different ways of trying to do this, but I do agree that we have to have a very large appropriation for a new capital, because obviously we'll not be able to house all of us new folks here, and it would cost, the price of government would go up quite a bit. So not on or against right now, but certainly curious about how we could even develop a plan. Thank you, Mr. Chairman.
Thank you, Senator Cole. Senator Case.
Mr. Chairman, thank you. Mr. Chairman, I kind of became a believer in the committee. And I'll tell you why, Mr. Chairman. I think the good senator, tall senator from Natrona County has actually hit on, there are two ways that you might potentially be able to satisfy both things. One is to take our smallest county, which is Niobrara County, and to give them 2 representatives and 1 senator per the state constitution, and then scale that up statewide. And so that, if Niobrara County is 2,400 people and Laramie County is 110,000 people, I don't know, they would get that many proportional more representatives, okay? So that, at least 30, 40 times more, Mr. Chairman, that's a bunch of representatives for Laramie County. And that does work. The other way would possibly be to go down the weighted votes way. So we'd still have the numbers from the counties, but the votes would be some votes would be more powerful. I think the legislature's gone down that a couple times. But, Mr. Chairman, I've also been through this a few times, and not as many as my good tall friend from Natrona County. But Eastern Wyoming has been very upset every single time. So upset this time that they actually appointed representatives and a senator to come and be a member, to follow the Wyoming Constitution. And what the courts instructed to us in the Gorn case was that we may ignore that section. They didn't say you shall ignore that section of the Wyoming Constitution because of that possibility of this big, large legislature like, I think it's New Hampshire, has a house that's really that big. But Mr. Chairman, I think it's just worth time in between reapportionments to go spend some time going around the state talking about why we do it without the actual pressure of drawing lines. And I really think that, good people can sit down and talk about it more in an abstract way, Mr. Chairman, and it might help with understanding. There's one piece that I think we need to talk about, and that's the notion that if we find that we should change the Wyoming Constitution, which I guess we all kind of agree, maybe we agree we should, but we propose it to the voters and they say, no, we want it to be like it is written now. Well, what do we do then, Mr. Chairman? It's still been told by the court that we may ignore that. but yet the people feel vindicated and they have passed this thing. We have a problem then, Mr. Chairman. That's why I don't think that's necessarily the best way to go. Imagine in a state that doesn't believe in the Second Amendment as much as Wyoming did, had a proposal in a constitutional platform in its constitution that said that they could regulate the right to keep and bear arms. Just imagine that. And the people would say, and maybe a federal court would strike that down and say, no, 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 Second Amendment is really important. But maybe the people in this odd state, Mr. Chairman, and there probably are more than one, say, no, the court can tell us to strike it down, but we want you to put it back to a vote. Put it to a vote to take it out of our Constitution. And they don't. Think about that, Mr. Chairman. That part of messing with the Constitution is a little bit dangerous and could backfire on us. But I'm all for the education process, holding hearings, sitting down with people, trying to explain how we got there, explain the 14th Amendment, explain all those redistricting cases, and spend the time to do it when we don't have to produce a plan to come down here and try to get the votes. I think that's worth doing.
Thank you, Senator. Let's go to Senator Cooper, and then we'll go back to Senator Driscoll.
Thank you, Mr. Chairman. There's nothing I'd love more than having one county, 2 municipalities, and 2 school districts, rather than 5 counties, 14 municipalities, and 11 school districts. But logistically, I just cannot imagine how this would be feasible. It just doesn't work. If we're going to try to do this, pull your shorts up tight, folks, because this is going to get crazy. We're going to need a bigger boat.
Thank you, Senator Cooper. Good reference. I'm going to run to Senator Dox there real quick, and then we'll go back to Driscoll.
Thank you. It's worth the discussion. Last time around, my neighbors directly to the east wanted to have someone within their own county representing them. Well, the elections came and went, and now no one is from that county. But we take care of our neighbors. We spend a lot of time making trips across the state for their hospital project and other things, and that's what we do. We take care of our neighbors. But maybe it's worth exploring, trying to find a balance. I'll stay with it at this point.
Thank you, Senator Dockstader. Senator Driscoll.
Thank you. Somehow we got on a rabbit hunt from Bates Creek. Not sure how this actually happened. I kind of encourage you all to read the bill, because nowhere in it does it say that we're going to go to 1,000 members in the legislature. If you read section 1, that's just what's actually already out there. When you go to section 2, we'll go to page 5. What it really says is this: legislature shall make a good faith effort to apportion itself as required by the 14th Amendment. That goes right against the other end of it. Little II on line 9 says legislature shall make a good faith effort to apportion itself as required by Article 3, Section 3 and 48 of the Wyoming Constitution by providing for legislative districts that follow county lines and legislative districts that have at least one representative, one senator per county. And then it goes on to what we do. So what we did is what always happens in redistricting. We jump to the perceived solution that we see, not looking at a group of us looking at it and saying, what are the possible solutions? And maybe there is one. As we travel the towns, maybe there is one. We came close last year, I will tell you that. I voted against redistricting. Do you know why? Because we had a chance to be less than 500 people out of deviation and go out in the Bighorn Basin, which we did, that would have put one senator and one representative, at least one representative in every county that would have helped solve this. And we voted against it, and we went against it. And instead, we added a senator and 2 representatives and ended up with a county, actually 2 counties, that have neither. 2 on the eastern side of the state do not have a senator in them. It's kind of interesting how this all works out. All they do, the appointments that were talked about by the good chair of Corporations Committee, the 2 ladies, I happened to go over to Newcastle to a county commission meeting. They're who brought this to me, them and a group of people. And by the way, That same group of people sued, not last time, but the time before, considered doing it again this time. And it is contentious. What is the harm of actually sitting down and seeing if we can find a solution? We all know the solution will not be 1,000 legislators. We don't have a room to put even any more than we have now. I'd never go for it. But is there another solution that can do it? And even if there isn't, is there a way, once people have participated, that they understand it's where we're at and they accept it? And that's been the hard part. I can tell you, I've been in for 15 years. It's never been accepted up in that far corner of the Northeast that what has happened is fair or right. And I got to tell you, I feel somewhat the same with good Cooper, or the good senator from the center of the state. I feel the same way. I've represented 7 counties all the way across, and I fail to see how it's equal representation to represent 6 counties at once, when down here you can walk your district and represent 1 school district in 1 county. It's probably not exactly equal representation, but it's well worth it. I encourage you to pass this. At worst, a few senators, a few representatives, and people spend some time trying to find a solution when you're not beating the heck out of each other. It's a good time to do it, and it makes common sense. Thank you.
Thank you, Senator Driscoll. Senator Steinmetz.
Thank you, Mr. Chairman, on and for the bill. And, you know, good senators, there are a lot of people out in the hinterlands that have done a lot of work on this, and they have some really good ideas to bring to the table. I think all anyone wants is to have a conversation about it, Mr. Chairman, and to look at all the solutions on the table rather than just the redistricting process. So, Mr. Chairman, on and for the bill.
Thank you, Senator Steinmetz. Any further discussion on Senate File 174, Constitutional Apportionment 2? Senator Hicks.
Mr. Chairman, on and for the amendment, as I listened to these discussions, and you know, this whole thing's predicated on a 1964 Supreme Court case that said 1 man, 1 vote, and being an originalist, I go back and say, why was this not tested before 1964? What changed? And all of that 150 some years leading up, why did they change it in 1964? Well, you have to look at that and say, well, the court evolved. Doesn't mean they were right. I can look back in history at a number of Supreme Court cases where the courts actually got it wrong. Now, we could start out with Dred Scott, you know, that black men are property. Or we could look at things like Plessy versus Ferguson that upheld our apartheid laws in the southern United States. How about the one in 1944 where we said that we can confiscate the property of Japanese Americans because of their ancestry? There's a whole list of court cases where the Supreme Court got it wrong. Recently, they overturned a 50-year-old precedent. It's called Roe versus Wade. So if nothing else, shouldn't we go back as a state and look at our own Constitution? Look at why wasn't it changed before 1964? Have a better understanding. Is there a legal challenge here that maybe little old Wyoming needs to stand up for our own Constitution? The Supreme Court doesn't always get it right. They're made up of people just like we are. Our history has taught us over and over and over again, they're fallible. This is just let's take a look at that, make a determination. If we're not going to fill the chambers, maybe it's a challenge to the Supreme Court ruling. Maybe that's where we end up, but let's give it a chance. The courts make mistakes, folks.
Thank you, Senator Hicks. Any further discussion? Senator Scott, back to you.
Mr. Chairman, I find myself in the odd position of defending the Supreme Court. Frankly, Mr. Chairman, the history was that, and this is a problem that is probably the most difficult part of our democracy, is keeping the representation fair and equal and making it work. But, Mr. Chairman, the reason you got the Supreme Court decisions was that in spite of state constitutional requirements for reapportionment of the legislatures, Many legislatures in this country, including this one, were simply not obeying their own constitution. Because the problem you get into is the population shifts, and you look at a particular senator, and you see you are right next door, there's going to be one senator from that area instead of two. Somebody's not going to come back. And legislatures can't get that done. So we were having situations nationally where a majority of the legislature was being elected by 25% or less of the people. And that's not right, Mr. Chairman. That denies people equal protection of the laws. And the courts finally, they had been saying, well, it's a political question, we're going to stay out of it. They finally said enough is enough is enough, and said we've got to do it, and gave us some parameters. So I don't think you can, at this point, Mr. Chairman, short of a U.S. constitutional amendment, which you aren't going to get, because you couldn't get the necessary majorities, you aren't going to change the requirements. You're going to have to live with the requirements the court has set. And I don't think you need a big study. Having a committee look at it would be another thing. But the mathematics of getting enough members to satisfy the provisions of the Wyoming Constitution are pretty straightforward, Mr. Chairman. It's not a big study.
Thank you, Senator Scott. Any further discussion? Any further discussion? Seeing none, all those in favor of Senator Case's motion that when the committee of the whole rises to report, it do so with a favorable recommendation on Senate File 174, please say aye. Aye. Those opposed, no. No. Standing division, all those in favor, please stand. Sixteen ayes. Those opposed, please stand. It's going to be less than 16. Eleven noes. Senate File 174 has passed the Committee of the Whole. Next bill for your consideration is Senate File 61. Will the reading clerk please read the Senate file?
Senate File 61, Pollution Control Property Tax Exemption Applicability, an act relating to environmental quality, sponsored by Senator Case. It was referred to Committee Number 3, which returned a committee recommendation that it do pass amended. Ayes, Senators Case, French, Ide, McEwen, and Pappas. Senator McEwen, Chairman.
You have heard the reading of the bill. What is your pleasure, Senator McEwen?
I move that when Committee of the Whole rises to report, it do so with the recommendation that Senate File 61 do pass. And I will turn it over to the Senator from Fremont County.
Thank you, Senator McEwen. Senator Case.
Thank you, Mr. Chairman. There is a standing committee amendment. Do you think we can get that read into?
Let's do it.
Senate File 61, Standing Committee Amendment Number 1, page 1, line 4 after.
Senator Case.
Thank you very much, Mr. Chairman. Mr. Chairman, there is a property tax exemption that's in the green books, but it's not in the revenue code. It's actually in the environmental protection code. And what it is it allows for industrial facilities to install pollution control equipment, usually in response to a requirement from regulatory authorities. It could be state or federal, in the areas we have primacy. And it allows for a property tax exemption to occur for the cost of that equipment. So if you had a big coal-fired plant and you installed scrubbers, for example, that massive investment in those scrubbers would potentially qualify for the exemption. It applies to local and state assessed property, so it'd be your local assessor in terms of local assessed property, the Department of Revenue in the case of state assessed property. That sounds well and good, But there's one potential issue as we've learned about the potential for plants to be constructed whose sole purpose is to remove carbon dioxide from the air. And these are called direct air capture plants. You might have heard of them. There's different various technologies. And we've done a lot of studying about this in Wyoming. In fact, the university has studied all the geological formations that Wyoming has, and they're substantial. They can actually sequester CO2. We've talked about pore space. We've had a lot of work in this area. We've tried to make Wyoming a very attractive place for this potential investment to occur. And Mr. Chairman, we had one proposal that was very close, that looked like that was going to happen, but now that's pulled away. It was a very gigantic effort. But these plants, Mr. Chairman, could be as big as any plant we have in Wyoming now. They could be as big as our big gas plants. And under this tax exemption, since the entire plant is created to sequester CO2, they could potentially qualify for 100% tax exemption. All right, so gigantic plant coming into a county that has lots of impacts on roads, infrastructure, schools, you name it, would not pay any property taxes. This bill is an attempt to close that loophole, and what it proposed was that tax exemption not apply if you're talking about CO2. That was the bill, Mr. Chairman, but the industry came up with a better plan. And they proposed an amendment which became the standing committee amendment, which I don't know if I moved it. Did I, Mr. Chairman?
You did not.
I would like to, it's been read in, I would move the standing committee amendment, which is, in essence says, you're right on that plant whose sole purpose is direct air capture. But down the road, we may have investments regarding CO2. Now, some of us may agree with that or not, and I know that's a bit controversial. But what this would say is that if you had an existing plant, like a refinery, and you installed something to remove CO2, it could qualify for the exemption. But if you built an entire gigantic billion-plus-billion-dollar plant whose purpose was solely to capture CO2, you couldn't use this to avoid all the property taxes on that plant. So that's the entirety with the standing committee amendment. I think the standing committee amendment makes it a better bill and seems to be well supported, and I ask for your support, Mr. Chairman.
Thank you, Senator Case. We are on the standing committee amendment. Any discussion? Senator Hicks, are you standing for that? Yep. Okay.
Yeah, Mr. Chairman, just a question. Was there any discussion as defining what non-point source carbon dioxide is? Non-point's the operative word there.
Thank you, Senator Hicks. Any discussion on non-point source? Senator Case.
So, Mr. Chairman, that gets at the crux of it as well, because these direct air capture plants, they are controlling non-point source carbon dioxide. They pull it out of the air. So there's no identifiable source, it's in the air, okay? Whereas the ones that the industry is concerned about is where they have an industrial process, and in order to keep their process regulatorily viable, they have to reduce CO2. That is a point source. The effluent from a stack at a power plant, refinery stacks, other things, those are point sources which would still qualify for the exemption. Non-point sources, gigantic, huge facilities that suck air in from the atmosphere and remove CO2, eventually putting it in the ground for sequestration would not qualify. Thank you, Mr. Chairman.
Thank you, Senator Case. Further discussion on standing committee amendment number 1? Seeing none, all those in favor of Senator Case's motion to adopt standing committee amendment number 1 to Senate File 61, please say aye. Aye. Those opposed, no. Standing committee amendment number 1 to Senate File 61 has been adopted. We're back on the bill. Question's been called. All those in favor of Senator McEwen's motion to adopt, that when the Committee of the Whole rises to report it, do so with a favorable recommendation of Senate File 61, please say aye. Those opposed, no. Senate File 61 has passed the Committee of the Whole. The next bill for your consideration is Senate File 123. Will the reading clerk please read the Senate file?
Senate File 123, School Finance Competitive Grants for Crossing Guards, an act relating to school finance, sponsored by Senator Brennan, was referred to Committee Number 4, which returned a committee recommendation that it do pass. Ayes, Senators Brennan, Olson, Rothfuss, Schuler, and Scott. Senator Schuler, Chairman. Re-referred to Committee Number 2, which returned a committee recommendation that it do pass amended. Ayes, Senators Driscoll, Garou, Larson, Salazar, and Smith. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator Schuler.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with the recommendation that Senate File 123 do pass. There is a standing committee amendment. Could I have that read in?
Senate File 123, Standing Committee Amendment Number 1, page 1, line 13, delete.
And with that, we'll turn the time over to the good senator from Cheyenne.
Thank you, Senator Schuler. Senator Brennan.
Thank you, Mr. Chairman. I bring you another great little bill that is for the children. Senate File 123, School Finance Competitive Grants for Crossing Guards. Mr. Chairman, we discussed earlier a bill that we passed about children getting to school to and from safely, and have noted that there is an issue with this, not just in my county, but there's also a county up in the northwest corner of the state, and some other counties that have been mentioned that have also issues with kids getting to and from school safely. So this is another way for us to help our kids get to and from school safely. It creates a competitive grant that you will see starting on page 1 for the school years 25 through 26 and years 27. I'm going to explain the bill, and then there is a committee amendment from the appropriations, as there's an appropriations on that, but I'll just go through the bill first. That a school district could apply for to help with the education and faculty and help with the purchase of equipment for a crossing guard program. If you go to page 2, lines at 9, it talks about the grant award. It should not exceed $10,000 per school per year. And then in line 19, Romanet I, it starts on what would need to be included at minimum in that request for the grant money. So they would need to document the need for the crossing guards, the intersections where the crossing guards would be at, the number of hours for the volunteers or employees, the type of training, the equipment needed, and any other necessary information required by the Department of Education. This would be no later than August 1st of each applicable year. And that is basically the gist of the bill. And I will go ahead and we can do the standing committee amendment and then discuss the bill.
Thank you, Senator Brennan. Let's find an appropriator to, there we go, Senator Larson.
Thank you, Mr. Chairman. I move standing committee amendment number 1 to Senate File 123 and ask for your favorable consideration. Essentially, what we're doing is funding for 1 year and then saying that it is available for 26, 27, 27, and 28 years if funds are available on page 1. And then we go to page 5. We delete the 4.9 million and insert 1.65 million. And essentially say on page 5, line 23, I'm going to read it if I can find it. Well, essentially, it said that this ought to be included in the standard budget and doubled. to make it available for the next 2 years, 4 years. So that's what we did.
Thank you, Senator Larson. Discussion on Standing Committee Amendment Number 1. Discussion on Standing Committee Amendment Number 1 to Senate File 123. Seeing none, all those in favor of Senator Larson's motion to adopt Standing Committee Amendment Number 1 to Senate File 123, please say aye. Those opposed, no. Standing Committee Amendment Number 1 to Senate File 123 has been adopted. We are back on the bill. Discussion on Senate File 123, School Finance Competitive Grants for Crossing Guards. Senator Landon.
Yeah, Mr. Chairman, thank you. I just had a question really about this budget line item, which is fairly significant, and my heart really goes out to this district. We've really had some struggles down here, and I commend the senator for really working hard and bringing this. The only question I have, however, is whether or not this needs an appropriation. It just feels like to me that maybe, we talked not long ago today about the ability of a school district to move some money and to have some flexibility with what they can do, particularly on school safety and issues like that. This district has some wherewithal, and I'm just curious to know what that conversation has been like and why this district, particularly this one, has not stepped up on the crossing guard front. Thank you, Mr. Chairman.
Thank you, Senator Landon. Any further questions before the sponsor rises? Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a question about, I guess, when I grew up a little while ago, that there were volunteer crossing guards. I just wonder why that doesn't work. I think I understand the liability issue. That definitely is a concern for people doing this. But I just wondered, just why is the money necessary? I mean, what are they getting paid for? What people used to volunteer for because we don't have volunteers? So this is a general question about the necessity of the appropriation. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Senator Larson.
Yes, Mr. Chairman, thank you. I'm not really excited about the funding either. We did put an amendment in there, obviously, but we're still at like 4.9 million over five years, I think. One of the questions I had, is there a one-to-one match or something from the school district? And I don't think I read that in there. I think that should be maybe a possibility, but that's a lot of money.
Thank you, Senator Larson. Further discussion before the sponsor rises? Seeing none, Senator Brennan.
Thank you, Mr. Chairman, and thank you for the discussion on the budget and the appropriation in this bill. I think that is something that we should always look at in a bill. When asking why, in particularly our district, why we couldn't have a crossing guard program, there was a couple of things that came up. The money was one of them, and currently the block grant does not have for any safety issues within the block grant. That's not one thing that we provide for in the block grant. I do think that with one of our other things, we did take care of the ability for volunteers to be a part of this. I do want to correct, the standing committee amendment did only fund this for 1 year, and then we can come back in the budget session and look and see, was this something that was utilized and did it help? But it is only for 1 year. And I would also say that if there is any issues on the appropriation still with it, I would be happy to work with anybody on a second reading amendment for this.
Thank you, Senator Brennan. Any further discussion at this time? Further discussion? Seeing none, all those in favor of Senator Schuler's motion that when the committee of the whole rises to report, it do so with a favorable recommendation on Senate File 123, please say aye. Those opposed, no. No. Standing division, all those in favor, please stand. 7 ayes. Those opposed, please stand. A lot more than 7. Pursuant to Senate Rule 6.5, having failed a standing division, a roll call is required. Will the chief clerk please call the roll?
Committee of the Whole roll call vote, Senate File 123, Anderson? Aye. Barlow? Aye. Boner? No. Brennan? Aye. Case? No. Cooper? No. Crago? Aye. Crum? No. Dockstader? No. Driscoll? No. French? No. Guru? No. Hicks? No. Hutchings? No. Ide? No. Jones? No. Cole? No. Landon? No. Larson? No. McEwen? No. Nethercott? No. Olson? Aye. Pappas? Excuse Pearson? No. Rothfuss?
Aye.
Aye. Salazar? No. Schuler? Aye. Scott? Aye. Smith? Aye. Steinmetz? No. President Beitman? No. Closing vote? Peru, no to aye. Closing. Vote closed. Senate File 123, 10 aye, 20 no, 1 excused.
Pursuant to Senate Rule 6-5A, Senate File 123, having failed a roll call vote, is deemed indefinitely postponed. The next bill for your consideration is Senate File 125. Will the reading clerk please read the Senate file?
Senate File 125, Defining Healthcare and Protecting the People's Welfare, an act relating to statutes and rules of construction, sponsored by Senator Steinmetz, was referred to Committee Number 10, which returned to Committee recommendation that it do pass amended. Aye, Senators Barlow, Crum, Hutchings, and Steinmetz. No, Senator Scott. Senator Scott, Acting Chairman.
You've heard the reading of the Senate file. What is your pleasure? Senator Barlow.
Thank you, Mr. Chairman. Mr. Chairman, I move that when the Committee of the Whole rises to report it, do so with the recommendation of due pass for Senate File 125. Mr. Chairman, there's a standing committee amendment. Could that be read, please?
Senate File 125, Standing Committee Amendment Number 1, page 2, lines 1 through 7, delete.
Thank you, Mr. Chairman. I move Standing Committee Amendment Number 1, and I would turn over the explanation of the bill and the Standing Committee Amendment to the sponsor, Senator Steinmetz. Thank you.
Senator Steinmetz.
Thank you, Mr. Chairman, and thank you, body, for hearing this good little bill so late at night. Fellow senators, this bill takes a little different approach than what we have before by inserting some definitions into Chapter 8, which is the common law statutes and rules of construction of the state legislature. And fellow senators, you should have a tracked-in copy of the bill in your little sections at the top of your desk there that shows this bill and the date today from me. We amended this bill quite a bit in committee, and so I wanted you to have that document in your possession for ease of going through the bill. Mr. Chairman, you'll see the beginning of the amendment is on page 2, where we are inserting the definition, interpretation, and construction under the Wyoming Constitution and all statutes of the state, and we are inserting healthcare. Healthcare shall mean acting to promote the curative, improving, healing, restorative, and therapeutic physical health and well-being of a person, including an unborn person from the moment of conception, herein defined as life. Healthcare shall not mean actions to terminate life and are hereby prohibited except as provided by this section. Abortion, as defined by paragraph 2 of this section, shall be defined as healthcare only if the abortion is medically necessary to save the life of a pregnant woman by performing a pre-viability separation procedure necessary in the physician's reasonable judgment to prevent the death of the pregnant woman, a substantial risk of death for a pregnant woman because of physical condition of serious and permanent impairment of a life-sustaining organ of a pregnant woman, provided that no separation procedure shall be deemed necessary under this section unless the physician makes all reasonable medical efforts under the circumstances to preserve both the life of the pregnant woman and the life of the unborn baby in a manner consistent with reasonable medical judgment. Then subsection 2 of the new amendment defines abortion, which shall mean the act, procedure, device, or prescription administered to or prescribed for a pregnant woman by a person with knowledge of pregnancy, including the pregnant woman herself, with the intent of producing a premature expulsion, removal, or termination of a human embryo or fetus, except that in cases in which the viability of the embryo or fetus is threatened by continuation of the pregnancy, early delivery after viability by commonly accepted obstetrical practices shall not be construed as an abortion. So those two things, we went ahead and did the long version of those rather than referring to statute, because some of those definitions have been enjoined in a lawsuit. The next subsection in 3, we reworded, and it just says that no act, treatment, or procedure that intentionally causes harm to the heart, respiratory system, central nervous system, brain, skeletal system, joint or muscles, appendages, or organ function shall be construed as healthcare unless documented and medically necessary for the treatment of an illness or injury documented to save the life of a person, or in cases in which a licensed medical provider has determined and documented that a person has no chance of meaningful recovery from an injury or illness and recommends terminating life support systems. Subsection B basically just says that this does not apply to the Wyoming Healthcare Act decision. And then subsection 2 with the amendment makes the act effective immediately. And Mr. Chairman, with that, that's pretty much the bill and the amendment. And since the amendment is a lot of the bill, I would stand for questions on the amendment or call for the amendment and discuss the bill.
Thank you, Senator Steinmetz. We are on Standing Committee Amendment number 1 at this time. Discussion on Standing Committee Amendment number 1. Senator Scott.
Mr. Chairman, on the Standing Committee Amendment. Mr. Chairman, the Standing Committee Amendment, whether you're for or against the bill, the Standing Committee Amendment is absolutely necessary. Something went drastically wrong in the drafting process. I don't care to speculate what the problem was, but the results didn't make any sense. And the Standing Committee Amendment, at least you can tell what the bill does with the Standing Committee Amendment. So, Mr. Chairman, on and for the Standing Committee.
Thank you, Senator Scott. Further discussion on the Standing Committee Amendment. Senator Cooper.
Thank you, Mr. Chairman. I'm trying to figure out what this says, but as I read this Standing Committee Amendment removes the protections for women who are victims of rape, incest, and abuse. Is that correct?
Thank you, Senator Cooper. Any further questions before Senator Steinmetz rises? Seeing none, Senator Steinmetz.
Thank you, Mr. Chairman. We are not dealing with who this is intended for. That would be the subject of who. We're just dealing with what healthcare is. So you're talking about who healthcare would affect. We're talking about what healthcare is and defining healthcare. I hope that helps, or that's the intention anyway.
Thank you, Senator Steinmetz. Further discussion, Senator Landon.
Thank you, Mr. Chairman. What does this do to the impact of in vitro sorts of procedures? I just know that that's a fairly big deal. So just wondering if this pulls all of that into the definition. Help me with that one, please.
Thank you, Senator Landon. Senator Nethercott.
Thank you, Mr. Chairman. Just question if in committee or anywhere anyone's heard about any complications that may arise with health insurance by prescriptively defining healthcare in this way. If you want a procedure that doesn't fit this definition of healthcare, will your health insurance provide coverage, or will they have another reason to deny that coverage? And then I see that it does say in the definition in the standing committee amendment that it does say and well-being of a person, but is healthcare just, we've limited it to the physical well-being, just obviously with mental health issues and the application of coverage for mental health diagnoses, mental health being, what is the impact of this definition? I know we're coming at this definition from one single sole angle, which is abortion. And we're trying to get ahead of the Wyoming Supreme Court on the constitutional definition of healthcare. And so we're providing this one solution, and I'm not sure we're fully appreciating the global and holistic consequences of defining healthcare for all people in the state of Wyoming for all time.
Thank you, Senator Nethercott. Senator Grew.
Oh, my first question. Oh, thank you, Mr. Chairman.
Yeah.
My first question is a standing committee amendment. What does that do to the questions in abortion of rape, incest, life of the mother? Or how does that addressed? How is the standing committee amendment addressing that? It's part of what the global nature of this has got me really concerned. So I'll start there, and then we'll move on to more questions as we go.
Thank you, Senator Grew. We are on standing committee amendment number 1. Senator Landon, you rose. Do you want to go one more? Not right now. Let's go to Senator Steinmetz.
Thank you, Mr. Chairman. With regard to in vitro, I will have to do a little more research on that. The Wyoming Hospital, or I'm not supposed to say that, the people who represent healthcare providers across the state have a second reading amendment that might address some of the other concerns. And with regard to the lawsuit, we've talked about pushing the effective date out a little bit later. So that might help with some of that. And I can't remember what the good senator here asked me next door.
Thank you, Senator Steinmetz. Let's get a couple more questions here. Senator Landon and then Cooper.
Thank you, Mr. Chairman. Look, I know the lay of the landscape these days, and I understand with this word in there, we're expected to toe a line here. But I guess my question to the bringer of the bill, there was a question asked about 4 days ago by one of our newest senators. What's happening to our doctors? Why are they not coming here, and why are they leaving? Well, I represent probably the major health hub in our state, in my community, and I've heard from some of our healthcare providers, and they point to this right here. I just wonder if that's been researched or talked about. What are we doing here? That's very concerning to me. We talked about maternal health care. Well, what do you think's going to happen? Why would a new doctor come and set up practice here? Thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Cooper.
Thank you, Mr. Chairman. I have a constituent question here from a gentleman in the medical field. I wish I was smart enough to ask this question myself, but does the amendment allow for the humane termination of pregnancy in situations in which the embryo, fetus, unborn child, by a consensus of medical judgment, is determined to not be compatible with life, to include trisomy 13, trisomy 18, anencephaly, renal angenesis, Lehman body wall complex? Thank you, sir.
Thank you, Senator Cooper. To Senator Salazar, then Senator Hutchings.
Quick question. Are we anticipating
an amendment, or is there any discussion about an effective date for this bill? Maybe someone can, okay, thank you.
Thank you, Senator Salazar. We are on the standing committee amendment. Let's focus on that for now, and then we'll get to the rest of the bill. We are still on the standing committee amendment. Any further discussion on the standing committee amendment? Senator Barlow on the standing committee amendment.
Thank you, Mr. Chairman. There's a couple inquiries about whether rape, incest, et cetera. That is not part of the standing committee amendment, and it was not part of the original bill. So I think certainly the bringer of the bill can speak to that more broadly in the bill, but it is not a part of the standing committee amendment. Thank you, Mr. Chairman.
Thank you, Senator Barlow. Any further discussion on the amendment? Senator Hutchings on the amendment.
Maybe just to answer a couple questions. If we go to page 2, lines 9 through 16, I think that would answer Senator Cooper's question. And the good senator from the back of the room questioned about doctors coming here. I think we passed a bill this morning that we should be getting some foreign doctors here real soon. So I wouldn't worry about it. Thank you, Mr. Chairman.
Thank you, Senator Hutchings. Madam Majority Leader on the amendment.
Mr. Chairman, yeah, so my question is to the amendment, haven't heard an answer. Really need to direct everyone's attention there. I know we're fixated on the concept of abortion and all those things, great. We can talk about that again for the 20th year in a row, but I really want to focus everyone's attention to the amendment. Page 1, lines 7, 8, 9, and 10. We are defining in statute healthcare. And if you look at lines 3 through 5, it says, for purposes of definition, interpretation, and construction under the Wyoming Constitution and all statutes of this state, including in the insurance code. I don't mean to be flippant. This is very serious, but are we actually considering the full consequences of this definition? Your concern about saving life aside, in the zealousness of this effort, we are causing serious damage. And it says healthcare shall mean acting to promote the curative, improving, improving, I guess is just a word there, healing, restorative, and therapeutic physical health and well-being of a person. I guess with the exception of mental health and any elective or questionable things that might not fall into improving or curative or restorative. But this also includes the unborn person from the moment of conception, herein defined as life. That's what this bill is about. That's the most important piece of this bill, and the consequences thereof that may not be being considered due to the zealous advocacy associated with the need to protect life, which I understand, which I fully supported, but there are real consequences to real humans, the born and the unborn, with this definition.
Thank you, Senator Nethercott. Anything further on standing committee amendment number 1? Senator Case and then Landon.
So, Mr. Chairman, it's kind of hard here because we are on a standing committee amendment, but really the standing committee amendment is the bill, okay? So, and the bill is the big issues that just been identified by my good colleague from Cheyenne. So, Mr. Chairman, we're trying to put in a statute through the standing committee amendment and the bill a way to force the Wyoming Supreme Court to analyze future lawsuits in this area that are related to Article 2, Section 38, which is the right of healthcare access, which is in our Constitution, and so that they're forced to interpret things in this manner. And just to remind you all, Section 38, right of healthcare access, each competent adult shall have the right to make his or her own health care decisions. I don't see that in here, Mr. Chairman. It looks like everybody else is making the decision. The parent, guardian, or legal representative of any other natural person shall have the right to make healthcare decisions for that person. Part B is any person may pay and a health provider may accept direct payment for healthcare without imposition of penalties or fines for doing so. Not really relevant to this. C is the legislature may determine reasonable and necessary restrictions on the rights granted under this section to protect the health and general welfare of the people or to accomplish the other purposes set forth in the Wyoming Constitution. D, the state of Wyoming shall act to preserve those rights from undue government infringement. If you look at these things, the first one is the most important. And Wyoming must look at the first thing. Each competent adult shall have the right to make his or her own health decisions, and the parent or guardian of a legal representative of any other natural person shall have the right to make health care decisions for that person. All the others qualify that. We can make reasonable and necessary to that number one thing. Now, this is trying to say, to undo that, Mr. Chairman, and to say, court, you have to accept R for purposes of definition, interpretation, and construction. I'm reading the amendment under the Wyoming Constitution and all statutes of the state. Health care shall mean. No. Each competent person has the right to make those decisions. Let me take it a step further, Mr. Chairman. We look back we have the right to keep and bear arms. It is Section 24, Article 1, Section 24. The right to bear arms, the right of citizens to bear arms in defense of themselves and of the state shall not be denied. What if we were talking about the Second Amendment? And what if we had a bill here to talk about what arms were and what bearing was? Do you think the court's going to fall for that smoke and mirrors, Mr. Chairman? I don't think they would. I don't think we'd tolerate it. The court is not going to fall for this smoke and mirrors of this bill and this amendment, because you can't do it that way. You can't say something that was passed by the people of Wyoming and the words are clear and strong. You can't undo those words with statutes that are vague, manipulative, and affect people's rights, Mr. Chairman. You just can't.
Thank you, Senator Case. Senator Landon.
Mr. Chairman, I do want to come back to what I think is a legitimate question that was posed to me by a constituent. What does this mean on the reproductive rights for those couples that are struggling to have children and are using in vitro sorts of procedures? What does this mean? What does this define? I can't seem to zero in on it. I want to know what that's going to do. Does that eliminate the ability for people to do this? Thank you.
Thank you, Senator Landon. Senator Hicks, did I see you rising? Yep, Senator Hicks. Senator Hicks, go ahead.
So, Mr. Chairman, anytime that you have a constitutional amendment, it's always important to go back and actually read the context in which that constitutional amendment was passed. And you'll see this constitutional amendment was passed in 2012. And so myself and a few other were in here. In fact, my colleague from up there at Devil's Tower and myself were co-sponsors on that constitutional amendment. And so what was the original intent? And do the court's interpretation now meet what the original intent was? Textualism. How's the text used? What was the debate that we had in 2012 in this very body? I sat there where my colleague from Laramie County sits now. This issue of what constitutes health care and whether that meant abortion never arose on this floor, because it was nobody's intent and nobody's discussion to say abortion of a fetus is health care. The original intent of adopting this constitutional amendment by this body and the body down the hall that put it on the ballot was not in context of the definition of this healthcare constitution as abortion healthcare. That discussion didn't have out here. That wasn't the reason that we adopted that constitutional amendment. We had a federal government that was trying to do single payer, one-size-fits-all healthcare. That's why a competent adult. But this whole debate, whether it means and includes, that never occurred on this floor. Folks, I was here. I was a co-sponsor of that. So now we have a judge out there that comes out and didn't go back, didn't pull the transcripts out, didn't read it, didn't look at it, and made an interpretation of what was in the context of the debate that this body had that put this on the amendment, and what context was the discussions. And now they've made a determination that that's why we put it on there, because we felt as a body that abortion of the unborn was health care. That's an incorrect interpretation of what that constitutional amendment did. It's inconsistent with any debates that happened on this floor, and it's not accurate to say that, what this amendment means, because you have to put it in the context of the debates that happened and why we voted for that. And that wasn't part of it. It's not health care.
Mr. Chairman.
Senator Case.
Mr. Chairman, you're looking pretty swell up there today.
Feeling good, thanks.
With leeway, I'd like to read this co-sponsors of the 2011 constitutional amendment. Healthcare freedom, sponsored by Senators Nutting, Case, Driscoll, and Jennings, and Representative Brechtel, Gay, Jaggi, and Kroger. That's who sponsored that amendment. I'm standing here to tell you what that amendment means. And there are two sponsors left in this legislature, and they're in this back corner. I don't mean to speak for him, but the gentleman was not a co-sponsor.
Thank you, Senator Case, for that clarification. We're not going to get into an argument here, but Senator Hicks, briefly.
Mr. Chairman, just a little correction for the record here. There was actually two constitutional amendments. I was on the Judiciary Committee, and we were handed both of those constitutional amendments, and I was on one of those. And the actual one that was passed was not the one quoted by my friend from Fremont County. So those two competing constitutional amendments went to the Judiciary Committee. We worked those, we consolidated those, and the one that passed was actually sponsored by a senator from Laramie County here called Senator Nutting. And so go back and look at the record. That's the one that passed out of this body. So just a little clarification. Didn't say that the senator from Fremont County wasn't, but that's not the one that passed. The one sponsored by Senator Nutting at the time was the passed, and I was a co-sponsor on that particular amendment. Just clarifying the record.
Thank you, Senator Hicks. To Senator Scott.
Mr. Chairman, the hour is late, we're getting a little growly. Mr. Chairman, I would urge us let's keep this a civil debate. Mr. Chairman, I rise to answer the question on the in vitro fertilization that was raised several times and not been answered. As I understand that procedure, there's likely to be a number of embryos potentially created, and if they get a successful implant, they will discard the other ones, is my understanding of the way that works. And so the answer to the question, if the standing committee amendment should pass and then become law, yes, we're still in the standing committee amendment.
Yes, we are.
My understanding is that anybody who wanted that procedure would have to do it entirely outside the state of Wyoming, because it would be illegal here.
Thank you, Senator Scott. Senator Landon, and then Cooper.
Well, thank you, Mr. Chairman, and that's really a point that I want to drive home tonight. You know, all frivolous answers aside, yes, we cleared the way for some international doctors to make their way to this state, but not in maternal health care and not in OBGYN. We need to consider these bills for the unintended consequences, Mr. Chairman, and that's all I'm doing this evening. I represent a healthcare community. They're very, very concerned about this bill and the way it's written and where it comes from and what it's going to do to our healthcare community in Wyoming. And I think it's going to be dramatically drastic. Thank you, Mr. Chairman.
Thank you, Senator Landon. Senator Cooper, then Giroux.
Thank you, Mr. Chairman. I wasn't here in 2012 to listen to this argument on the amendment as it was presented in this body. I was on the outside. It was presented to us as a member that voted for it, as a voter that voted for this amendment, word for word. Every competent adult is responsible for his or her own health care. That's the way the amendment was presented. That's the way we voted for it. Thank you.
Thank you, Senator Cooper. Senator Giroux.
Thank you, Mr. Chairman. I think the words from the good senator from Bates Creek are well taken. But I also understand how it can get a little bit upsetting and a little bit growly, as he says. Because now, as you just heard, we've had a good vigorous debate on what happened 11 years ago. And then tonight, on this amendment, what we're poised to do is that the Wyoming Senate is going to define health care in the state of Wyoming. I don't know what this means about restorative. What happens with elective procedures? What happens if, I don't know, are we going to make Botox illegal, Botox treatments illegal with this? I don't understand. I know where the bringers want to go, but I don't think they realize that they're probably opening Pandora's box, Mr. Chairman, to all sorts of questions that other legislative members, long past us, are going to sit here and debate, just like the debate we just heard about who sponsored an amendment that went into a bill that went to the Constitution 11 years ago. We're going to be talking about this every week. We're going to be talking about this every session. What does this bill mean now to this person? And once you get past that, then I think you go back to the good senator from the middle of the state talking about the chilling effect this is going to have on recruiting doctors. Internationally, locally, we've made these bills and we've turned our doctors into felons, over again, and now we're going to perpetuate it once more. That's not what this group talks about every other time we talk about this. We talk about we need doctors, but then we're going to tell them what to do. We're going to tell them what they can't do, and what they can't do at a specific moment in time, whether it's really defining some other procedure that they're trying to get at. And by casting that net out, we're going to talk about throwing out the baby with the bathwater. This is it. Thank you, on again.
Thank you, Senator Giroux. Senator Driscoll, and then Senator Steinmetz.
Mr. Chairman, thank you. I hesitated to rise. I was one of the original co-sponsors 12 years ago. We talked about what happened, what didn't happen. I will tell you, it was anticipated. I spent several hours downstairs with the AG and the guy that lived down there over this. They anticipated very much that this could be there. And I represent to you a big part of the people on the floor knew about that because we came back up and we talked about it. And so I'm just doing it as a matter of correction. I do think there is unbelievable amounts of unintended consequences with this one. This is far, far reaching. I think it's a good next step in our 3 or 4 year series of cases going to the Supreme Court. I'll make a prediction that this will add yet another layer to it. We can come back next year and try to fix what the court's saying one more time, because this is the third swing at it that I've seen, and I'm guessing it's going to be 4 and 5 coming.
Thank you, Senator Driscoll. Senator Steinmetz.
Thank you, Mr. Chairman. I'll try to take us home and swat away a few of those black helicopters as we move forward. If you see the definition of healthcare, it is to promote the curative, improving, healing, restorative, and therapeutic physical health and well-being of a person. Nothing in there is a limitation of anything regarding mental health. If we need to tweak that a little bit, I'm more than happy to have that conversation. With regard to in vitro, if we need to tweak it for that, that's not a problem. That's not what we're trying to get to. This is about life and preserving life. And as far as the court case, we can push that effective date out to where it doesn't affect that. That's a discussion some of us have been having in the body. I didn't want to bring it on this amendment because we had such a large amendment to deal with. But as I said, there is a second reading amendment coming should the body pass this through, and I would urge you to do that at this late hour. Thank you, Mr. Chairman.
Thank you, Senator Steinmetz. Any further discussion on Standing Committee Amendment number 1? Seeing none, all those in favor of Senator Barlow's motion to adopt Standing Committee Amendment number 1 to Senate File 125, please say aye. Aye. Those opposed, no. Standing Committee Amendment number 1 to Senate File 125 has been adopted. We are back on the bill. Any discussion on Senate File 125 for the discussion? Seeing none, question's been called. All those in favor of Senator Barlow's motion that when the Committee of the Whole rises to report, it do so with a due pass recommendation on Senate File 125, please say aye. Aye. Those opposed, no. No. Division. Those in favor, please stand. Nineteen ayes. Those opposed, please stand. It's going to be less than 19. To 9. 9 noes. Senate File 125 has passed the Committee of the Whole. The next bill for our consideration is Senate File 124. Will the reading clerk please read the Senate file?
Senate File 124, Illegal Immigration, Identify, Report, Detain, and Deport, an act relating to immigration, sponsored by Senator Steinmetz. It was referred to Committee Number 1, which turned to committee recommendation that it do pass amended. Ayes, Senators Crago, Crum, Hicks, Kolb, and Olson. Senator Olson, Chairman. Re-referred to Committee Number 2, which turned to committee recommendation that it do pass. Ayes, Senators Larson, Salazar, and Smith. No, Senators Driscoll and Grew. Senator Salazar, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator Olson.
Mr. Chairman, I move that when the Committee of the Whole rises to report that it do so with the recommendation that Senate File 124 do pass. There's a standing committee amendment, which I would ask to be read in at this time.
Senate File 124, Standing Committee Amendment Number 1, page 1, line 4, delete.
And standing committee amendment is pretty substantial change to the bill, so I think the best way to approach this is I'll turn it over to the bill sponsor, I know, to walk through the bill as amended, and then I can clean up anything that isn't addressed.
Sounds good. Thank you, Senator Olson. Senator Steinmetz.
Thank you, Mr. Chairman, and thank you for staying late to hear this important bill. I will walk you through the bill. You have a tracked-in copy on your desk as well so that you can see exactly what we've done and look at the amendment. On page 1, you'll see some things being deleted and an authorizing part. On page 2, we go in and we start talking about, we add in providing for an appropriation on line 1 after applicability because we are adding an appropriation. The first part on page 2 is transportation or concealment of illegal aliens. It's talking about no person shall transport, move, or attempt to transport or move in the state of Wyoming any illegal alien knowing. So that's an important word, knowing that the alien has come to, entered, or remained in the United States in violation of law. One thing that has been discussed, and for everybody who's listening, please be awake and listen, because there could be an amendment about taking out or remained in, because folks, if they have an expired visa or something like that, we don't want to get them caught up in this if they were here legally and just something went wrong with their paperwork. The same thing on subsection B about concealing, harboring, or sheltering from detection an alien. We could look at a second reading amendment about or remained in there as well. On page 3, we went into the peace officer's citizenship status and cooperation. We deleted lines 10 through 13 in subsection A and created a new subsection. This was something that there was a concern about profiling there. That was not the intent. So now it just reads that no law enforcement agency in the state shall adopt a policy, rule, or procedure that prohibits peace officers from asking about a person's immigration status upon a peace officer's reasonable, articulable suspicion of a person's immigration status. Then we made a new subsection B. The sheriff shall investigate the immigration status or lawful presence in the United States of any person who is arrested and booked into jail. That way they're doing the investigation of someone who has had some criminal problem. And this also takes care of another subsection we deleted, because it then doesn't require the Department of Corrections or anyone in the prison system to be doing those inspections. On the next page, on page 4, we've inserted some language that the sheriffs wanted, and they may continue to hold a person after determining that the person is an unauthorized alien, and gives some statutory references there. And the other part of this, why it refers to the sheriff in particular, they are the law enforcement agency that is tasked with this under statute. And so that's why you'll see references to the sheriff. And this also contemplates the signed agreement with the United States Department of Homeland Security or the United States Immigration and Customs Enforcement. Under either agency, they can hold them until they assume custody of the person. And if they decline or refuse to take custody in a timely manner, then they can deal with that as well, the sheriff can. There's some definitions of what a local government is, and then you come to the definition of an unauthorized alien on page 5. Then we delete all of the bottom of page 5. This is your employer verification reporting. So that's all been taken out. 13 through 23. Page 6 is gone. Page 7 is gone. You can thank your good Judiciary Committee for. Page 8 is gone. Page 9 is gone. So it's going to be a much smaller bill. Page 10 and 11 are gone. And then we get back into the memorandums of understanding and communication of immigration status. So the Attorney General and the Governor's Office are supposed to negotiate the MOU between the state of Wyoming and the U.S. Department of Justice or Homeland Security, and then you have your reference to the federal laws. And then it should be signed on behalf of the state by our governor. And then each county sheriff, in consultation with the Board of County Commissioners, and there's another change, instead of shall, may negotiate terms of the MOU between the county and the United States Department of Justice or the Department of Homeland Security for enforcement of federal immigration and customs laws, detentions, removals, investigation, So that's what they're doing. No local government, but by any process shall enact any ordinance, policy, or limits on which prohibits a peace officer or local law enforcement or government employee from communicating or cooperating with federal officials. On to page 14, that's just more language concerning that, about restricting any employees from doing this as well, or checking into citizenship, or sending information about all of this to the Department of Homeland Security. Then on to page 15, we are talking about the record of prisoners, and we have deleted all of lines 8 through 23. And on the next page 16, all of 1 through 14. The next just applies to a driver's license or permit. Our driver's licenses here are real ID compliant IDs. They are doing most of this. There were a couple of things that were not in the YDOT's rules as far as driver's licenses, so we left that entire section in. And so then you go back onto page 18, that's still driver's licenses. On 19, that's still driver's licenses. And then at the bottom of 19, we're adding in the amendment for an appropriation that would be inserted on line 15, and on the back of your bill, it tells you what that amendment is. It's $1 million from the LSRA to the Office of the Attorney General for reimbursement to counties that for expenses incurred in this process, and also for anti-terrorism training. So, Mr. Chairman, that is the bill, and I would stand for any questions. Do you want me to move that amendment now, or did we move it or just read it in?
Thank you, Senator Steinmetz. We haven't moved it yet, but I'll look to Senator Olson to see if he wants to move it
Okay,
and
I'll let
provide any
him.
more.
Okay.
You don't want to? All right. Senator Steinmetz, would you move it?
Yes, I would move Standing Committee Amendment number 1 to Senate File 124 and ask for your favorable consideration.
Great.
And that would dispose of the amendment.
Thank you, Senator Steinmetz. All right, we are on Standing Committee Amendment number 1 to Senate File 124. Any discussion on the amendment? Seeing none, all those in favor of Senator Steinmetz's motion to adopt Standing Committee Amendment number 1 to Senate File 124, please say aye. Those opposed, no. Standing Committee Amendment number 1 to Senate File 124 has been adopted. We are back on the bill. Discussion, Senator Larson.
Mr. Chairman, can I ask for a privilege?
Yeah, you can. Let's do
I
it.
had an incident up in Byron. A couple people might be dead. I can read the press release if you want.
Go ahead, Senator Larson.
Would you read it?
Yeah, this is a sad situation up in just east of Park County and Bighorn County. This is from the Bighorn County, Wyoming Sheriff's Office. Today, February 10th, 2025, at approximately 1:30 p.m., the Bighorn County Sheriff's Office Public Safety Communication Center received a 911 call regarding shots fired from a residence on the south side of the town of Byron. Byron's a small town between Lovell and Powell. The Bighorn County Sheriff's Office immediately responded with multiple personnel, along with the Wyoming Highway Patrol and the Lovell Police Department. The residents involved with the reported shots fired incident was immediately secured by arriving law enforcement. While securing the residence, law enforcement officers observed multiple victims of gunshots within the residence, both alive and deceased. Multiple individuals were transported by ambulance to North Bighorn Hospital in Lovell, Wyoming for emergency care. Bighorn County Sheriff's Office has requested the assistance of the Wyoming Division of Criminal Investigation to process the scene. At this time, there is no active threat to the citizens of Bighorn County. Our thanks go out to the Wyoming Highway Patrol, the Lovell Police Department, North Bighorn Hospital and Ambulance, Powell Valley Hospital Ambulance, and the Wyoming Division of Criminal Investigation. So I think Dan and I, since it's up in our neck of the woods, would ask that you please pray for the individuals up there in the community. It's a bad deal.
Let's stand up, have a moment of silence, and think about our citizens in Bighorn County. All of Wyoming. Thank you all. All right. Resuming, we're on Senate File 124. Discussion on Senate File 124. Senator Nethercott and then Senator Kolb.
Thank you, Mr. Chairman. On page 12, we've left in that the Attorney General, with the approval of the governor, is authorized and directed to negotiate the terms of an MOU between the state of Wyoming and the United States Department of Justice. I guess we're assuming that there isn't one that already exists potentially, but more importantly, why the Attorney General? Because the Attorney General doesn't do law enforcement investigations. Local law enforcement does, and they are not subject to the authority of the Attorney General. Your local sheriffs and local police departments are not under the chain of command of the Attorney General. And so this would be very unusual, and the Attorney General couldn't bind all of those agencies unless the Attorney General bound all of those agencies to some type of MOU. So I guess we could get the 99 cities, towns, and counties to agree with the Attorney General to sign on to an MOU with the DOJ, but most of these law enforcement agencies already work with the federal partners, depending on the type of legislation that gets passed out of this body. But they already do that oftentimes. And so just wondering why the Attorney General, what we're trying to accomplish there, because really it should be your local county attorney perhaps entering into these contracts with the feds in order to do federal law enforcement work such as detaining illegal immigrants. So questions about the Attorney General's role in this process?
Thank you, Senator Nethercott. Senator Kolb.
Yeah, thank you, Mr. Chairman. Just a question about the driver's license and the ID section of this proposed bill. I believe that the majority of that's been covered by other legislation that we've moved. And I'd just like to know if, I guess, if it's still necessary, or what is different about this than the other. I guess we haven't had that legislation signed into law yet, and maybe that's the reason why it's here. Just a general question about the need. Thank you, Mr. Chairman.
Thank you, Senator Kolb. Further questions? See Senator Schuler and then Senator Biden.
Thank you, Mr. Chairman. I had a constituent reach out to me on this about an issue where driving a family member who was here waiting, they're on a visa, but their visa has run out, and it seems to me as though, and she was very concerned about being a felon, it seems like over here on the application for a driver's license, it does take into account that they've got a pending or approval application, but her concern is, it's taking so long to get some of these things through that she's concerned about, her status. So if you can answer that question, that'd be helpful.
Thank you, Senator Schuler. Senator Biden.
Thank you, Mr. Chairman. I guess, I should have stood up there in the last bill as well, but my concerns here at 7 o'clock, 8 o'clock at night, is the kind of quality we're putting out. At what point do we pull the plug on some of these bills that aren't quite ready for prime time? I know we try our best to accommodate our fellow senators who we care about and we respect, and the issues, we're there on the issues, but trying to drag bills across the finish line that are so heavily amended and so in need of a lot of work, I don't think does this chamber justice. And I don't think we're living up to our reputation as doing the quality work. I have serious concerns about how the previous bill was drafted and this bill. I'm not saying we can't, as a team, pull together and fix them and possibly get them ready for third reading, but I'm struggling, Mr. Chairman. It's not that I don't disagree with the subject matter of either bill, but we've got to do better. Thank you.
Thank you, Senator Bateman. Senator Landon.
Mr. Chairman, that's one of the more important things that's been said in this session. I honestly think we should listen to the president. It's been a pretty difficult last hour because I agree with the president. We are not playing up the potential right now.
Thank you, Senator Landon. Any further discussion on Senate File 124? Senator Scott.
Mr. Chairman, a personal request. If members could be careful to speak reasonably into the microphone, I'm having trouble, even with my hearing aids in, hearing some of the things that are said, and some of them are very important.
Thank you, Senator Scott. Senator Guru.
Thank you, Mr. Chairman. I too rise. I think the remarks of the president were well taken. And what gives me pause is that even as the bill was being described, the good bringer of the bill, with the best of intentions, I know, brings the bill and talks about possible amendments and even weaves possible amendments into the description of the bill that's being brought. I think that is kind of proof positive that maybe we've got something here that's not quite ready for prime time. But I know where it comes. Fear. Fear's real. But you know, this is so important to so many people. Either side of the issue, it doesn't matter. And we have to get this right. We can't make a mistake here. This is something where we need to be doing our best work. And with all due respect, I think right now we are far from it. Far, far from it. On and against this bill.
Thank you, Senator. We do have another Committee of the Whole amendment. I hope that's what Senator Olson's rising for. Senator Olson.
Thank you, Mr. Chairman. I'm actually going to withdraw this Committee of the Whole amendment. It was an attempt to delete 3 more pages and continue the effort of trying to improve this bill as our Judiciary Committee has done, but I think I agree with the previous speakers that at this point in time, I just don't think this bill is ready for prime time, so I'll withdraw Committee of the Whole.
Senator, one moment, we have to read it in before withdrawing.
Senate File 124, Committee of the Whole Amendment Number 1, page 15, line 4, delete.
Senator Olson.
Okay, I'll withdraw Committee of the Whole Amendment Number 1 to Senate File 124.
Without objection, Committee of the Whole Amendment Number 1 to Senate File 124 has been withdrawn. Senator Dockstader.
Thank you, Mr. Chairman. There's probably wisdom in pulling back. There's also wisdom in just simply checking with your local law enforcement authorities, which I did. And a summary statement would be, this one's probably not broken, let's not try to fix it. We're doing just fine with the working relationships we have. So if we were to move the bill forward, I'd probably not be with it because I've counseled with my local law enforcement authorities.
Thank you, Senator Dockstader. Further discussion on Senate File 124? Further discussion? Seeing none, all those in favor of Senator Olson's motion that when the Committee of the Whole rises to report, it do so with a favorable recommendation on Senate File 124, please say aye. Those opposed, no. Standing division, all those in favor, please rise. Nine ayes. Those opposed, please rise. More than 9. All right, pursuant to Senate Rule 6.5, having failed a standing division vote, a roll call vote is required. Will the Chief Clerk please call the roll?
Committee of the Whole, roll call vote, Senate File 124. Anderson? No. Barlow? No. Boner? No. Brennan? No. Case? No. Cooper? No. Craigo? No. Crum? No. Dockstetter? No. Driscoll? No. French? Aye. Guru? No. Hicks? Aye. Hutchings? Aye. Ide? Aye. Jones? No. Cole? Aye. Landon? No. Larson? Aye. McEwen? Aye. Nethercott? No. Olson? No. Pappas excused. Pearson? Aye. Rothfuss?
No.
No. Salazar? No. Schuler? No. Scott? No. Smith? Aye. Steinmetz? Aye. President Beitman? No. Closing vote. Closing. Vote closed. Senate File 124, 10 aye, 20 no, 1 excused.
Pursuant to Senate Rule 6-5A, having failed a roll call vote, Senate File 124 has been indefinitely postponed. Madam Majority Leader.
Mr. Chairman, I move that the Committee of the Whole rise and report.
You have heard the motion. All in favor say aye. Aye. Those opposed, no. Motion carried. Mr. President.
Committee of the Whole report.
Mr. President, your Committee of the Whole, having had under considerations bills on general file, begs leave to report as follows. Senate File 187, do pass. Senate File 166, do pass. Senate File 156, do pass amended. Senate File 190, do pass amended. Senate File 178, do pass amended. Senate File 181, do pass amended. Senate File 189, do pass. Senate File 195, do pass amended. Senate File 197, do pass amended. Senate Joint Resolution Tail 10 failed to pass Committee of the Whole and is indefinitely postponed. Senate File 174, do pass. Senate File 61, do pass amended. Senate File 123 failed to pass Committee of the Whole and was indefinitely postponed. Senate File 125, do pass amended. Senate File 124 failed to pass Committee of the Whole and was indefinitely postponed. Senator Rothfuss, Chairman.
Senator Rothfuss.
Mr. President, I move for the adoption of the Committee of the Whole report.
You've heard the motion. All those in favor say aye.
Aye.
All those opposed, no. Committee of the Whole report has been adopted. Thank you, Senator Rothfuss. Senator Hicks.
Mr. President, could I have privilege of the floor?
The floor is yours.
Mr. President, we were discussing a bill a little while ago, and I had represented that I had been a co-sponsor on that. I want to correct a record. I was not. Senator Case had indicated that he was a co-sponsor on that one, and he was a co-sponsor on that. And I just wanted to correct that record, that I made a mistake. So, thank you, Mr. President.
Thank you, Senator Hicks. We all make mistakes. Appreciate you clearing the record. Okay. And do we have any reports, Helen? We ready to go home? All right, Madam Majority Floor Leader, that clears the desk.
Mr. President, I move that we stand adjourned until 10 a.m. Tuesday, February 11th, 2025.
Okay, any announcements? Senator Landon?
Mr. President, your Travel, Recreation, and Wildlife Committee will meet tomorrow morning at 8. We'll take up House Bill 45, removing otters as protected animals. We'll be down in room 4. That's the Wind River room. We ought to get to work in the morning.
There ought to be a law about that. All right, Senator Olson.
Mr. President, your Committee Number 1 Judiciary will meet tomorrow upon the noon recess in W002 to consider 2 House bills, House Bill 54, Chancery Court Judges District and Circuit Court Assistants, and House Bill 189, Harmful Communications Minors.
Thank you. Senator Cooper.
Thank you, Mr. President. Your Committee Number 8, Transportation Military Affairs, will meet in Public Meeting Room Number 2 at 8 a.m. tomorrow to consider the following bills. House Bill 33, Vehicle Sales and Use Tax Distribution, Highway Fund. House Bill 23, Surrender Driver's License Repeal. House Bill 25, Vehicle Accident Reporting Amendments. And time permitting, House Bill 27, Disabled Parking Windshield Placards Revisions.
Thank you, Senator Cooper. Thanks for stepping in for Senator Pappas. Senator French.
Did you call on me?
I did, Senator French. Go ahead.
I'm sorry, Larson and I are rattled. Your committee number 5, Senate Ag, State and Public Lands and Water Resources will meet tomorrow morning at 8 a.m. in Capitol Extension Room 6, W006, and online to consider the following 3 bills. House Journal 2, Foreign Adversaries Prohibited Property Ownership. House Bill 93, Protect Wyoming's Lands Act. House Bill 61, State Lands Lease Preference Amendments, if time permits on that one.
Thank you. Let's go to Senator Anderson.
Mr. President, your favorite committee, Minerals, number 9, will meet Wednesday, February 12th upon noon recess in Capitol Extension Room W4. We'll hear 3 bills. House Bill 14, Solid Waste Municipal Cease and Transfer Funding, the perpetual bill that's just so much fun. House Bill 22, Water and Wastewater Operator Emergency Response, and House Bill 41, Engrossed Environmental Quality Irrevocable Letters of Credit. Thank you.
Thank you, Senator Anderson. Senator Vice President Salazar.
Thank you, Mr. President. Senate Appropriations will meet tomorrow at 8 a.m. in room 113. The committee will meet to develop the Standing Committee Report on NHB 001, General Government Appropriations 2.
Thank you, Mr. Vice President. Any other announcements? You've all heard the Majority Leader's motion. All those in favor say aye. Aye. Those opposed, no. The Senate will stand at recess till 10 a.m. Or adjourned, sorry. Adjourned till 10 a.m.